Fresh matter 2024 for admission.
May I, my lords, request a matter for 2:30? My lords, I enjoy a decree in the year 91. After 30 years, my lords, they would invoke the PTCL Act, suppressing the decree. And my lords, as I submit now, the revenue authorities are there surveying the land, my lords, pursuant to...
Tomorrow. Yes, tomorrow.
Well, it's one 2018 matter. The similar matters have been decided by this honorable court, my lords. After notice, it hasn't come before your lordships.
What is that matter?
Pertaining to SC/ST, my lords. Grantee has the DC has passed an order against me, and there is a stay operating, my lords. It may be heard.
Next week, yes.
My lords, for admission, my lords were pleased to order notice. The civil court is proceeding further with the matter, my lords. Kindly tomorrow, my lords.
Yes.
Obliged.
Page wise adjournment. List number 1, page number 1, serial number 1 to 6. Page number 2, serial number 7 to 12.
Serial number 9.
Yes.
The MC is already posted for judgment. Last time I made a submission, your lordship directed call after 2 weeks.
Hmm.
That's 24th is order.
ಇನ್ನೇನ್ ಮತ್ತೆ ಅಲ್ಲಿಗೆ if it is posted for final
ಹೌದು IA ಹಾಕಿದ್ರು, IA ಮೇಲೂ ಮತ್ತೆ ಫೈನಲ್ ಎರಡು ಇದೆ.
then what is the question of transfer?
ಅಲ್ಲ ತಾವು ಅದ್ರ ರಿಸಲ್ಟ್ ನೋಡ್ಕೊಂಡು ಮಾಡುವ ಅಂತ ಅಂದ್ರಿ.
See, either if it is dismissed or allowed, question of transferring would not arise as now.
It doesn't matter.
Then we'll see what is that other side says. Password. When the matter is raised, we'll dispose of that. In view of that matter is resolved, it will not survive for consideration now. Yes.
Page number 3, serial number 13 to 16. Page number 4, serial number 17 to 20. Page number 5, serial number 21 to 24. Page number 6, serial number 25 to 28. Page number 7.
26, my lord, serial number 26
26, yes.
for P. Shivakumar. 26 and 27, my lord.
Office is directed
Supreet
to
VP.
the name of Shivakumar P. Show the name of so and so. Week's time is granted to do the needful.
Page number
Much
7.
obliged, my lord. 26 and 27, my lord.
26 and 27 same.
Page number 7, serial number 29 to
Much
32.
obliged, your lord.
Page number 8, serial number 33 to 39. Page number 9, serial number 40 to 41. Page number 10, serial number 45 to 47.
46 ಮೇಲೆ ರೆಕಾರ್ಡ್ಸ್ ಬಂದಿದ್ರೆ ಮಾಡ್ತೀವಿ. ನೆಗ್ಲಿಜೆನ್ಸ್ ಇದೆ.
Yes, records ಬಂದಿದ್ಯಾ? ಇಲ್ಲ, records ಬಂದಿಲ್ಲ.
2022 ನಲ್ಲೇ ರೆಕಾರ್ಡ್ಸ್ ಕಾಲ್ಫರ್ ಆಗಿದೆ.
Yes, post this matter at the request of the parties. Leave this matter after 2 weeks. Yes.
ಅಲ್ಲ ಕಾಲ್ಫರ್ ರೆಕಾರ್ಡ್ಸ್ ಅಂತ ಹೇಳಿ ಇನ್ನೊಂದ್ಸರಿ ಹೇಳಿ.
ಆರ್ಡರ್ ಆದ್ಮೇಲೆ ಇನ್ನೊಂದ್ಸರಿ ಏನಿಲ್ಲ. We are waiting for records ಅಷ್ಟೇ. Yes.
Page number 11.
ಡಿಲೇ ಕಂಟ್ರೋಲ್ ಮಾಡ್ಬಿಟ್ರಿ ಸುಮ್ಮನೆ.
Then you wait for that, mister, when the matter is called.
I'm sorry.
Yes.
Page number 11, serial number 48 to 51.
My lord, serial number 51, appearing for respondent.
46 urgent. Yes.
Serial number 51, appearing for respondent, my lord.
50.
51,
51. Yes.
appearing for respondent, grant 1 week time. my lord.
It's IAP for petitioners. IAP for petitioners, your lordships have heard us in part. They have some inconvenience any earliest date, no, Tuesday or Wednesday.
Wednesday, next week. We'll have it on 26th or 27th.
26th,
Leave this matter next week. Yes.
interim order to be extended.
Interim order granted earlier is extended till next date.
Great, much obliged.
Page number 12, serial number 52. Page number 13, serial number 53 and 54.
Serial number 54, my lord.
54, yes.
My lord, senior is out of station, my lord. Kindly have it on next week.
Appearing for whom?
Petitioner, appellant, sorry.
At the request of counsel for the appellant, leave this matter next week.
Page number 14, serial number 55 to 58.
57, 58. Cross appeal is filed by Nagaraj Hegde. Copy is not furnished to me, my lord.
No, which is,
I have not filed 58.
58.
yes. Wait, when the matter is called, we'll ask them to give it. Yes.
Page,
Allah, it may be directed to give me a copy, I'll file the wakalat.
No, you ask your colleague to be there. We'll ask him to give it to that. Again, he will not serve. Again, matter is posted.
Oh, yes,
For
yes,
that
but
purpose, we need not attend. Yes.
page number 15, serial number 59 and 60. List number 1 for preliminary hearing, serial number 1, PM Siddamalappa for petitioner.
Yes, paper petitioner.
Hmm.
The
What is this dispensation, Mr.?
I have not produced the copy, certified copy.
What is that annexure E?
The annexure E, please lordship, this order of the assistant commissioner
Hmm.
passed in CST 75/20, 2010 and 11.
Is
In
that
that
order
order
you
you
are
are-
challenging?
Yes, I am challenging that order.
Where is
Sir.
that certified copies of that order?
The certified copies I have applied, please lordship, due to urgency, they are trying to
Yes.
interfere my position.
IA 1 of 2024 is filed for production of certified dispensation for production of certified copies of annexure E.
Is-
The production of certified copies of annexure E for the present, for the period of 4 weeks, it is dispensed. Yes.
The grant made in year 1962, please lordship.
You are a grantee or a
I am
purchaser?
the purchaser, lordship.
What is the date of the grant?
22/10/1962.
1962.
It is for upset price. They have
Yes.
referred that in the upset. I have purchased the property on 14/5/1973, please, Your Honor. After
17
lapse, 10 years is the
first sale.
first sale. I am the first person.
Yes, 73 purchase.
Please, Your Honor.
What is the condition in 1962?
Only 10 years non-alienation, please, Your Honor.
Adi put chart.
So it's a permanent non-alienation. 20 years is it?
20 years.
62. 15 years.
18. What is the date?
1973, please, Your Honor. I am purchased the
No,
property.
no, no. Date of grant.
22/10/1962.
22/10.
1962.
53, 15 years.
20 years. 1932.
ಗ್ರಾಂಟ್ ಸರ್ಟಿಫಿಕೇಟ್ ಅಲ್ಲಿ 10 ವರ್ಷ ಹೇಳಿದ್ದಾರೆ ಸರ್.
ಅದು ಇಲ್ಲ. Rule says 20 years. Yes. What is that order of that AC?
They have approached in 2010, please, Your Honor. After
2000
lapse of 40 years.
2010.
10.
Yes. What is that?
The assistant commissioner, they have not called for the record and grant and other things. They have not verified blindly except the version of the respondent, Your Honor. They have restored the property to the
Then
Anjamariyappa.
DC
And
is also held
that
same.
same thing, the
He
DC
has
has not.
confirmed that. Since there is a violation, only thing is that there is a delay.
Please, no.
Yes, that issue is pending. We'll see.
I have thought for stay, please, now taking the advantage, Your Lordship. They are interfering my position.
Issue notice. Government advocate is directed to take notice for 1 to 4. Counsel for the petitioner is directed to serve 4 set of copies on government advocate. Stay of annexure.
Annexure E and annexure
Annexure E and G till next date of hearing.
grateful.
Serial number 2, Dharmapal for petitioner.
Yes.
My lord, petitioners, they belong to the community of SC/ST. Land measuring 3 acre was granted in the year of 67-68 in favor of his father. After death of his father, the Kata was transferred into the elder brothers of the petitioner and the Kata entered. And during the year of 89, my lord, without consent of his brothers and the permission of the government, he has sold the property in favor of the respondent number 527. The petitioner approached Assistant Commissioner of Commissioner and Honnali. He has passed the order. He has called for the report from the Tahsildar. Tahsildar, it is in the ink page number 23. Tahsildar has given a report. 67-68ರಂತೆ ವೆಂಕಪ್ಪ ಬಿನ್ ಸಣ್ಣಪ್ಪ ಎಂಬುವರಿಗೆ ದರ್ಖಾಸ್ತು ಮಂಜೂರಾಗಿದ್ದು ಇವರು ಬೋವಿ ಪರಿಷತ್ ಜಾತಿಗೆ ಸೇರಿದವರಾಗಿದ್ದು ಇವರು ಪೌತಿ ನಂತರ ಮೊದಲನೇ ಮಗನಾದ ದೊಡ್ಡವೀರ್ restored.
Then what is that order of the DC?
And RTC entered in favor of the petitioner.
Why it is
And
reversed by the DC?
DC, he says just they have not submitted the original grant certificate where it is shows whether it was granted freely or in page number 32, my lord.
Yes.
ಮೂರನೇ ಅರ್ಜಿಯರು ಸಹ ಹಾಜರುಪಡಿಸಿರುವುದಿಲ್ಲ. ಆದ್ರೆ ಮಂಜೂರಾದ ಬಗ್ಗೆ ಸಾಗುವಳಿ ಚೀಟಿ ಅಥವಾ ದರಖಾಸ್ತು ವಹಿ ಅಥವಾ ಇತರ ಯಾವುದೇ ಒಂದು ದಾಖಲೆ ಸಹ ಕೆಲ ನ್ಯಾಯಾಲಯದ ಕಡತದಲ್ಲಿ ಲಭ್ಯ ಇರುವುದಿಲ್ಲ. ಹಾಗೂ ಮೂರನೇ ಎದುರುದಾರರು ಸಹ ಹಾಜರುಪಡಿಸಿರುವುದಿಲ್ಲ. ಕೇವಲ 68-69ನೇ ಸಾಲಿನಲ್ಲಿ ಪಹಣಿ ಮಾತ್ರ ಸಲ್ಲಿಸಿರುತ್ತಾರೆ. ಇದರಿಂದಾಗಿ ಮಂಜೂರುದಾರರಿಗೆ ಉಚಿತವಾಗಿ ಮಂಜೂರಾಗಿತ್ತೋ ಅಥವಾ ಹರಾಜು ಆಫ್ಸೆಟ್ ಬೆಲೆ ಮೂಲಕ ಮಂಜೂರಾಗಿತ್ತು ಎಂಬ ಬಗ್ಗೆ ಮಂಜೂರಾತಿ ಷರತ್ತುಗಳ ಬಗ್ಗೆ ಯಾವುದೇ ಸ್ಪಷ್ಟತೆ ಇರುವುದಿಲ್ಲ. The Tahsildar, he has after verification, he has given the report that the land was granted in the by way of Darkhas.
Issue notice. Government advocate is directed to take notice for respondent number 1 to 4. Counsel for the petitioner is directed to serve 4 set of copies on government advocate. Emergent notice to 5 to 7. Stay of annexure G till next date of hearing.
Also record, my lord.
Bharat, record out.
Serial number 3, SV Prakash for petitioner.
My lord, I appear for petitioner.
Yes,
My lord, the purchaser is the petitioner, my lord.
yes.
Survey number 44/1, my lord, new number 21.
Hmm.
My lord, measuring 5 acres of Sagar Karenahalli village, my lord, in Sira Taluk, Tumkur district was granted in favor of father of the fifth, my lord, respondent. My lord, and grant certificate was issued on 25th January 1962.
Yes.
My lord, the original grantee, he sold, my lord, 2 acres 20 guntas out of 5 acres. To, my lord, the Venkamma, who is mother-in-law, that is the husband's mother.
Yes.
My lord, by way of a sale deed, my lord, in the year, my lord, to 22/11/1974.
Yes.
And remaining 2 acres 20 guntas, my lord, was sold to one Shivanna, my lord, by means of a sale deed dated 6/1/1975. My lord, these are all admitted facts.
Yes.
My lord, what happened? The father of the fifth respondent, during his lifetime, my lord, he made an application seeking, my lord, the annulment of the sale transaction on the ground it was, my lord, in violation of terms of the grant. My lord, Assistant Commissioner has, my lord, initiated proceedings, and my lord, he rejected it, my lord, on 31/8/1990.
On what ground he has rejected? Why is he
My lord,
rejected?
that's not available, my lord. It is, my lord, admitted fact, my lord, that it was rejected.
Yes.
No appeal was filed against that, my lord.
Hmm.
No appeal was filed against that. And, my lord, suppressing this, my lord, in 2014-15, my lord, the fifth respondent, son, he makes an application before, my lord, Deputy Commissioner. Next year, he is the order. My lord, page 21. My lord, this mother-in-law of the petitioner was no more than. Her legal heirs were not impleaded. Only Shivanna's wife and son were, my lord, impleaded. And Assistant Commissioner, my lord, Annexure A, page 21. My lord, he has held that, my lord, the sale transactions were, my lord, in violation of terms of the grant and directed, my lord, the resumption and restoration. Annexure, my lord, A is the order.
Yes.
This order, my lord, was challenged by me, by the petitioner after coming to know that such an order was passed. Well, before that, my lord, the Shivanna's wife and son, my lord, same order was challenged before Deputy Commissioner. Annexure C, page 27. Well, same order of the Assistant Commissioner was challenged. My lord, your lordship, kindly come to page 28, my lord.
Yes.
The Deputy Commissioner, my lord, in the said, lord, order. My lord, I will read, my lord, page 28, my lord, 4 line from the bottom, my lord. ದಿನಾಂಕ 22/4/74 ವೆಂಕಟಮ್ಮ ಅಥವಾ ಹನುಮಂತ ಬೋರ್ ಇವರಿಗೆ 220 ಗುಂಟೆ 6/1/75 ಶಿವಣ್ಣ ಬೋರಣ್ಣ ಇವರಿಗೆ ಮಾರಾಟ ಮಾಡಿರುತ್ತಾರೆ. ಹನುಮ ಬೋವಿಯವರು ಸರ್ಕಾರದಿಂದ ಯಾವುದೇ ಪೂರ್ವಾನುಮತಿ ಪಡೆಯದೆ ಜಮೀನು ಮಾರಾಟ ಮಾಡಿರುವುದು ಕಾನೂನು ಬಾಹಿರವಾಗಿರುತ್ತದೆ. ಹನುಮ ಬೋವಿಯವರು ಈ ಮೇಲ್ಕಂಡ ಮಾರಾಟ ಮಾಡುವ ವಿಚಾರ ತನ್ನ ಕುಟುಂಬದ ಮಾಹಿತಿ ಇರುವುದಿಲ್ಲ. ನಂತರ ಈ ವಿಚಾರ ತಿಳಿದು ಉಪವಿಭಾಗಾಧಿಕಾರಿ ನ್ಯಾಯಾಲಯದಲ್ಲಿ PTCL ಕಾಯ್ದೆಯಡಿ ಮೇಲ್ಮನವಿ 55 ದಾಖಲಿಸಿದ್ದು ಸದರಿ ನ್ಯಾಯಾಲಯವು ಸದರಿ ಮೇಲ್ಮನವಿ ಪುರಸ್ಕರಿಸುತ್ತದೆ. ಈ ಕ್ರಯವನ್ನು ಅಸಿಂಧು ಘೋಷಿಸಿ ಸರ್ಕಾರದ ಜಮೀನನ್ನು ಸರ್ಕಾರದ ಸುಪರ್ದಿಗೆ ಪಟ್ಟು ಮೂಲ ಮಂಜೂರು ಮಾಡಲು ಆದೇಶಿಸುತ್ತಾರೆ. ಅದರಂತೆ ಆಗಿರುತ್ತದೆ. ಮೇಲ್ಮನವಿದಾರರು ಯಾವತ್ತೂ ಸ್ವಾತಂತ್ರ್ಯದಲ್ಲಿದ್ದ ಉಪವಿಭಾಗ ಮಾಡಿರುವ ಆದೇಶ ಕಾನೂನು ಪ್ರಕಾರ ಅಸಿಂಧುವಾಗಿದ್ದು ಮೇಲ್ಮನವಿದಾರರು ಎದುರಾರು ತಂದೆ ಕಡೆಯಿಂದ ಕೊಂಡುಕೊಂಡಿರುವ ಜಮೀನು ಸರ್ಕಾರದಿಂದ ಪೂರ್ವಾನುಮತಿ ಕ್ರಯಪಟ್ಟುವುದರಿಂದ ಮೇಲ್ಮನವಿಯು ಅಸಿಂಧುವಾಗಿರುತ್ತದೆ. ನೆಕ್ಸ್ಟ್ ಮೇಲ್ಮನವಿದಾರ ಮುಖ್ಯವಾದವೇನೆಂದರೆ ವಿವಾದಿತ ಜಮೀನು ಬಗ್ಗೆ ಉಪವಿಭಾಗಾಧಿಕಾರಿಗಳು ನ್ಯಾಯಾಲಯದ ಮೊದಲು ನಂಬರ್ LND UGSC 4089 ಪ್ರಕರಣ ವಿಚಾರಣೆ ನಡೆದು ದಿನಾಂಕ 38/90 ಆದೇಶವಾಗಿದ್ದು ಈ ಆದೇಶವನ್ನು ಯಾರೂ ಪ್ರಶ್ನಿಸದೇ ಇರುವುದರಿಂದ ಇದು ಅಂತಿಮವಾಗಿ ಉಳಿದಿರುತ್ತದೆ. ಇದನ್ನು ಪರಿಶೀಲಿಸದೆ ಉಪವಿಭಾಗಾಧಿಕಾರಿಗಳು ಮತ್ತೊಮ್ಮೆ ಪ್ರಕರಣ ದಾಖಲಿಸಿಕೊಂಡು ವಿಚಾರಣೆ ನಡೆಸಿ 17/1/2018 ಮಾಡಿರುವ ಪ್ರಸ್ತುತ ಆದೇಶ ಕಾನೂನುಬದ್ಧವಲ್ಲ. ಸೆಕೆಂಡ್ ಅಪ್ಲಿಕೇಶನ್, ಡೆಪ್ಟಿ ಕಮಿಷನರ್ allowed the appeal and exercised, my lord, order of the Assistant Commissioner. When I prepared appeal, my lord, it should have been clubbed, but it was not clubbed. When my appeal, my lord, page 25, Annexure B, Deputy Commissioner confirms the order of the Assistant Commissioner, which is made on the second application.
Same officer.
Yeah, no, different officer. Different officer.
Yes.
My lord, my submission is division bench, my lord, and also this honorable court held that, my lord, the second application is not maintainable. Any order passed on second application, my lord, is void, illegal.
Yes.
One, and my lord, this second application was made after 29 years.
No, which is the judgment? Second application order is void.
My lord, that is, my lord, ILR 2006 Karnataka, page 174, division bench judgment,
Yes.
Page number, sir.
174.
ILR 2006 Karnataka 175.
174.
Yes. Heard. Issue notice. Attakali. Government advocate is directed to take notice for respondent number 1 to 4. Counsel for the petitioner is directed to serve 4 set of copies on government advocate. Issue emergent notice to respondent number 5. Stay of annexure B till next date of hearing.
My lord, caveator is there, my lord, for 5.
Yes.
He entered caveat, respond number 5.
That.
Asappa B.
Yes. Yes, let it be there. If you want to take
Yes.
notice, let him take. Yes, we'll send a
Yes.
notice to him. Yes.
Serial number 4, Avinash Gowda GS for petitioner.
For the petitioner in this case, my lords. My lords, the petitioner is the one Gangappa, who is the grandfather of the petitioner, was the grantee, my lords. By virtue of the grant was made on 5/11/1977, my lords.
Yes.
And with the condition of 15 years for non-alienation, and they were in possession and they were cultivation in that land, my lords.
Yes.
On 25/11/2014,
Yes.
without realizing they could sell the property, and since they were uneducated, they sold the property in favor of respondent number 3, my lords. My lords, the petitioner have filed were before assistant commissioner, my lords, were assistant commissioner.
What is that order of the assistant commissioner?
My lords, he set aside the CLD dated 25/11 and 25/11/2014, and also he ordered to put back the petitioner in possession of the land and imposed a condition that they should not alienate for 25 years, my lords. And the respondent number 3 filed an appeal before the special deputy commissioner, my lords, where the deputy commissioner, the respondent number 3 set aside the order passed by the assistant commissioner, my lords. And they took up the specific contention that the land in question was for an abstract price and of rupees 62.50 paise, and that would not be a grant under the PTCL Act, my lords. Aggrieved by that order, we have filed this
Yes, Mr.
writ petition,
Government.
my lords.
Is it a market price? 62 rupees.
No, 62 rupees it is the purchase, they are
Hmm.
telling.
He said it is in a market price, therefore condition is not applicable. Is it that? It is a reduced market price,
No,
it's an
it is
upset price.
purchased from the government.
Hmm.
What is the market rate? It is not mentioned.
No, if 62 is the market rate as on 1977.
No, we have to
In
verify.
Chikmalapur.
TC also is not set, it is
He
purchased.
said just because it is 62, it is in purchased.
It
it
is
is not a
purchased 62 rupees.
62 is
Market
it's a
value or
reduced
not?
market price. It is number of judgments said if it is reduced market rate, condition is applicable. Yes. Heard. Issue notice. Government advocate is directed to take notice for respondent number 1 and 2. Counsel for the petitioner is directed to serve 2 sets of copies on government advocate. Issue emergent notice to respondent number 3. Stay of further proceedings. Annexure A, na?
Yes, please, my
A
lords.
till next date of hearing.
Serial number 5, Umesha Murthy JM for petitioner.
Yes.
Fifth respondent, my lord, said to have LRs of original grantee, my lord, filed an application, my lord, before the assistant commissioner under PTCL Act, my lord, after lapse of 45 years, my lord, the assistant commissioner that is 1957
The
granted.
date of grant,
Date of grant is, my lord, for 23/5/1957.
57.
But
Date of purchase,
that's it, that here, my lord, we have not purchased at all. Our names are forthcoming from 1967-68. That has been questioned, that saying that remove that names in the, and that is the PTCL Act itself is not applicable in the.
no, if it is a granted land, if it is, your name is entered,
Please, my lord.
then there should be a reason. That is, you have to prove how you have come to that position.
That is the, my lord. In view of that, my lord, and in fact, my lord, after 45 years, my lord, that 2016, 15, 16, they filed a petition before the Assistant Commissioner, my lord.
No, Assistant Commissioner has dismissed.
Dismissed, my lord.
Why?
That is, they are, claimant is not the LR of original grantee.
Not LR.
Please, ma'am.
Where is the DC order?
DC order is, my lord, relevant, my lord, page 33, my lord. Mary.
10 ವರ್ಷಗಳ ಪರಭಾರೆ ಮಾಡುವಂತಿಲ್ಲ. ಜನಬಸವರಿಗೆ ಪಾಲು ವಿಭಾಗದ ಮೂಲಕ 10 ಬದಲಾವಣೆ ನಂತರ 1ನೇ ಎದುರುದಾರಿಗೆ ಹಸಿರು ಹಕ್ಕು ಬದಲಾವಣೆ ಅಕ್ರಮವಾಗಿತ್ತು ಹಾಗೂ ಕಾನೂನು ಬಾಹಿರವಾಗಿತ್ತು. ನಿಬಂಧನೆಗಳಿಗೆ 86, 87. Then when that application is filed?
The application, but the date of the application is not forthcoming, but the on the basis of the Assistant Commissioner number, my lord, that is 1516, that is.
Issue notice. Government advocate is directed to take notice for respondent number 1 to 3. 1 to 4. Counsel for the petitioner is directed to serve 1 set of copies, 3 sets of copies on government advocate.
Please.
Issue emergent notice to respondent number 5. Parties are directed to maintain. How much you have purchased? What is the extent?
Estimate entire, my lord, 6 acres, my lord, and
Parties
5
are
guntas.
directed to maintain status quo in respect of survey number 196, measuring 6 acres, situated at Anuboru village.
Naboru village.
Kasba Hobali, Jaglur Taluk, Davangere district.
Davangere, please.
Till next date of hearing.
Please.
Admission matter, serial number 6, Ajit A. Shetty petitioner, Bimbadar M. Gowda.
Last date of hearing, my learned friend had voiced his apprehension, my lords, that if the petition were to be transferred to Kundapura, the petitioner would file certain complaints against him. That was what he had concerned. And my lords had directed me to file an affidavit.
Yes.
But I filed an affidavit yesterday. I don't think it has been put up, my lords, but may I just pass this on?
Yes.
I served a copy on my learned friend.
I received a copy.
Yes, Mr.
It may be allowed, my lords, in view of this affidavit.
Yes. Now that this petition is filed by whom?
My lords, by the wife, my lords,
Wife.
seeking transfer of a petition, my lords, filed under section 9 by
Yes.
the husband, my lords, at Bangalore.
He is filed in the Bangalore.
Please,
Yes.
Fourth additional family.
You want to transfer to that Kundapur?
please.
Yes. Have you filed any case?
My lord, she had filed a divorce petition, my lord, which was rejected on merits. My lord, she has now instructed me to file an appeal. I have the papers, my lord, but it is yet to be filed.
Yes. Tagali.
And there is a criminal case also pending, my lord.
That is different. Yes. So and so learned counsel appearing for petitioner wife has contended that after the matrimonial dispute, she is residing with her parents.
Please,
With her
parents and a daughter.
Parents, what is the age of the daughter?
But she's 7 years old.
With the parents along with the 7 years old daughter in Kundapur. Respondent husband has filed an MC. What is the number?
781 of 2023.
Yes, MC 781 of 2023. Before
Fourth edition.
Principal Judge Family Court, Bangalore.
Fourth additional, my lord.
Fourth additional Family Court, Bangalore for restitution of conjugal right. From Bangalore to Udupi, it's about what?
But 460 kilometers.
460 kilometers. It is inconvenience for the petitioner to come to Bangalore along with her minor child to prosecute the case. Hence, he sought for transferring of allowing that CP. Learned counsel appearing for that respondent husband has contended that respondent has a life threat if he go to that Udupi from that petitioner and his family members. Therefore, it is difficult for him to go to the Udupi. Respect of apprehension of the respondent, the petitioner has filed an affidavit before this court stating that the petitioner or family members will not threaten the respondent whenever he is visited Udupi for prosecuting the case. In view of the above and the civil petition, in view of the above and that inconvenience made out by the petitioner, the civil petition is required to be allowed. Accordingly, CP is allowed. MC number 781 of 2023, pending in the file of 4th additional Principal Judge Family Court, Bangalore, is withdrawn. Same is transferred to Principal Jurisdiction Principal Judge Family Court, Udupi.
Kundapur.
Udupi anta hakidira?
I'm sorry.
To the Jurisdictional Principal Judge Court, Udupi.
Very well.
Yes, Udupi. Yes.
I'm grateful.
Serial number 7, Hemant Kumar GM for petitioner. Rettihalli Geeta.
The respondent. And for the petitioner, Swami.
Yes.
Lordship, this petitioner has made two grounds in their petition, Your Lordship. That is page number 3, paragraph number 4, Your Lordship. The petitioner is working as a Seva Niranetru, Sri Dharmasthala Manjunatha Sangha. The petitioner is not in a position to come to Bangalore. Here, Your Lordship, the respondent is ready to bear the expenses, whatever she is traveling expense as well as the lodging expenses.
I'm for the petitioner.
You are for the petitioner.
I am for the respondent, Your Lordship.
From this side, you are started arguing. I thought that you are petitioner, you are submitting. Yes.
For the petitioner, Swami.
Yes.
This is the transfer petition. The transfer MC number 1000/24 filed by the respondent against the petitioner, which is pending in the court of the 4th additional Principal Judge Family Court, Bangalore.
No, you are residing in Chikmagalur.
Chikmagalur, Tarikere.
Husband is in Bangalore.
Husband is in Bangalore.
Bangalore. You are residing with whom?
With parents, aged parents.
Due to that marriage, due to wedlock, any?
No, my lord, no child.
No child.
No.
Then
She is unable to travel from Tarikere to here because in Guddahalli,
what is the distance between Tarikere?
280 to 300 distance is there, kilometers distance is there.
Has she filed any case?
In Tarikere, she filed a DV Act.
Where is that?
In additional civil judge at JMFC.
What is the case number, madam? You are not copy.
Criminal miscellaneous petition number 449 of 16.
Miss.
Criminal miscellaneous petition number 449 of 16. 449.
449 of
16. 16.
2016.
Yes.
Till it's pending.
Still it is pending.
Why?
Because he's not.
From 2016 it is pending.
Yes, my lord.
He is appearing in that case,
No, he's properly not appearing in.
but he has engaged the council and all.
Yes, ma'am.
It is filed before which court?
In additional civil judge at JMFC.
Yes. Additional civil judge JMFC?
Terikere.
Tarikere. Yes. Yes, madam.
Lordship, according to their petition, they have made two claims, Your Lordship. That is one, she is not working, but she is working. They themselves admitted they are working.
Where
They have
working?
that is this one, Seva Nirantaro, Sri Dharmasthala Manjunatha Sangha. The petitioner is not in a position to come to Bangalore. That is one contention.
No. She is working where? In the Dharmasthala or in Tarikere or Chikmagalur?
It is a trust, it is, Your Lordship. They have to go village and educate the women in the.
Now that she is residing in Tarikere.
She is residing in Gadihalli, Your Lordship. From
Yes.
there, she is traveling around all the villages and all.
Yes,
Your
yes.
Lordship. And in the fifth paragraph, Your Lordship, the petitioner has no independent means of livelihood. In the previous paragraph, they admitted she is working, so she will get some lump sum amount and all. And coming to the paragraph number 6, Your Lordship, that is the line number 5, Your Lordship. The petitioner also apprehends danger to her life if she is forced to travel Bangalore, but she has not made any ground what threat she is having.
You leave all these things.
Yes.
Now, anyhow, one case is pending in that Tarikere, you have to go for a criminal case.
Lordship, one small, I wanted
But
to
you are
convince the
dragging
Honorable
from
Court.
2016.
Yes, Your Lordship, because she is not attending, because that is the cross of this petitioner, Your Lordship. She is normally not appearing. From here to there, he has
That
to
is
go.
for the court to take care of that. I
Your
did
Lordship,
not go to all these
no,
things.
Your Lordship.
No, yes, you tell me that what is your objection for transfer?
Your Lordship, he is suffering from varicose veins. He has to undergo all the time laser therapy, Your Lordship. For that reason, the police department has given him as a telephone attendant work for him, Your Lordship. And also he is having a, because
He
she
is a
herself.
police constable.
Yes, Your Lordship. And there is a life threat she is telling, but apart from that, she herself has placed a number of complaints against him, and also she published one article against him as a, that is, I'm insisted in my objection, Your Lordship, that is in the paper, Your Lordship, Hennu Baka Mukhya Pede. By hearing this one only, he lost his mother, Your Lordship.
Varicose vein is, he is suffering from that.
No, Your Lordship, that is, he's having a tension, pressure and all the things. Now he is he is a patient like Your Lordship.
No, he is a police constable. Don't tell like this.
No, Your
Tomorrow
Lordship.
it will be that ground for him to remove from the service, madam.
No, Your Lordship. Yes, not, yeah, actually for that reason only they had given him a phone operator, Your Lordship, because if he cannot travel a long distances, Your Lordship. For that reason, that is.
Why he can't travel long distance?
That because that his legs are becoming heavy for him, because of the varicose veins.
That's what I am.
Because even I have produced some.
They are suffering from varicose veins.
Yes, Your Lordship. I produced some medicals also, Your Lordship. He's all the time, twice in a month, he has to undergo for the, that is, I don't know, they have to cut the nerves and make a straighten and all they are telling. And also I studied, Your Lordship, and recently our Apex Court also noticed, Your Lordship, clearly noticed, Your Lordship. I furnished some citations also, Your Lordship. That is, 1 second, Your Lordship.
Yes, madam. Have you filed an objection to this? Have you filed an rejoinder to that objection?
No, my lord, in this objection.
He has produced so many medical records. What is this photographs and all, madam?
He is undergoing for the laser therapy for that varicose.
Yes, you file an objection to that, madam. Is it
Okay,
true
fine.
or not? He is suffering from serious this thing.
Just I will file in next year. In
Yes, because you can travel for
But my
your
lord,
threat
she's
and
not
all.
working. What madam told at para 4, we are submitted that saying.
You file an objection. What he has filed that any reason? Yes. But the request of counsel for petitioner.
That is Apex Court also noticed in very crucial, that is Anandita Das versus Srijit Das, and also Honorable Justice, the two sir also observed, why should give the lenience to the ladies only? Why don't they can transfer? observe that, your lord, safety and economic implication with travel.
Yes, yes,
And these all the things are there, your lordship.
yes,
Because of his health,
yes, yes. At the request of counsel for the petitioner, read this matter after 2 weeks. Yes.
Serial number 8, Shauri HR for petitioner, Sandesh P. Nadigar.
Yes, madam.
date, your lord. Any date, please.
2 weeks, 2 weeks it will come. Yes.
It's a petition by wife, my lord, seeking transfer of my lord's MC number 5009 of 2023. Filed
Yes.
In serial number 7, interim order can be.
Interim order granted earlier is extended till next term. Yes.
Petitioner is a wife, my lords. They sought the MC petition filed for restitution of conjugal rights to be transferred from family court at Bangalore to Dharwad, my lords. The small kid.
Yes.
and she is living in Dharwad with her parents.
Yes.
aged
What is the
parents.
age of the kid?
It is
child?
around 3 years old, my lords.
Daughter or
A son.
son? What is the distance from Dharwad to Bangalore?
Dharwad to Bangalore is around 300 plus kilometers.
Yes. Has she filed any case in the Dharwad?
No, she has not filed any case, my lord. The only
Yes.
case,
Husband has filed MC for dissolution of marriage or
conjugal rights.
restitution of conjugal right? Yes, madam.
We have no objection for counsel.
Yes. Learned counsel appearing for the petitioner wife has contended that after the matrimonial dispute, petitioner is residing with her parents along with her 3 years old son in Dharwad. The respondent has filed an MC number 5048 of 2023 for restitution of conjugal right before the family court Bangalore. From Bangalore to Dharwad, it's about 300 kilometers. It is inconvenience for the petitioner to come with her 3 years old son to Bangalore to prosecute the case sought for allowing that CP. Learned counsel for respondent has no objection to allow the CP. Heard the learned counsel for the parties. Peruse civil petition paper. It is not in dispute. Petitioner is the legally wedded wife of respondent. Their marriage was solemnized on 29/5/2019. Due to wedlock, male child was born. Now he is aged about 3 years. After the matrimonial dispute, petitioner is residing with her parents in Dharwad. Respondent has filed MC number 5009 of 2023 before family court Bangalore. From Bangalore to Dharwad, it's about 300 kilometers.
400, sorry, stand corrected.
430, yes. From Bangalore to Dharwad, it's about 430 kilometers. It is inconvenience for the petitioner to come to Bangalore along with her minor son. Considering that inconvenience made out by the petitioner and judgment of this court, the civil appeal required to be allowed. Accordingly, CP is allowed. MC number 5009 of 2023, pending in the file of Principal Judge Family Court Bangalore is withdrawn. Same is transferred to Principal Judge Family Court Dharwad. Yes.
Serial number 8, Shankarappa S per petitioner, Jagadish Padigal.
Yes, madam, the matter is reserved for judgment. Why do you want to transfer?
Your Lordship, you have filed for recall of the stage for filing written statement, Your Lordship. It is,
Upon that,
Your Lordship, it's posted for orders on 25th of September, Your Lordship.
recalling it's posted. 24th. Yes, leave this matter on 25th. Yes.
Your Lordship, it is posted for orders on 25th, Your Lordship.
25th, yes, we'll have it on 28th. Let us read this matter. 30th. Yes.
Serial number 10, Vijay Shetty B for a petitioner.
I appeal for the respondent.
Yes.
In this matter. My lord, the first petition, my lord, that is GNWC petition filed by the respondent, my lord. The jurisdiction for filing the GNWC section 9, my lord, of the
No, the first is that
288.
MC petition, divorce petition is the first petition, my lord.
288 first petition, my lord.
GNWC.
GNWC.
23 of 24, filed by that husband.
Husband.
Yes,
My lord, the filed by the husband in Mysuru, my lord.
Mysore.
Mysuru.
Yes.
My lord, filing itself, it should have been in Hubballi for the reason that, my lord, as per section 9, my lord, I'll read section 9 of the Guardians and Wards Act, my lord.
Yes, where the child is residing.
Child is there, my lord, in Hubballi.
Yes.
My lord, at the time of filing itself, the child, it is filed on 27th, my lord, 27th May, it has been filed, GNWC. But
Yes.
as on that day, my lord, child was in Hubballi.
Yes.
So the jurisdiction lies there.
Yes.
That is one, my lord. The regarding the second petition, my lord,
Yes.
that is the second petition filed by the child for maintenance, my lord.
Second petition is filed by
Filed by the child.
you.
Filed by me, yes. Mother.
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 What is that?
That is being the guardian, my lord. 204.
204. Second is for
That
maintenance.
is for maintenance.
Yes.
My lord, the third petition, that is MC petition filed by the wife, my lord,
For what?
for the divorce, my lord.
Divorce.
My lord, kindly see annexure H, my lord, in this.
In
In the first petition, 288, my lord.
204 ಕೊಟ್ಟಿದ್ದೀರಲ್ರಿ 204 is that child petition.
Child petition. ಹೌದು.
ಮತ್ತೆ 288 why, which is that you, now you come to that second matter, mister.
ಅಲ್ಲ 288 ಫಸ್ಟ್ ಮ್ಯಾಟ್ರ್ ಇತ್ತು ಅನ್ಸುತ್ತೆ ಸುಮ್ಮನೆ.
You see in the serial number.
Yes, please.
First 288 you have argued.
Yes, please.
You said that child is the
Child is
jurisdiction of
residing
the
there.
place
Yes,
for
please.
it.
Yes, please, madam. 204, my lord. In 204, my lord, this is filed for the maintenance, my lord. My lord, the mother, my lord, mother is now residing at Hubballi. She has got job there. Your lordship may kindly see annexure. Yes.
ಅದು ಕೊಡಿ. When you have filed?
My lord, it is filed in Mysore, my lord.
No, it is filed in Mysore.
Yes, please.
When you have filed that?
My lord, that is filed on 26/11/2022, my lord. 26/11/2022.
26/11/2022. 11/22.
Yes.
Yes.
My lord, the annexure K, your lordship may kindly see annexure K at page numbers 116, my lord. As per the interim order passed by the Honorable Court, my lord, the 15,000 interim maintenance order has been passed. Out of that, the 7,500 has to be paid by the husband, and the other 7,500 has to be paid by the wife, my lord. My lord, the wife got the job at Hubballi at annexure K, my lord. That is on 5/4/2024. Appointment letter has been issued. We refer to your recent interview dated 20th March 2024. We are pleased to inform you that you have been appointed as computer lecturer lab assistant at Dr. D.G. Shetty Education Society's T.M. Shetty's Memorial Independent PU College with the following terms and conditions. Salary, consolidated salary of rupees 18,000 per month. Working hours will be from Monday to Saturday, 8 a.m. to 2 p.m. Reporting date 10th April 2024 at 10 a.m. Documents required attested so and so on. She is there since April 2024. And my lord, next the child has been admitted there. Next document you also may kindly see at annexure L, my lord. That is dated 25/4, ಅದು 24/5 ಅಂತ ಆಗಿದೆ translation copy also. Actually 25/4. My lord, that is, I understand the principal M.R. Sakare English Medium School, Hubballi, hereby informed that Master Mrs. Ria Sandeep has taken admission for standard 4 in our institution for the academic year 2024-25. Then next document, that is, the school has given the letter to requesting to give the transfer certificate and records pertaining to this. Since April, she is staying there and child is also staying there. Now the stage of this case, this child's case, that is for the cross-examination of PW1. In mother's case, that is cross-examination PW1 was over. And the GNWC case, in that case, it is just notice has been issued, and presently it is gone for ADR.
Yes. Yes, madam.
I do not know. This is the third time, my lord, they are misleading this honorable court. My lord, I was shocked when my learned friend says that he is there in Hubli and he has produced some document stating that she is appointed. My lord, I have secured the record from the Hubli, that particular institution. If she was really working there, my lord, it must find a place in the PF records and other records. And I have secured records, my lord, by stating none of the institutions is there. Her parents were they are residing in Mysore.
No, that you are saying that she is not working there.
Yes, my lord, I will secure the records. I will file the affidavit with the details, my lord. She is taking
you file it.
for a right, my lord.
No, you place it before the court, then only you can say, madam.
I will do it, my lord. I will secure all the records, my lord. I will secure and I placed it before this court, my lord.
You place it, yes, you place it. Its main case is on that.
That time will come, my lord. So far, the MC case is concerned, where she has sought for transfer, my lord. Evidence of the wife is over. It is at the stage of cross-examination of the husband.
You place it. No, you place first her entire case is on the basis that she has appointed there. If you place that she is not appointed there, then it is a false.
Well, I secured all the records, my lord. Yes. I'll place all the materials, my lord. Your lordship may take it next week, my lord. I'll place it.
Yes, at the request of respondent. Yes, leave this matter of 2 weeks. Yes.
Date may be given, madam.
Yes. When will you file it, madam?
Well, next week I'll file it, madam.
Next week.
I have secured all the records.
30th. Yes.
August. Interim order.
Interim order granted earlier is extended till next date.
Serial number 11, Suresh Kumar HM for petitioner.
We are for petitioner.
Yes.
Lordship, we have filed the transfer petition.
Yes.
Respondent have filed MC number 3978 of 24.
Oh, who are you?
I am for petitioner.
Petitioner is the wife.
That's my wife, my lord.
Yes. MC filed by whom?
Respondent, dissolution of marriage.
Husband.
Husband.
For what? MC for what, Mr. Divorce or dissolution or restitution of conjugal?
Dissolution.
Dissolution of marriage. Yes, it is filed in Bangalore.
Bangalore.
You are residing in Chikmagalur.
Chikmagalur. Kodur.
Kodur.
Giriyapur.
Ajampur Taluk.
Ajampur Taluk.
What is the distance between Ajampur and Bangalore?
240 kilometers.
You are residing with whom?
Parental home.
Parents. Due to the wedlock, any issues?
No, my lord.
Maklailla.
One male child.
Male child.
3 years old man.
Male child. What is the age?
3 years.
It is with her mother.
Yes, with mother.
Yes. She has filed any case?
No, my lord.
Or issue notice. Stay of further proceedings in MC number. Stay kalilva. Yes. Issue emergent notice.
Grant interim.
There is no application, Mr.
I will file the applications.
Yes.
For order.
File ಮಾಡಿ.
Early application illa. There is no application for stay, Mr. Yes.
Yes. For orders, serial number 12, Jagadish Mundaragi for petitioner.
Petitioner in this matter.
Yes.
We have taken paper
Acceptance of
publication.
notice taken through paper publications. Yes. ಎಲ್ಲಿದೆ paper?
Kannada Prabha.
This court by order dated 19/7/2024 permitted the petitioner to take out notice to respondent by substituted service through paper publication in Kannada Prabha, Chikmagalur edition. Pursuant to that, pursuant to that, petitioner has taken a paper publication and produced that paper publication along with that paper notification along with that memo. Respondent is called
K. Arun.
None appear. Memo is accepted. Service of notice to respondent is held sufficient. Yes, Mr. What is this?
My lord, transfer petition, my lord. My lord, initially, the respondent filed one MC petition before MC petition at Tarikere, my lord. We filed CP and it was transferred to Davangere, my lord.
No, MC for what?
For restitution of conjugal rights, my lord.
First he has filed a restitution of conjugal right.
At Tarikere, my lord. We filed CP and it was transferred to Davangere, my lord. Thereafter, he filed one more PCR at Tarikere, my lord.
Now what is that you want to seek for transfer?
My lord, thereafter he withdrawn that MC petition and filed GNWC petition at Tarikere, my lord. For
custody of child.
Please, my lord. That GNWC petition we are seeking transfer to Davangere, my lord.
GNWC. Now that where is that child is residing?
With petitioner at Davangere, my lord.
Davangere only.
Please, my lord.
Yes. So and so learned counsel appearing for petitioner wife has contended that after the matrimonial dispute, petitioner is residing with her parents along with her 3-year-old son in Davangere. Respondent husband has filed MC number 233 of 2021. No, not MC number. GNWC number 21. What is the number, Mr.?
Please.
21 of 2022.
21 of 2022, my lord.
You seen that prior, Mr. Yakre itara mistake ಮಾಡ್ತಾರೆ. Whether your prior has to be considered or you have to see the paper, Mr.
My lord.
Then see that prior.
Sorry.
Then filed in a GNWC 21 of 2022 for custody of son by name
Param.
The petition has been filed before Senior Civil Judge Tarikere. What is the date of? On 30/11/2022. At that time, the child is ordinary resident of Davangere. And he further contended that from Davangere to Tarikere, it's about, what is the distance, Mr.?
For 250 kilometers.
250 kilometers. It is inconvenience for her to go to Tarikere. Hence, sought for allowing that CP. Respondent is served unrepresented. It is not in dispute. Heard the learned counsel for the petitioner. It is not in dispute. Petitioner is the wife of, legally wedded wife of respondent. Their marriage was solemnized
31/1/2015.
on 31/1/2005. Due to wedlock, a male child was born. Now he is 3 years. What is his name?
Param, my lord. Param.
His name is Param. After the matrimonial dispute, ಯಾವಾಗ matrimonial dispute ಆಯ್ತು?
The year 2018, my lord.
In the year 2018, there was a matrimonial dispute. Hence, the petitioner left with the matrimonial house. What is the age now that Mr. Child? 2018 ಅಲ್ಲಿ ನೀವು matrimonial home ಬಿಟ್ರೆ 3 years ಅಂತಿರಲ್ರಿ.
Child born in the year 2016, my lord. So now it is
ಮತ್ತೆ 3 years ಅಂತ ಹೇಳ್ತೀರಾ? 16 ಅಂತ ಅಂದ್ರೆ 8 years ಆಗ್ಲಿಲ್ಲೇನ್ರಿ?
8 years, my lord.
ಮತ್ತೆ 8 years ಕಡಿಮೆ. Yes. ಏನ್ ಹೇಳಿದ್ನಲ್ಲ? Left with a matrimonial home in the year 2018, along with her minor son. From that date, she is residing with her parents in Davangere, along with her son, Param. The respondent has filed an GNWC
21%.
God and Water 21 of 2022 for custody of Param before Senior Civil Judge Tarikere. Under section 9 of the Guardian and Wards Act 1890, if the application with respect to the guardianship of the person under the Guardians and Wards Act, the application for custody has to be filed. The court having a jurisdiction in place where the minor ordinarily resides. At the time of the filing a petition, the minor child by name Param was residing. His ordinary residence is in Davangere. And also from Davangere to Tarikere, it's about 250 kilometers. It is inconvenience for the petitioner to come to Tarikere for prosecuting the case. In view of the above, the civil petition requires to be allowed. Accordingly, CP is allowed GNWC 21 of 2022 pending in the file of Senior Civil Judge JMFC. Tarikere is withdrawn. Same is transferred to Family Court at Davangere. Yes.
Serial number 13, Shankar DC for appellant.
Yesterday, good memo for withdrawal of the appeal. It seems that memo is not put.
ಯಾವುದು
ನಿನ್ನೆ ಫೈಲ್ ಮಾಡಿದ್ದೆ ಮೆಮೊ
withdrawal?
withdrawal.
Yes,
Now
we'll record it.
again I am filing one more.
Learned
more
counsel
memo.
for the appellant has filed a memo seeking leave of this court to withdraw this appeal.
Is not.
The memo is taken on record. The above appeal is dismissed as not pressed. Amount in deposit is transferred to the tribunal.
MS.
Yes.
Serial number 14, Chetan B for appellant, B Pradeep.
Respondent.
Where is Chetan? Pasor. Came. Yes. Yes, Mr.
My lord, it's a case of death, my lord. My lord, the tribunal has assessed the income of the deceased at rupees 9,000.
It is for enhancement.
Yeah, for enhancement of compensation.
Case of death.
Case of death, my lord.
Yes. What is the date of accident?
My lord, date of accident is on 2/6/2007. 17, sorry, 2/6/2017.
What is that income?
My lord, the income assessed with taken by the tribunal is 9,000 rupees per month.
Yes. What is that amount you have claimed?
My lord, I have claimed, my lord, 25 lakhs. My lord, as per the Lokadala chart,
ಎಷ್ಟು ಕೇಳಿದ್ರಿ ನೀವು?
my lord, I have claimed, my lord, total compensation of rupees 50 lakhs, my lord, sorry.
No. Monthly income ಎಷ್ಟಿದೆ ಅಂತ ಹೇಳಿದ್ರಿ ಅಂತ?
ನಾನ್ ಹೇಳಿದ್ದು 25,000, my lord.
25,000. Yes. Yes, 2017 ಗೆ ಎಷ್ಟಿದೆ?
11,000.
11,000. Yes. Future prospect, what is his age?
My lord, his age is 65. Hagagi, my lord, future prospects, my lord, is not there. My lord, the other thing is, my lord, the contributory negligence, my lord, of 10% is taken.
What is the deduction?
10%.
Alala.
1/3.
All expenses, 1/3.
1/3, yes.
Yes. Now that contributory negligence.
Yes, my lord.
Why?
My lord, on the ground that, my lord, he was, the deceased was not having the driving lessons. My lord, and on the other ground is that, my lord, but it is at issue number.
Document reveals that RC pertains to whose rider of the
The accident
motorcycle
took place
was
on the
holding that valid DL
road, madam.
to ride that offending motor vehicle's insurance policy was forced as in the jointly severely liable to pay the compensation to indemnify.
Lord.
Now, where is the finding?
Page number 12 of the judgment.
Yes.
I'll read it from the top, my lord. The PM report exhibit P8 reveals that the death of Siddhappa was due to shock and hemorrhage as a result of multiple injuries sustained. Thereafter, it is clearly established that said Siddhappa died on RTA on 2/6/2017 that held on 9:45 AM at Tiranya village near the house of Ramkrishna in collusion between two motorcycle bearing number so and so, which belongs to Rajanna, but ridden by this said Siddhappa by another cycle bearing number so and so, which was ridden by one Mallikarjuna along with a pillion rider with so and so. The said 3 persons were sustained injuries and said Siddhappa had succumbed to this said injury on the next day of the said accident itself. The PM PW1, who is the wife of Siddhappa, has categorically admitted that during the cross-examination that her husband Siddhappa was not having DL, and he further categorically admitted that the husband was riding his friend's motorcycle on the said date. The said admission of PW1 itself go to show that Siddhappa had contributed for the accident to an extent of 10% as held by so and so, my lord. Several judges.
That her husband Siddhappa was not having a DL.
And she further
categorically admitted that her husband was riding
his friend's motorcycle on the said date.
Admission itself goes to show that Siddhappa had contributed for that said accident. Angry agutte?
Lord, the
friend vehicle accident contribution.
Is actually is coming on left side of the road, opposite direction.
Adena illala finding all. Yes. That's all.
Yes.
Sorry. So learned counsel appearing for. The claimant has contended that the accident is occurred due to the negligence of Driver of, ಯಾವ vehicle?
Rider of the offending motorcycle.
Vehicle bearing
Motorcycle
number,
ಅನ್ನ?
ಎರಡು motors.
ಎರಡು motors.
Rider of the motorcycle bearing registration number KA
13S
S354. The tribunal error in held that deceased also contributed 10% of the accident only because he was not holding DL. This finding of the tribunal is contrary to the material available on record. In respect of quantum, he has contended that at the time of the accident, deceased was earning 25,000 per month. Tribunal has assessed notional income as 9,000 per month is on lower side. Lastly, he has contended that in view of judgment of apex court in case of Magma, claimants are entitled 40,000 each. Shri B. Pradeep Learned Counsel appearing for insurance company has contended that admittedly the deceased was driving that motorcycle not holding DL. She has no experience in driving that two-wheeler. Did cause for accident. The tribunal, he has no experience in driving the two-wheeler. He has also contributed to the accident. Therefore, tribunal has rightly held that deceased has contributed 10% to the accident. In respect of quantum, he has contended that
ಅದ್ರ ಬಗ್ಗೆ ಏನು ಹೇಳಲಿಲ್ಲ ಇವ್ರು ಏನು ಹೇಳಲಿಲ್ಲ.
ಕೇರಳ ಎಲ್ಲ ಮ್ಯಾಟ್ರ್ ಬಂದಿತ್ತು. ಇದನ್ನ ಮಡಿಸಿದ್ದೆ ನಾನೇ ಇದರಲ್ಲಿ ಇದೆಯಲ್ಲ yes, even though yes contended that he was earning 25,000 per month, he has not produced any document to establish the same. Therefore, tribunal has rightly assessed notional income as 9,000 per month. Lastly, he has contended that considering that age and avocation of the deceased, the overall compensation awarded by the tribunal just and reasonable, sought for dismissal of the appeal. Heard the learned counsel for the parties, peruse judgment and award. It is not in the case of the claimants that on 2/6/2017, deceased Siddhappa was riding a motorcycle bearing registration number KA 44H9013 at about 9:45 AM in front of Ramakrishna's house. Which place, madam?
Tiranya village, my lord, at
Taranya village. At the time, the rider of the motorcycle bearing registration number KA13 S354 was riding the bike in rash and negligent manner from opposite side along with the pillion rider dashed against the said Siddappa's motorcycle. Due to impact, he fell down and succumbed to the injury. To prove his case, he has examined, the claimant has examined. First claimant has examined as PW1 and Dharmendra has been examined as PW2. They have produced 16 documents. On the basis of the evidence of the parties, tribunal has come to the conclusion that the accident is occurred due to the negligence of rider of motorcycle bearing registration number KA13 S354 only because deceased as not wearing the helmet. Tribunal has assessed 10% negligence on the deceased.
Not having DL, my lord, not wearing helmet.
Huh?
Not having DL.
Not having DL.
Yes. My lord said
Helmet.
not wearing helmet andre adi.
Or not having DL. Yes. Riding that motorcycle if a person drives a vehicle without driving license, he committed an offense. The same by itself is not leads to finding of negligence as regarding the accident. The Apex Court in 2008 12 SCC 436 para 9 extract money. In view of the above, finding of the tribunal that deceased has contributed 10% to the tax extent is unsustainable. The driver of the bike bearing registration number KA13, rider of the bike registration number KA13 S354 alone is negligent in causing the tax extent. In respect of quantum, even though claimant has claimed that deceased was earning 25,000 per month, they have not produced any document to establish the same. Under the circumstances, notional income has to be assessed as per the guidelines for the accident occurred in 2017. 11,000 has to be considered. Tribunal has rightly deducted 1/3 of the income of the deceased for personal expenses. The multiplier applicable to that age group is 5. What is his age? 66. For 66 is 5. Accordingly, loss of dependency has been reassessed as follows.
11,000 minus 3,666 at the rate of 1/3, 7,334. 7,334 into 12 into 5, 4,40,040.
In addition, 15,000 for loss of estate, 15,000 for funeral expenses. Who are the claimants?
Wife and son.
Wife and son.
The claimant number 1 is entitled 40,000 for spousal consortium. Claimant number 2, 40,000 for parental consortium. Accordingly, the appeal is allowed in part.
Lord, medical expenses, my lord.
The medical expenses awarded by the tribunal is retained.
Yes.
Accordingly, the appeal is allowed in part. Judgment and award passed by the tribunal is modified as follows. Insurance company is directed to deposit entire compensation amount with interest.
Obliged, my lord.
14.
Notice to R1 is dispensed.
Serial number 15, Manjunath ND for appellant, P. Pradeep.
Appellant, my lord, in this case.
Yes.
My lord, records are needed, my lord.
Records. Yes. Notice to R1 is notice to R2 is dispensed. Yes. Office is directed to secure original records.
Serial number 16, K. Shantaraj for appellant, connected matter, Janardhan Reddy.
Non-compliance of the office objection. None appear for the appellant. 2 weeks time is granted to do the needful.
Connected. Serial number 17, Sanat Kumara came for appellant, Lala Kumar.
Needful to record some. R1 and
Yes, madam.
record to needful soon. Process are done.
Now, what you want now?
R1 and R2 process needful. Soon. Needful today.
We have done it.
Yes.
Yes. Cabinet Council for the appellant has submitted that needful has been done. Office to verify and proceed further.
Yes.
Yes.
Serial number 18, MR Iremated for appellant,
Non-compliance of the office objection and process memo. The advocate has to furnish IA. Yes, password. Where is that?
serial number 19, G. Lakshmi Rao for appellant,
Yes, mister. Week's time. At the request of council for the appellant, week's time is granted to do the needful.
serial number 20, Nagaraj RC for appellant, Ravish Benny.
Only 2 weeks time, my lord. Other respondent number 2 is death, my lord.
Yes, learned council for the appellant prays 2 weeks time to do the needful.
Serial number 21, Shripad Vishastri for appellant, connected matter, Ravi S. Samprati.
My lord, I am for appellant, my lord.
Yes, ready.
Ready, my lord. It's only for enhancement, only for enhancement.
Where is Ravi? Password. Once we will pass it to. Yes.
Serial number 22, Padmanabha Kedilaya V for appellant.
In this case, for respondent number 2, I may be permitted to serve to any standing counsel for Bajaj Alliance. R1, I will take notice. R2 to any standing counsel, I will serve now only.
Yes, Bajaj Alliance.
Bajaj Alliance.
Pradeep.
I will serve.
Yes. B. Pradeep is directed to take notice. Learned counsel for the appellant is directed to serve one set of copies on B. Pradeep. Notice to R1 is necessary.
Necessary.
Yes. Week's time is granted to pay the process, issue notice to. Unclaimed anta bandidiyala. Held sufficient.
Held sufficient. Agar
Yes.
held
Who
sufficient.
is owner of the vehicle?
Yes, but in the trial court, owner is held liable.
Yes. Notice issued to that respondent number 1, written with postal shara unclaimed. In service of notice to R1 is held sufficient. R2 Pradeep is directed. Yes. Why that owner has held liable?
Your lordship, why? But he is held liable.
Yes.
Cody, I. There's a.
Driver come owner, not.
It will be.
Serial number 23, Ravishankar Shastri G for appellant, R. Govindarajan.
2 weeks, my lord, for taking correct steps, my lord.
R1 is necessary.
Yes, ma'am.
Yes, week's time is granted to do the needful.
Serial number 24, O. Mahesh for appellant.
Yes, Mr. Mahesh.
24, O. Mahesh.
Yes, password.
Serial number 25, Ananda KS for appellant. 25,
Anand KS furnishing a PF with correct address issue notice to R1 a second time. Left R2. ಯಾರಿದು? ಇನ್ಸೂರೆನ್ಸ್ ತಗೊಂಡಿಲ್ವಾ? Date found. Reliance General Insurance Company.
Reliance General Insurance.
Ashok Patil. Ashok Patil is directed to take notice for respondent number 1. Learned counsel for the appellant is directed to serve one set of copies. Yes, sir. Week's time is granted to pay the process, issue notice to R2.
Serial number 26, 27 Arjan. Serial number 28, Chetan B for appellant, connected matter, M. Venkatesh.
I am for the appellant in the connected matter. Short point for consideration, my lord. Instead of taking 8,000 as income, 9,000 is taken, EC Act.
Now that you are challenging on only quantum.
Only quantum.
Yes.
Only quantum. Only difference will be around 1,06,000 rupees will be difference.
Yes, you are challenging on what ground?
Yes. He wants on the higher compensation. I want to reduce the compensation.
Yes, it's a case of
Death, my lord.
death. Yes, date of accident.
Date of accident, my lord.
Date 13/11/2016.
2016 ಅಲ್ಲಿ ಎಷ್ಟು 8
8,000 ರೂಪಾಯಿ 9,000 ರೂಪಾಯಿ ತಗೊಂಡಿದ್ದಾರೆ.
Yes.
It's all by the Naxor multiplied by the 11 factor.
Factors ಎಲ್ಲ correct ಇದೆಯಾ?
Either correct.
Yes. Or the question of law, substantial question of law arises for consideration. Whether tribunal justify in taking monthly income of the deceased as 9,000
Instead of 8,000.
is whether that monthly income assessed by the tribunal 9,000 is contrary to section 4 of
Section 4(1),
section 4 of
1 EC Act, WC Act,
4B na
4(1),
4(1B na another
4(1)A, my lord,
4(1A).
4(1)A.
Yes, section 4(1)A of Employees Compensation Act. Yes. So and so learned counsel appearing for insurance company has contended that
Maximum amount that can be taken from 31/5/2010 is for 8,000.
yes, contended that the accident was occurred on 13/11/2016. As per that section 4(1)A of the Act, the monthly salary as fixed by notification issued by the central government is 8,000.
Yes.
The tribunal has error in considering that monthly income of the deceased as 9,000 per month. CH-10 learned counsel appearing for claimant has contended that at the time of the accident, deceased was earning 20,000 per month.
Yes.
Therefore, tribunal has rightly assessed therefore, the monthly income assessed by the tribunal 9,000 is on lower side.
Lower side.
Heard the learned counsel for the parties. Feroz, judgment and award. It is not in dispute. Deceased, what is his name?
Or Pradeep Kumar.
Yes, sir.
Pradeep Kumar.
Deceased Pradeep Kumar
Is said medical.
was working under first respondent.
47,000.
He died on 13/11/2016 during the course of the employment. Under section
4(1)A.
4(1)A of so and so Act, as per that notification issued by central government dated 31st May 2010, the minimum wages has been fixed as 10,000, 8,000. Therefore, monthly income of the deceased has to be considered
At 8,000.
8,000 per month.
And 50% of the same because it is a case of death.
Yes. 50% of the income of the deceased has to be deducted in terms of, in view of provisions of section 4 of the Act.
Plus 28 years.
The factors applicable to that age group, what is his age?
No, for 28 years.
28 years is 211.79. Accordingly, the compensation has been assessed as follows.
8,000 into 50%, 4,000 into 211.79. 8,47,160.
Plus 5,000 towards funeral expenses.
Yes. In addition, 5,000 rupees for funeral expenses. Accordingly, the appeal filed by that insurance company is allowed in part. The appeal filed by that claimant is dismissed. Yes.
The excess amount deposited by the company may be deposited.
Yes. If there is any excess amount deposited by the companies, same is directed to be returned to the client. after due verification.
It carries 12% interest, my lord.
My lord, so far as the amount, my lord, which is entitled by the claimant, my lord, it may be transferred to the tribunal, my lord.
No, it is in the tribunal only. ECA Act Yes, delay of 92 days condoned. Dispense notice to R1. Yes.
Connected dispense.
Elderly dispensation idea. Yes. Notice to R3, second matter dispense. This is the R3 yaradu.
Because there is no dispute regarding quantum.
Yes.
Therefore, not necessary.
Yes, yes.
Serial number 29, VP Siddaramaya for petitioner.
My lord, the office objection is to furnish the typed copy of annexure B and C, my lord. At page number 20, annexure B is the form number
Kept the
7.
order sheet to be furnished as.
My lord, I am seeking writ of mandamus.
Para B. What is that prior para B?
My lord, prior B is
Mandamus
dispose
any
the-
director respond Deputy Commissioner Tumkur District Mini Vidhan Soda.
so they have not entertained and disposed the PTCL appeal number 4/2020
You are seeking only mandamus.
mandamus.
What is that? Who are you?
My lord, I am the successors of the original grantee.
You are LRs of grantee.
Yes, Karesiddhaya. My lord, the fact is like this, my lord.
When the
20
land was granted.
My lord, land was on 21/10/1971. We have executed the sale deed in favor of the private respondent.
No, what is the date of the grant?
My lord, grant is on 1982. 1974 under the Land Reforms Act.
No, when by the sale. Sale is
Sale is on 21/10. The fact is like this, my lord.
Where is that AC order, Mr.?
My lord, that may make ಇಲ್ಲಿ ಸ್ವಲ್ಪ twist ಇದೆ.
Yes, ಹೇಳಿ.
My lord, on 21/10/1971, Karesiddhaya has executed sale deed in favor of the private respondents for survey number 46/2. So it is a nominal sale deed, possession remains with Karesiddhaya. So after introduction of the Land Reforms Act, they have filed an application of form number 7 on 19/12/1974. My lord, land was granted, form number 10 was issued on 17/3/1982. So for survey number 42/2 instead of survey number 46/2. The Revenue Department has made an inspection and submitted a report. The property which were in possession is survey number 46/2, not 42/2. A rectification order has to be issued to rectify the same as survey number 42/2.
No, occupancy is in respect of 42/2.
Two only.
Application is filed under which?
46/2.
He has filed an application 46/2. Tribunal has granted 46/2
only.
Then you have to challenge that order.
My lord,
You said application is 46. If application is 42 and order is wrong, then you can say.
My lord, official memorandum dated 3 annexure F में kindly peruse, my lord. A report has been submitted to make rectification.
How can you miss? Who has sought for a rectification?
My lord, we have sought for rectification.
No, person who has filed in a form number 7.
Is my father. It's my father.
Your father has filed.
Father has filed application.
Then we have sought for the rectification.
Rectification. My lord, meanwhile, Kata of the property was transferred in the name of the earlier sale deed as per the 21/10/1971. And having the knowledge that we are in possession of the property, the land has been sold to some third parties. Hence, we have filed an appeal before the Assistant Commission that has not been entertained by the authorities. And second is we have given a complaint.
No, that what is that AC has held? Where is that order of the Assistant Commissioner?
No, the Assistant Commissioner order. PTCL 17/2014-15 ಇಲ್ಲ ಅದನ್ನು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡ್ತೇನೆ.
ನೀವು ಯಾವ ಆರ್ಡರ್ ಚಾಲೆಂಜ್ ಮಾಡಕ್ಕೆ?
We have not challenged. Deputy Commissioner ಮುಂದೆ appeal ಆಗಿದ್ದು, he has not entertained the appeal.
No, appeal against which order, Mr.?
Against the order of the AC that we have not produced.
Where is that order of the AC?
I will furnish it.
You furnish that?
Copy, now I have got the copy.
Kodi. What is your name?
My lord, Kampamma. Karesiddhaya is the
Chiಕ್ಕ ನರಸಮ್ಮ ಯಾರು?
ಇಲ್ಲ ಅದನ್ನ ನಾನು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿ ಹೇಳ್ತೀನಿ ಈಗ ತಂದು ಕೊಟ್ಟವ್ರು.
ಕೆಂಪಮ್ಮ ಲೇಟ್ ಕರಿಸಿದ್ದಯ್ಯ.
ಹೌದು.
ಇಲ್ಲಿ ಕೆಂಪಮ್ಮ
ಕರೆಸಿದ್ದಯ್ಯ ಇಸ್ ದಿ ಒರಿಜಿನಲ್ ಗ್ರಾಂಟಿ.
Narsama co late Siddlingaya. Then what has happened to your case?
Appeal has not been entertained. Let the deputy commissioner consider my appeal and decide on merits on that.
No, I am asking that what has happened?
That was
before
dismissed. That was dismissed.
Why that AC has dismissed, Mr.
ಇಲ್ಲ ಗ್ರಾಂಟ್ ಕೊಟ್ಟಿರೋದೇ ಬೇರೆ ಇದೇ ಬೇರೆ ಅಂತ.
Heard both present, advocate present, both the parties pray for notaries that case file may be objection document office within that 1 week. Hence, no, they are, this is also not final order matter. This is only order sheet.
ಇಲ್ಲ ಅದಕ್ಕೆ ನನಗೆ ಈಗ ತಂದು ಕೊಟ್ಟವ್ರೆ ಅದನ್ನ ನಾನು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡ್ತೀನಿ.
Yes, when will you produce?
ನೋಡಿ ಕರೆಕ್ಟ್ ಮಾಡ್ಕೊಂಡು ಮಾಡ್ತೀನಿ.
When?
So within
You produce, if you correct, I will direct them to dispose of this. Why do you want to make all these persons as in a party if you are?
ಬೇಕಿಲ್ಲ. There is an appeal is pending, my lord. That is sure.
You produce that.
Yes, I will produce my.
If appeal is pending,
yes,
you are directing the authorities to dispose of that. Why other parties will dispose of the writ petition?
My lord, the next Monday, 23rd.
Next
Monday, 23rd.
23rd. Yes, leave this
I will
matter.
collect it and I will file.
You collect that 23rd. I will not say any survey number and all. I will say this is the appeal is pending, directed to dispose.
Here interlocutory application matter, serial number 30, Mohan KN for petitioner, government advocate.
This petition filed by the indigent person, my lord, with regard to court fee. Last occasion, this honorable court has suggested me to file an application before division bench for release of amount. I have filed last week, not yet listed.
You move that matter there.
And
Yes, at the request of counsel for the petitioner. Leave this matter after 2 weeks. You are getting crores of together there. Why do you want that?
but the state has come in the way.
We have also directed request only for the court fee. Either way, it will go to the state only. Yes. ನೀವೇನ್ ಪೂರ್ತಿ ದುಡ್ಡಿಗೆ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದ್ದೀರಾ?
ಇಲ್ಲ ಅಂದ್ರೆ ಕ್ಲೈಂಟ್ ತುಂಬಾ ಸಫರ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ. ಅಲ್ಲ,
Don't take this advantage, Mr.
there is a loan also.
It is a case which is pending.
Bank notice ಬಂದಿದೆ.
Government has objected for releasing. You can seek release only to
Worst
that amount of court fee. If you seek entire, they will reject it.
ಇಲ್ಲ ಅದೇ ಲೋನ್ ಅಮೌಂಟ್ ಒಂದಿದೆ, ನೋಟಿಸ್ ಬಂದಿದೆ ಬ್ಯಾಂಕ್ ಇಂದ.
It's not concerned with that, Mr. It is when it is disputed. Yes.
For 31, Vinod Gowda for appellant, BC Sitaramma Rao.
But I appear for the respondent in the matter, no? I am ready,
Vinod
my lord. Appeal only for enhancement.
Yes, Mr. Anup.
Appeal only for enhancement, my lord.
Yes, other side is not there. Pass over.
Any other day, my lord.
Yes. There is a delay of 21 days. Delay is condoned. Yes.
Serial number 32, Shri Harsha AK for appellant.
For appellant, my lord,
D.
my lord,
Kumar,
11 days delay in filing the appeal, my lord. And LCR is required, my lord.
Why?
Claim petition is dismissed, my lord.
Yes, Mr. Vijay Kumar. Delay of 18 days in filing.
11 days, my lord.
IA is allowed, condoned, or admit. Yes.
Please, my lord.
Serial number 33, Mohammed Sharif for appellant, D. Vijay Kumar.
Here for appellant in this case.
Ready.
Court had ordered me to file a fresh affidavit with regard to the continuation of delay, which I have already filed, my lords. There is a delay of 492 days.
Where is the direction? Yes, pass out. Let Vijay Kumar come. Yes.
There is also a office objection to be complied. The delay may kindly be condoned.
No, this
Weeks
case
time-
for what? Enhancement or?
It is for enhancement, my lords.
Hmm.
It's only on contempt. Only on contempt.
Yes, Vijay Kumar, pass out.
So office objection complaints was.
Nodana. Let us see. That if he has no objection for condonation of delay, we'll condone it. Yes.
My lord, one submission, my lord. Venkatesh for appellant, R. Kiran.
One submission, my lord.
I'm for appellant, my lord. Delay may be condoned, my lord. Praise 1 week time.
We'll condone the delay, Mr. Then. There is a delay of 42 days. IA 1 of 2018 is filed for condonation of delay. For the reason stated in that accompanying affidavit, delay of 42 days in filing an appeal is condoned. Yes.
Admit.
And my lord, the matter is a small matter, my lord. I'm for the respondent in this case, serial number
Why-
54.
On on what ground they are
It's
challenging?
only one ground, my lord, that is the contributory negligence they had been.
Yes, ready, madam.
The trial court has awarded 70-30 contributory negligence, my lord. 70% on the insurance company.
Yes.
That is the only ground. So lordship
Yes.
can take up the matter in the admission leads itself so that it can be disposed of.
Next week, they are not ready, Mr.
Please, my lord, next
Yes,
week.
next.
Serial number 35,
My
Gaurav
lord,
GK.
serial number 33, my lord.
Yes, pass over, Mr.
32, 33, please, my lord, ready.
35, Gaurav GK for
I'm for
appellant.
the appellants,
M.
my lord.
Ashok Kumar.
I'm for the appellants. This is a case of injury. We have filed an appeal for enhancement of the award. And we had filed a IA for condonation of delay. This is a condonation of 524 days, my lord. The appellant had some financial constraint. He was not able to.
Where is that Ashok Kumar? Yes, they filed any objection?
They have filed their objection.
What is that objection there?
The
Pass out, get him. We'll condone the delay.
Please, ma'am.
ಯಾರು ರಿಟೈರ್ಮೆಂಟ್ ಹಾಕಿದ್ದಾರೆ ಇಲ್ಲ ಪಾಸ್ ಓವರ್.
Serial number 36, Harish Babu KN for appellant, Ashok N. Patil.
There is only 9 days delay.
Yes.
Death case.
Delay of 9 days is condoned.
Permit questioning the permit illa ant helide. Pay and recovery order ಮಾಡುದು if they agree.
ಅಷ್ಟೇನಾ?
ಅಷ್ಟೇ. Quantum ಇದೆ. Quantum income ಕಡಿಮೆ ತಗೊಂಡಿದ್ದಾರೆ ಅಷ್ಟೇ.
Yes, what is the date of the accident?
Date of accident is on 2014.
What was that?
8,000 ತಗೋಬೇಕಿತ್ತು. 6,000 ತಗೊಂಡಿದ್ದಾರೆ. 8,000.
Was his income at that time?
Income 15,000.
15,000. Tribunal ಎಷ್ಟು ತಗೊಂಡಿದ್ದಾರೆ?
6,000 ತಗೊಂಡಿದ್ದಾರೆ.
What was that in the chart?
8,000 ಕೊಟ್ಟು.
8,500.
1/3 ಡಿಡಕ್ಟ್ ಮಾಡಿದ್ದಾರೆ, 1/4 ತಗೋಬೇಕು.
1/4 ಆಗ್ಬೇಕಾ?
Why,
who are the claimants?
Claimants are mother, wife and children.
Yes. Mother, wife and children. 1/4. Then future prospects ಕೊಟ್ಟಿದ್ದಾರಾ?
ಕೊಟ್ಟಿದ್ದಾರೆ. 40% ತಗೊಂಡಿದ್ದಾರೆ.
What is his age?
His age is 33.
Yes.
But 40 ತಗೊಂಡಿದ್ದಾರೆ.
40 ಕೊಟ್ಟಿದ್ದಾರಾ?
40 ಅಂತ ತಗೊಂಡಿದ್ದಾರೆ ಏಜ್.
Age 40. Multiplier?
Multiplier 16. ಅಲ್ಲ 33 ತಗೊಂಡಿದ್ದಾರೆ ಸ್ವಾಮಿ, ಸಾರಿ 33 ತಗೊಂಡಿದ್ದಾರೆ. 16
ಎಲ್ಲ ಹಾಕಿದ್ದಾರೆ. ಎಸ್ ಮಿಸ್ಟರ್
ಪೇಜ್ ನಂಬರ್ 14 ಅಲ್ಲಿ ಇದೆ. ಅಂಡ್ ಅದರ್ ಇಟ್ಸ್ ಅಲ್ಲಿ ಕನ್ಸಂಪ್ಷನ್ ಅಲ್ಲಿ ಬರೀ 40,000 ಕೊಟ್ಟಿದ್ದಾರೆ. ಅದು 160 ಆಗಬೇಕು.
16. 33 16
ಅಷ್ಟೇ.
Yes. Where is that finding regarding that liability?
Liability.
Yes. Read para 26.
26. As stated above, in spite of service of notice, respondent did not appear before the tribunal and place ex parte, which is turn leads to the adverse infraction against him that he has admitted the claim petition. Respondent to insurance company has contested the petition and denied its spot liability to pay compensation to the petitioner on the ground that lorry in question has no valid permit to play on the accident spot at the time of accident. In order to substantiate its defense, respondent number 2 examined RTO Anantpur as RW1, who is in his evidence has produced authorized letter RC extract to owner of lorry so-and-so, permit extract, fitness certificate, which was marked as exhibit R1 to R4. In his evidence, he has stated that the permit pertaining to lorry bearing so-and-so is valid in the state of Andhra Pradesh only. during the course of his cross-examination by the learned counsel for petitioner, RW1 has stated that in order to go to other states other than Andhra Pradesh, the RC owner shall obtain a permit. In order to go to Karnataka from Andhra Pradesh, the RC owner of the vehicle shall obtain permit from the RTO from which he has obtained permit, that is on Anandpur RTO, Andhra Pradesh state only. He has denied that the suggestion that it is only state transport authority that has authorized to grant permit to enter the different state but not RTO, and has further stated that the temporary permit is
Yes,
permissible.
pay and recovery.
And
Yes.
Insofar as-
Criminal has fasting on the liability on the owner itself.
Owner itself, because not the
Owner service ಆಗಿದೆಯಾ? ಯಾಕೆ ನೋಟಿಸ್ ಆಗಿಲ್ಲ? Patil, how you have filed an wakalat?
the court ಇಲ್ಲಿ ಡೈರೆಕ್ಷನ್
Patil for auto notice not ordered.
ಡೈರೆಕ್ಷನ್ ಇತ್ತು ಸ್ವಾಮಿ, ಕೋರ್ಟ್ ಮೇಲೆ ಡೈರೆಕ್ಷನ್ ಇತ್ತು.
ಇನ್ನೊಂದು ಕನೆಕ್ಟೆಡ್ ಮ್ಯಾಟರ್ ಇದೆಯಾ?
ಇಲ್ಲ
Void order dated
Not aware.
in MFA 10.395 of 2018 dealing from this file.
ಇಲ್ಲ ಯಾವ್ದು ಇರ್ಲಿಲ್ಲ.
ವಕಾಲತ್ ಫೈಲ್ ಮಾಡಿದ್ದೀರಾ?
ಮಾಡಿದ್ವಿ.
ಮಾಡಿದಾರಾ?
ಮಾಡಿ.
Yes, owner has not filed any this thing. He has placed an ex parte, file in a memo. Order 41
Right.
rule. Order 21 rule 33 ಇಲ್ಲ. If it is placed ex parte.
Rule 10.
ಅಲ್ಲ, order 21 rule 33 ಕೊಡಿ. ಅಲ್ಲ, order 41 rule 14. Order 14.
Rule 14.3 ಬರುತ್ತೆ ನೋಡಿ. Order
Huh?
41 rule 14.3.
Order 41 rule 14.3 subclass 3.
Yes, yes. Notice to be served on that respondent shall be accompanied by order 40,
Order 41 rule 14 subclass 3.
14.3 ಅಲ್ಲಿ ಇಲ್ಲಲ್ಲ, ಇದೇನಾ ಇದು? Subclass 3.
ಹೌದು.
14 ಯಾವ್ದ್ರಲ್ಲ ಇದೆ? Subclass 3 ಅಲ್ಲಿ the notice to be served on that respondent shall be accompanied by the copy of the appeal memo. Country court shall first instances appear appeal, not swept. There ಏನಿದೆ 14. Thousands are provided that where the suit is proceedings, ex parte in the court of whose degree is appeal is preferred, declared absent by the Madras, Karnataka, same as Andhra Pradesh. Andhra Pradesh. Provided the appellant court may dispense with the state amendment ಅಲ್ಲಿ. Appellant court may dispense with the service of notice and respondent who has remained absent against whom the suit is proceeded as ex parte
Yes.
in the court whose degree appeal is preferred, who has been declared absent by the said court. This is Andhra Pradesh, same is in Karnataka also. Then state amendment ಅಲ್ಲಿ ಇದೆ. You file an application memo.
Please.
Under order 41 rule 14.
Please.
Order 41 rule
But
14.
before the minutes, before the trial court minutes, he is represented by a lawyer.
Huh?
Before the trial court is represented, the owner is represented by a lawyer.
Ex parte ಅಂತ ಏನಾಯ್ತಲ್ಲ. Court ಅಲ್ಲಿ he has served unrepresented place an ex parte ಅಂತಿದೆ.
His name
ಇದೆಲ್ಲ
is
ಓದಿದ್ರಲ್ಲ ಇವರು.
K. Kumar anta.
ಅದೇ ಇದ್ರಲ್ಲಿ ತೋರಿಸ್ತಾನೆ. Then you can't, mister.
BK Kumara.
ಇಲ್ಲಿ where is that somewhere you have read in the hand defense of the respondent.
Inter alia, para number 4 it is there.
Huh?
Para number 4, inter alia, in spite of service of notice to respond number, failed to appear before the tribunal and placed ex parte anta ide. But minutes here.
Records ಇದೆಯಾ?
The 4 of the judgmental.
Huh?
4 of the judgment.
ಏನ್ ಬೇಕಾದ್ರೆ ಬರೀತಾರೆ judgment ಅಲ್ಲಿ ಏನ್ ಬೇಕಾದ್ರು. See that his name has been shown here para 4 ಅಲ್ಲ.
ಹೌದು.
Based upon the relevant contention so and so, the petitioner and the company claimed that so and so denied that rest. Para 4 ಅಲ್ಲಿ ಎಲ್ಲಿದೆ?
Para 4
Piece of notice to the respondent when failed to appear before the
tribunal placed ex parte. Respondent number 2 is the insurance company. We have not resisted the
BK Kumaran advocate ಅಂತ ತೋರಿಸ್ತಲ್ಲ ಓನರ್ ಆಫ್ ದ ಲಾರಿ. ಇಲ್ಲಿ ನೋಡಿದ್ರೆ ಎಕ್ಸ್ ಪಾರ್ಟಿ ಅಂತಾರೆ. Dismissed against that. ಇಲ್ಲೆಲ್ಲ ಫೈಂಡಿಂಗ್ ಅಲ್ಲೆಲ್ಲ ಕೊಟ್ಟಿದ್ದಾರೆ ನೋಡಿ.
Finding ಅಲ್ಲಿ ಇದೆ 27.
Case in hand as per the defense of the respondent, offending vehicle has no valid permit to play vehicle on the so and so. Permit. Right of the service R1 didn't appear before the tribunal and placed the ex parte, which in turn leads to that adverse inference against him that he is admitted the claim of the petitioner ಅಂತ ಹೇಳ್ಬಿಟ್ಟು para 26 ಅಲ್ಲಿ.
Para 26 ಅಲ್ಲಿ ಹೇಳ್ತಾರೆ.
ಇಲ್ಲಿ ಇವ್ರದ್ದು ಯಾರ್ದು ಅಡ್ವೊಕೇಟ್ ಹೆಸರು ತೋರಿಸ್.
ಮೋಸ್ಟ್ಲಿ ಅದು ರೀಟೈಪ್ ಮಾಡ್ಬೇಕಾದ್ರೆ ಮಿಸ್ಟೇಕ್ ಆಗಿರುತ್ತೆ ಅಷ್ಟೇ.
ಯಾರ ಅಡ್ವೊಕೇಟ್ ಹೆಸರು
ಪೇಸ್ಟ್ ಕಟ್ ಅಂಡ್ ಪೇಸ್ಟ್ ಅಲ್ಲಿ ಮಿಸ್ಟೇಕ್ ಆಗಿರುತ್ತೆ.
ಹೆಸರುಗಳ ಹೆಂಗೆ ಅಡ್ವೊಕೇಟ್ ಹೆಸರುಗಳು ಅವರಿಗೆ ಸ್ಟೆನೋಗ್ರಾಫರ್ ಬರುತ್ತೆ ಅದನ್ನ.
ಅದು ಹಳೇದಿರುತ್ತಲ್ಲ ಅದು ಹಂಗೆ ಕಂಟಿನ್ಯೂ ಮಾಡ್ಬಿಟ್ಟಿದ್ದಾರೆ.
Yes. File memo.
Please.
Learned counsel for the appellant has filed a memo. Under order 41, rule 14 of CPC seeking dispensation of notice to respondent. Here respondent number
1.
Respondent number 1 on the ground that he has been placed ex parte before the tribunal. Memo is taken on record. Notice to R1 is dispensed.
Now, I have 2 submissions to make. The claimant number 4 minutes was the mother of the deceased, but was deleted at para number 12 minutes because she died.
ಅದಕ್ಕೆ 1/3 ಮಾಡಿದ್ದಾರೆ.
ಹೌದು.
But see that in the cast title in the judgment
sorry.
and degree it is appearing.
ಹೌದು.
Yes.
1/3.
ಏನು ನೋಡೋದಿಲ್ಲ ಸುಮ್ಮನೆ ಒಟ್ಟು.
And minutes the interest part minutes is awarded at rupees 8%.
ಅದನ್ನ ಕಡೆ.
But since minutes we had no opportunity of minutes challenging this judgment and award.
Make it 6% for
Please,
one
6%
altogether. Yes. So and so learned counsel appearing for. ಇದು adding dead person again in the cast title, it shows further this thing. Doubt has been cleared that name of the advocate has been wrongly shown because number of this error is there in this judgment. So and so learned counsel appearing for claimant has contended that at the time of the accident, deceased was earning 15,000 per month. Tribunal has assessed notional income of the deceased as 6,000 per month is on lawyer side.
6,500.
6,500 is on lawyer side. He further contended that in view of judgment of apex court in case of magma, claimants are entitled 40,000 each. Hence he sought for enhancement of compensation. In respect of liability, he has contended that the tribunal has rightly held that the offending vehicle was not having a permit to play that vehicle in state of Karnataka as on the date of the accident, and rightly exonerated that insurance company. But in respect of third parties is concerned, the insurance company has to pay that compensation amount with liberty to recover from owner of the offending vehicle. In support of his contention, he has relied on judgment of Apex Court in case of Rani. Shri Patil, learned counsel appearing for insurance company, has contended that even though claimant has claimed that deceased was earning 15,000 per month, they have not produced any document to establish the same. Therefore, tribunal has rightly assessed notional income of the deceased as 6,500. Secondly, he has contended that considering that age and avocation of the deceased, the overall compensation awarded by the tribunal just and reasonable. In view of judgment of this court, the interest awarded by the tribunal 8% is on higher side. In respect of liabilities is concerned, he has contended that admittedly, as on the date of the accident, the offending vehicle has no permit. Since insured has violated the policy condition, insurance company is liable to pay that compensation. Tribunal has rightly, since insured has violated the policy condition, the tribunal has rightly exonerated that insurance company from the liability. Hence, he sought for dismissal of the appeal. Heard the learned counsel for the parties. Arose judgment and award. It is not in dispute. What is the name of the deceased?
Deceased.
Nagesh.
M. Nagesh died in road traffic accident occurred on
16/8/2014.
Order 41 Rule 14 haki.
Order.
Melgade. Nagesh died in road traffic accident occurred on 16/8/2014 due to rash and negligent driving of driver of lorry bearing registration number AP09 Y4323. Even though claimant has claimed that deceased was earning 15,000 per month, they have not produced any document to establish the same. Under that circumstances, notional income has to be assessed. Guidelines for the year 2014, 8,500 has been considered. Tribunal has rightly deducted 1/3 of the income of the deceased for personal expenses. I3. ನೀವು ಇಲ್ಲಿ ಬರ್ದಿದ್ದೀರಾ ಕಾಸ್ಟ್ ಟೈಟ್ಲಲ್ಲಿ deleted as per the order of the trial court ಅಂತ. Then you are arguing 1/4 again. ಲಕ್ಷ್ಮಮ್ಮ ಸತ್ತೋಗಿದ್ದಾರೆ ಅಂತ ನಿಮ್ ಕಾಂಟ್ರಾಕ್ಟ್ ಎಲ್ಲ ಇದೆ.
ಹೌದೌದು. But at the time of filing ಇದ್ರಲ್ಲ ಅಂತ 1/4 ಕೇಳಿದ್ದಷ್ಟೇ.
At the time of
filing the case she was alive. ಅದಕ್ಕೋಸ್ಕರ 1/4 ಕೇಳಿದ್ದಷ್ಟೇ.
Yes. Tribunal has rightly deducted 1/3 of the income of the deceased for personal expenses and rightly added 40% of the income of the deceased for future prospects. The multiplier applicable to that age group is 16. Accordingly, loss of dependency has been reassessed as follows.
8,500 plus 3,400 at the rate of 40%, 11,900 minus 3,966 at the rate of 1/3, 7,934. 7,934 into 12 into 16, 15 lakhs 23,328.
In addition, 15,000 for loss of estate, 15,000 for funeral expenses. In view of judgment of apex court in case of Magma, first claimant is entitled 40,000 for spousal consortium. 2 and 3 are entitled 40,000 each for parental consortium. In respect of, in view of judgment of this court, the interest has to be scaled down to 6% from 8%. It will interest kadme madi. Even though there is no insurance appeal, but the interest, entire amount it is 6%. In view of judgment of this court, interest has been reduced to 6%. In respect of liability, the tribunal has given a clear finding that in spite of service of notice to the owner, he did not appear before the tribunal. He has been placed ex parte. The respondent insurance company has taken a specific contention that as on the date of the accident, the offending vehicle has no valid permit to play that vehicle in Karnataka.
We have also examined RTO official
Also examine RTO
as RW1.
as RW1. Considering the same, tribunal has held that as on the date of the accident, offending vehicle was not having valid permit and exonerated that insurance company from the liability. However, in respect of claimant is concerned, in view of judgment of apex court in case of Rani, the insurance company has to pay that compensation amount in the first instance with liberty to recover from owner of the offending vehicle. Accordingly, the appeal is allowed. Judgment and award passed by the tribunal is modified as follows. Insurance company is directed to deposit entire compensation amount with 6% interest within 6 weeks from date of receipt of the copy of this order. Liberty to recover from owner of the offending vehicle.
Please.
Delay is controlled.
Serial number 37, Nagaraja HR for appellant, EI Sanmati.
Appellant.
Yes, ready.
Claim petition is dismissed now. Only on the ground, my lord, that earlier claim petition was dismissed first time. At the first instance, there is a claim petition has been filed. That has been dismissed for non-prosecution. Thereafter, this one more claim petition has been filed. On that ground, only, my lord, the claims tribunal has dismissed the claim petition without answering any other issues.
No,
though
yes,
it is framed.
whether it is maintainable, that is the issue.
Yes, my lord.
Where is that
That is
judgment?
maintainable.
Dismiss for default.
Yes, my lord.
Is it not amount to res judicata?
No, my lord. Section 9 of the CPC says, my lord, if it is within the limitation, then one more suit can be preferred.
Yes, which is that
Para 70 to 74, it has been discussed, my lord.
70?
Para 70.
70.
Yes, my lord. Section 9 of the CPC, it is very clear, my lord.
Yes, 74. 70, na?
Yes.
Yes, Mr.
One judgment miss out this.
What is the facts of this case, Mr.
In that case, it's the very same fact, my lord.
It is
Earlier,
also
my lord,
before that under that MEC Act.
yes, that has been discussed. Claim petition was dismissed at the first instance for non-prosecution. Thereafter, my lord, one more claim petition has been filed. The insurance company has taken the contention that this claim petition is not maintainable in view of the earlier dismissal. That has been considered by the court and specifically held, though it is dismissed for non-prosecution, it is not decided on merits.
Which is that paragraph?
Para 74 ಅಲ್ಲಿ 17 to 24
Andhra
ನನ್ನ
Pradesh High
judgment
Court in
miss
case
ಆಗಿದೆ.
of so and so has held that second claim petition is maintainable. dismissal of the earlier claim petition can't be a ground for dismissal. Ground relevant para 4 of the, because all the tribunal was in error. Ground that earlier work is dismissed on the default. This is remedy is to file the petition for restoration of the earlier work that he has to be from because of poor dismissed for default of non-prosecution. The prosecution of work the point is yes, madam.
My lord, as the senior land counsel said that it is not only dismissed on the basis of, there was one more petition which was dismissed on non-prosecution of the petitioner. There is also, he has also deposed that the accident has occurred due to his own negligence. Here, he himself has deposed in the cross-examination and also
Component 2 insurance company has submitted that in the evidence.
he himself has
Has
deposed
admitted
that the
that
accident has occurred on his,
No, this is on merit, mister.
on his own
Pardon, my lord?
negligence, my lord.
This is was disposed of on merit.
No, my lord. It was, no, sorry. my lord.
Judgment-
The petitioner proves that petitioner sustained bodily injury so and so.
That is thereafter.
Proves
my lord.
that driver of the Tata Suma was not holding valid and
That is why in that judgment,
the accident negligence and so on.
earlier it was dismissed for non-prosecution. It is this is a second claim petition. This is the second claim petition wherein, my lord, it was dismissed on, disposed of on merits.
What is this then finding?
Finding, my lord, it was allowed and compensation has been granted. Earlier claim petition was dismissed for non-prosecution. On that ground, my lord, the tribunal cannot dismiss the claim petition on its own
Earlier
ground.
in the
That is-
sense, my lords, before accident, he has filed a compensation petition before
it-
accident.
Which is that order you are challenging? That page 6.
Sorry, my lord, I may pass over, my lord. Judgment copy, copy till us. It may pass over.
Pass out, verify.
Bring it on more judgment.
Yes.
Sorry.
Yes.
Number 38, A. Prasanna Shetty for appellant, C. Shankar Reddy.
For appellant, my lords.
Case of minor
Minor, my lords.
injury.
Two injuries, my lords, one simple, one grievous, sir. 15,000 is given, my lords. In all, 36,000 is given, my lords.
What
Only
is that
Doctor has not been.
Doctor has been not examined.
has not been examined?
my lords.
ಎಷ್ಟು ಕೊಟ್ಟಿದ್ದಾರೆ? Again, what is that
36,832
injury, mister? What is the injury?
Injury, my lords, page number 6 of judgment, my lords. Multiple abrasion over lateral aspect of right forearm. Head injury with fracture left temporal bone
Abrasion
with right
over the
temporal dot
lateral
contusion.
aspect of-
I suggested
One grievous
another 30,000 for
Huh?
another 30,000 the
Yes.
global. ಹೇಳಿದೆ
Fracture of left forearm. 40 another 13
My
Ah,
lords,
under 30.
40,000 may be given, my lords.
40 doctor has not been examined.
70. Yes. ಅಲ್ಲಿಗೆ 36,000 ನ ವಿಲ್ ಮೇಕ್ ಇಟ್ 70,000.
ಆಯ್ತು
34 ಆಗತ್ತೆ ಅಲ್ಲಿ 34,000 ಆಗುತ್ತೆ.
ಆಯ್ತು.
ಯಾಕಂದ್ರೆ ಇದು 36 ಇದೆ. 40 ಅಂತ ತಗೊಂಡ್ರು 40, 30, 70. ಇಲ್ಲಿ 34,000 ಆಗುತ್ತೆ. Yes. So and so learned counsel appearing for. The claimant has contended that. Due to that extent, at the time of the extent, claimant was aged about 6 years.
Second standard student.
Second class, second
Second
standard. He has suffered 2 injuries. He has
Page number 6 of judgment.
ಎಷ್ಟು ದಿನ ಹಾಸ್ಪಿಟಲ್ ಅಲ್ಲಿ ಇದ್ರೆ ಏನಾರು ಇದೆಯಾ?
3 days.
4 days, my
He
lord.
was inpatient for a period of 4 days. He has suffered lot of pain during the treatment. The compensation awarded by the tribunal, 3,36,832 is on lower side. Hence sought for enhancement of compensation. For contra, Reddy learned counsel appearing for insurance company has contended that injuries suffered by the claimants are minor in nature. He has not examined the doctor. Considering that injuries suffered by the claimant, the overall compensation awarded by the tribunal is just and reasonable. Sought for dismissal of the appeal. Heard the learned counsel for the parties. Peruse judgment and award. It is not in dispute. Claimant has suffered an injury in road traffic accident occurred on 11/3/2016 due to rash and negligent driving of rider of motorcycle bearing registration number KA 18 X 9713. Due to that accident, claimant has suffered the following injury. At the time of the accident, he is aged about 6 years, studying in second standard. He has suffered and he was inpatient for a period of 4 days. He has suffered a lot of pain during the treatment. Considering that injury suffered by the claimant and medical records, I am of the opinion that the compensation awarded by the tribunal 36,832 has to be enhanced to 70,000 with interest. Accordingly, the appeal is allowed in part.
72 days delay.
Delay is controlled.
Please.
Serial number 39, Harish Babu Ken for appellant, B. Pradeep.
ಇದ್ರಲ್ಲೂ ಪರ್ಮಿಟ್
Yes, what
ಕಂಟೆನ್ಷನ್ ಈಸ್ ಪರ್ಮಿಟ್ ಇಲ್ಲ ಅಂತ ಹೇಳಿದೆ. ಮೈ ಕಂಟೆನ್ಷನ್ ಈಸ್ ಪರ್ಮಿಟ್ ಈಸ್ ನಾಟ್ ರಿಕ್ವೈರ್ಡ್ ಅಂತ ಹೇಳಿದೆ.
ಏಕೆ?
Because vehicle weight is, if the vehicle weight is less than 3,000 kgs, permit is not required under section 66 class 3 li.
Yes.
But ಅವ್ರೇನಾದ್ರೂ pain recovery ಇದ್ ಮಾಡಿದ್ರೆ I have no objection. I don't want to argue on that one.
No permit ಅಂತೇಳಿ exoneration ಆಗಿದೆ sir.
No, is it the, what is that law on that point? If that permit for route permit or vehicle permit?
ಅಲ್ಲ vehicle permit. Goods vehicle, goods vehicle.
No. Permit for this thing, vehicle is not required for goods vehicle. If it is
Less than 3,000 kgs ಇದೆ.
ಎಲ್ಲಿದೆ ಅದು?
66 class sub class 3 ಇದೆ.
ಕೊಡಿ.
I
66
class 3 I ಇದೆ.
To any goods vehicle.
Any goods
The
vehicle,
goods
gross
vehicle
weight
weight of which does not exceeding
3,000
provided
kgs.
further that permit of any articulated vehicle may use that beam over that articles related so on. So the provision substance shall not apply. Yes. One, what is that one? No owner of the motorcycle shall use or permit to use of the vehicle as a transport vehicle in any public places, whether or not such vehicle is actually carrying any passenger or goods. The condition of the permit granted, signed by the regional transport authority. ಇದೇನು goods vehicle?
Goods vehicle.
Yes, Mr. Ravi, what is that?
It's a passenger carrying vehicle or a goods carrying vehicle, it is not required.
Permit is not required.
Not required.
Then insurance company is liable. What is the pay and recovery?
ಅಲ್ಲ, if they agree ನಾನು
No, compromise ಪ್ರಶ್ನೆ ಅಲ್ಲ. This is a court. You have to assist the court on law, Mr. Tomorrow my order is wrong. If law permits that license is not required, then they are to liable to pay that compensation. Yes, Mr.
PCR required, my lord, maybe.
Why? That is the finding. Where is Pradeep? Ask him to come, pass out.
Please.
Yes. You have to assist the court on law, Mr. Not compromising that pay and recovery and all. Yes.
Serial number 40, Guru Prasad BR for appellant.
There is a delay of 63 days, my lords.
Preparing for that.
Yes.
Records are necessary, my lords.
Necessary. Delay of 63 days in filing an appeal is controlled. Office is directed to secure original records.
Please.
Yes, please.
Serial number 41, Guru Prasad BR for appellant, BC Shivande Gowda.
Please, my lord. Yes, there is a delay of 53 days, my lords.
Records ಬೇಕಾ?
ಬೇಡ.
Ready? Good. Yes. Yes.
It is a case of injury. Date of accident is 17/11/2016.
Yes,
The age of the claimant is 22 years at the time of accident.
yes.
The injuries are total 5 injuries. Out of them, 4 are minor, and the 5th one is fracture of
Distal.
fragment of fracture bone with underlying fracture of distal shaft of tibia and displaced fracture of distal shaft of fibula. Both tibia and fibula fracture, my lords. He was an inpatient for a period of 9 days on 2 occasions, my lords.
4 days.
ಅಲ್ಲ 2 occasion ಇನ್ನೊಂದಿದೆ.
Yes.
29ರಿಂದ total 9 days he was an inpatient, my lords.
Yes.
Disability has not been considered. The doctor has stated that 15% disability to the left lower limb. However, my lords, in the discussion, my lords, that the same has not been considered, and also other hits, my lords. My lords,
There is no discussion on it.
ಅಲ್ಲಿ ಏನು ಕೊಟ್ಟಿಲ್ಲ ಅವರ ಅದರೊಳಗಡೆ. Your lordship may kindly come to
Loss of amenities and medical expenses. Medical expenses ಎಷ್ಟಿದೆ?
ಮೆಡಿಕಲ್ ಎಕ್ಸ್ಪೆನ್ಸಸ್ 88,000 ಕೊಟ್ಟಿದ್ದಾರೆ, ಪ್ಲಸ್ 30,000 ಅಮ್ಯುನಿಟಿ ಕೊಟ್ಟಿದ್ದಾರೆ.
ಸರಿಗಿದೆ.
Yes. Pain and suffering 20 ಕೊಟ್ಟಿದ್ದಾರೆ.
ಅಂದ್ರೆ 3 ಅಂದ್ರೆ.
Yes, that's all.
Please, madam.
Yes, 5% we can consider functional disability.
5%.
Yes.
And also other head smellers, they are on the lower side.
Yes, we'll consider that.
Please.
During the later period ಕೊಟ್ಟಿಲ್ಲ.
ಕೊಟ್ಟಿಲ್ಲ ಸ್ವಾಮಿ.
ಏನು ಕೊಟ್ಟಿಲ್ಲ.
Yes.
Later period ಕೊಟ್ಟಿಲ್ಲ. Future medical expenses, my lords, for removal of implants, doctor has stated 15,000 is necessary. That has not been.
Tribunal ಏನು ಹೇಳಿದ್ದಾರೆ?
ಕೊಟ್ಟಿಲ್ಲ.
ಕೊಟ್ಟಿಲ್ಲ. ಟ್ರಿಬ್ಯುನಲ್ ಏನು ಡಿಸ್ಕಷನ್ ಮಾಡಿಲ್ಲ.
Discussion ಏನು? Where is that evidence of doctor?
Lords.
Doctor evidence ಇದೆಯಾ ಕೊಡಿ.
ನನ್ನ ಫೈಲ್.
$15,000.
15%.
Yes. So and so learned counsel appearing for the claimant has contended that at the time of the accident, he was earning 15,000 per month. He has examined the doctor as PW2, 3. In his evidence,
PW2, my lords.
2. In his evidence, he has deposed that claimant has suffered 15% disability
To limb.
to particular limb,
Left lower limb.
lower limb.
Left lower limb.
Yes. Tribunal has not granted any compensation for loss of income due to the disability. Secondly, he has contended that due to the accident, claimant has suffered grievous injury. He was inpatient for a period of 9 days. He has suffered a lot of pain during the treatment. He has to suffer this disability and unhappiness throughout his life. Compensation awarded by the tribunal, pain and suffering, loss of immunities is on lower side. Tribunal has not granted any compensation for loss of income during the later period. Lastly, he has contended that due to that accident, claimant has suffered grievous injury. He has undergone surgery. Doctor has deposed that he required 15,000 rupees for removal of the implant. Tribunal has not granted any compensation for future medical expenses. Hence, he sought for enhancement of compensation. For contra, Shri Shivanegowda, learned counsel appearing for insurance company has contended that even though doctor has deposed that claimant has suffered 15% functional partial disability of lower limb, it will not affect his day-to-day function, or it will not affect his avocation. Therefore, tribunal has rightly not granted any compensation for future compensation for loss of income due to the disability. Secondly, he has contended that considering that evidence of doctor and injury suffered by the claimant, the overall compensation awarded by the tribunal is just and reasonable. Hence, he sought for dismissal of the appeal. Heard the learned counsel for the parties. Perose judgment and award. It is not in dispute. Claimant has suffered an injury in a road traffic accident occurred on 17/11/2016 due to rash and negligent driving of driver of
gas tanker.
Gas tanker bearing registration number TN 28888255. Due to the accident, claimant has suffered the following injury. He has examined the doctor as PW2. In his evidence, he has deposed that claimant has suffered 15% disability to lower limb. Considering that evidence of doctor and age and avocation of the claimant, I am of the opinion that whole body disabilities has to be assessed 5%. Even though claimant has claimed that he was earning 15,000 per month, he has not produced any document to establish the same.
No, but like they have examined the
Employer examined
employer.
but
That is the reason the disability was not taken. Employer examine ಮಾಡಿ 15,000 ಕೊಡ್ತಿದ್ರು ಅಂತ ಡಾಕ್ಯುಮೆಂಟ್ ಇದನ್ನ ಹಾಕ್ತಾರೆ. ಸಪೋರ್ಟಿಂಗ್ ಡಾಕ್ಯುಮೆಂಟ್ ಏನು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿಲ್ಲ ಅಂತ.
Yes, he has produced the documents. Employer also examined.
ಹೌದು PW3 ಮೇಲೆ.
Yes, he has produced the salary certificate.
Supporting document ಹಾಕಿಲ್ಲ ಅಂತ was rejected.
Examine that employer. He has not produced the bank statement to prove that he is getting 15,000 per month. Therefore, notional income has to be assessed as per the guidelines. For the accident occurred in 2016,
9,000.
the notional income has to be considered as 9,500. At the time of the accident, he was aged about
22 years.
Multiplier applicable is 18. Accordingly, loss of future earning due to disability has been reassessed as follows.
9,500 into 12 into 18 into 5%, 1,02,600.
Due to that accident, claimant has suffered previous injury. He was inpatient for a period of
4 days.
9 days. 9 days. ಡಾಕ್ಟರ್ ಹೇಳಿದ್ದಾರೆ ಇನ್ನೊಂದ್ಸಲ ಎರಡನೇ ಸಲ ಆಪರೇಷನ್ ಅಡ್ಮಿಟ್ ಆಗಿದ್ದಾರೆ.
4 days or 9 days?
9 days ಮೇಲೆ ಡಾಕ್ಟರ್ has stated in
Lot of pain during the treatment.
ಆಮೇಲೆ ಡಾಕ್ಟರ್
Just to
ಇನ್ನೊಂದ್ಸಲ
suffer this disability and unhappiness throughout his
grafting.
life. Considering that evidence of doctor and injury suffered by the claimant, I am inclined to enhance the compensation for pain and suffering from 50,000 to 60,000. Loss of immunities and medical expenses has to be enhanced from 1,08,081 to 1,20,000. The claimant is also entitled for loss of income during the later period for 2 months. In respect of future medical expenses is concerned, due to that accident, claimant has suffered the aforesaid injury. He has undergone surgery. The doctor has deposed that he required 15,000 for removal of implant. Considering that evidence of doctor, injury suffered by the claimant, I am of the opinion that claimant is entitled for 10,000 for future medical expenses. It will not carry any interest. Accordingly, appeal is allowed in part.
Much.
Delay is controlled.
Till number 42, Shripad Shastri for appellant, A.N. Krishnaswamy.
None appear. Leaves this matter after 2 weeks.
My lord, I am for appellant. I am for appellant.
Yes.
My lord, the minor, there is a delay, inordinate delay. But my lord, since claim petition has been dismissed, these records is necessary. My lord, I am requesting my lord to condone the delay. My lord. It's a minor 7 years.
Yes. Have they filed any objection to that?
Illa.
Yes. There is a delay of 2070 days in filing that appeal. Respondent has not filed any objection. Peruse that affidavit. For the reason stated in the accompanying affidavit. Delay of what is the reason you have given, Mr. Shastri, for so many days delay? Fracture right rumors and also other injury, took the treatment inpatient. Dismiss the claim petition ground non-providing that. Age on this minor is doing to file that. I am poor illiterate. I was under the impression that trial court has 81 event. For the reason stated in that accompanying affidavit, delay is condoned in case appellant is succeed, not entitled for the interest for a period of 2070 days. Hard admit.
Serial number 43, Sanat Kumara came for appellant. D.S. Umesh.
Yes.
My lord, I appear for the respondent. Delay may be condoned, my lord. Claim petition is dismissed. Records may be necessary.
LCR may be called for.
186 days delay is condoned. Not entitled for the enhanced compensation amount interest. Hard admit.
Claim petition dismissal. LCR may be.
LCR. Yes. Hard admit.
Serial number 44, Kumara KG for appellant. Connected matter. M.U. Punacha, Ashok N. Patil, Suresh Kumar, H.M.
Yes. Kumar KG. Suresh Kumar Punacha, Paso. Yes, Patil, what is this?
This case, my lord, pay and recover order is made. Pay and recover order is made, my lords, in this case.
ಏನು enhancement ಗೆ ಹಾಕಿದಾರ?
ಹೌದು, enhancement ಗೆ ಹಾಕಿ owner appeal is also there.
Owner appeal is also there.
Yes. 4908 of 2022.
That is Suresh Kumar is for the owner.
Yes.
Where is Kumar KG? Claim it. Pass or?
Pass or.
Yes.
Serial number 45, Prasanna VR for appellant.
Appearing for
Ravish
the
Singh,
appellant.
Jonathan Reddy.
I have filed the application for impleading the LRs of the deceased appellant, my lord.
Appellant is dead.
Appellant.
ವಕಾಲತ್ ಹಾಕಿಲ್ಲ, ಪೇಪರ್ಸ್ ಕೊಟ್ಟಿಲ್ಲ ಇದ್ರಲ್ಲಿ.
ಕೊಡಿ ಒಂದು ಕಾಪಿ ಅವರಿಗೆ.
ಕೊಟ್ಟಿದ್ದೀನಿ.
ಇವ್ರು ಕೊಟ್ಟಿರೋದಂತೆ ನನಗೆ ಗೊತ್ತಿಲ್ಲಮ್ಮ. ಕೊಟ್ಟಿದ್ದು
ಯಾರಿಗೆ?
ಕೊಡ್ತೀನಿ ಸ್ವಾಮಿ, ಇನ್ನೊಂದ್ ಸೆಟ್ ಕೊಡ್ತೀನಿ.
ನ್ಯೂ ಇಂಡಿಯಾದು.
ವಕಾಲತ್ ಕೊಡಿ ಅವರಿಗೆ, ಪೇಪರ್ ಕೊಡಿ ಅವರಿಗೆ.
ಕೊಡ್ತೀನಿ ಸ್ವಾಮಿ.
Learned counsel for the appellant is directed to serve one set of copies on Janardhan Reddy.
ಅಲ್ಲ, impleading application ಹಾಕಿದ್ದೀನಿ. Sole appellant died.
ಅದನ್ನೆಲ್ಲ
LRs.
ಮಾಡಿ ಸರ್.
Yes. IA 1 of 2023 is filed for impleading. The ground that impleading that the impleading applicants are LRs of deceased appellant. Peruse that affidavit for the reason stated in
Death
the
extract is also filed, my lord. Death extract is also filed.
Yes, IA is allowed. The impleading applicants are permitted to come on record as a appellant in this appeal. Counsel for the appellant is permitted to amend the cost rate.
One submission, my lord.
What is this
Regarding-
process and all?
My lord.
Process ಯಾರಿಗೆ ಕೊಡ್ಬೇಕು?
Process ಅಲ್ಲಿ respondent number 2 ಮತ್ತು 5 ಗೆ. Respondent number 2 was the driver of the vehicle of appellant.
ನಿಮ್ದೇ ಡ್ರೈವರ್?
Yes, sir.
You are the owner of the vehicle?
Yes, my lord. The liability is fixed on the appellant.
On what
That was
ground?
told. The driver has no valid license to drive the high HGV, my lord. Then R5 was the owner of the bike, my lord. Offending vehicle.
No, you are challenging on what ground now?
The exhibit R7 was marked before the tribunal that the unladen weight of the vehicle was 6,600.
Yes, you also verify, Mr. Reddy.
ನಂಗೆ ಏನು ಪೇಪರ್ಸ್?
I will, my lord, the notices to the R2 and R5 may kindly be dispensed with. I will file memo with respect to that.
No, if insurance company is disputed, then what will that your
ಪೇಪರ್ಸ್ ಕೊಟ್ಟು ಎಷ್ಟು ಡೇಟ್
The R2 is the driver of.
Yes, yes. Learned counsel for the appellant has filed in a memo seeking dispensation of notice to R2
And
Notice to R2 is dispensed.
R5 who was ex parte before the tribunal.
Who is R5?
R5 was the owner of the offending vehicle, which was driven by the.
Yes. I filed a memo for dispensation of notice to R2 and
R5.
Memo is taken on record. Notice to R2. Already R5 unclaimed ಬಂದಿದೆ ಅಲ್ರಿ.
ಅಲ್ಲ unclaimed ಅಂತೇಳಿ ಬಂದಿದೆ, ಅಲ್ಲಿ ex parte ಆಗಿದ್ದಾರೆ ಅಲ್ಲಿ.
ಬೇಡ
Tribunal
unclaimed
ಅಲ್ಲಿ.
ಇದೆ, ಸರ್ವಿಸ್ ಹೆಲ್ಡ್ ಸಫಿಶಿಯಂಟ್ ಮಾಡ್ಬೋದ್ರಿ ಅಲ್ವಾ?
ಅಲ್ಲ, neither cover nor acknowledgement received ಅಂತೇಳಿ ಇದೆ.
I filed a memo seeking dispensation. Once unclaimed ಬಂದಲ್ಲಿ notice ಹೆಂಗ್ರಿ ಹೋಗುತ್ತೆ? 2 and 5 is dispensed at the risk of the appellant. Counsel for the appellant is directed to serve one set of copies on Janardhan Reddy. Yes, you serve, madam.
Interim order may kindly be extended. I have
Order
deposited.
granted earlier is extended till next date of hearing.
Much.
Serial number 46.
Now that Ravish Bini is for other vehicle.
Yes, sir.
46.
Now who is appearing for the claimant, madam?
Why not?
Claimant ಗೆ ಯಾರು appear ಆಗ್ತಾರೆ?
Claimant ಗೆ notice serve ಆಗಿದೆ, but ಯಾರು represent ಮಾಡಿಲ್ಲ.
That Vinod Kumar is the claimant.
No, Riaz is the claimant, R1.
Or Riaz is served, yes. Yes.
46. Gopal Krishna in for appellant, connected matter.
Milord, I appear for the appellant, in the first case respondent and in the second case appellant.
No, you said delay may be condoned, record may be required.
Yes, Milord, record await ಇದ್ರೆ ಬಂದಿದ್ರೆಗಿನ ಸ್ವಲ್ಪ
ಬಂದಿಲ್ಲ. Not at come. Yes.
2022 ನಲ್ಲಿ ಕಾಲ್ ಫಾರ್ ಮಾಡಿತ್ತು, await records ಅಂತಂದ್ರೆ ಇಲ್ಲ, ಇಶ್ಯೂ ರಿಮೈಂಡರ್ ಅಂತ ಮಾಡಿಸಿ.
ರಿಮೈಂಡರ್ ಕಳಿಸ್ಬೇಕಷ್ಟೇ.
ಇಶ್ಯೂ ರಿಮೈಂಡರ್
ಬಂದಿದೆ. Yet to be called ಅಂತ. ಇನ್ನೊಂದ್ರಲ್ಲಿ ನೋಡಿ ಕನೆಕ್ಟೆಡ್ ಆರ್ಡರ್ ಆಗಿದೆ.
ಕನೆಕ್ಟೆಡ್ ಫಸ್ಟ್ ಕೇಸ್ ಅಲ್ಲಿ ಕರೆದಿದ್ದಾರೆ 5011 of 2019.
No, there is no such order, mister. Yet to be called ಅಂತಿದೆ Mr. Nagaraj.
I am sorry. ನಮ್ ಈ ಕಂಪ್ಯೂಟರ್ ನಲ್ಲಿ ಬೇರೆ ತೋರಿಸ್ತದೆ.
ಇದರಲ್ಲಿ will condone the delay.
ಆಯ್ತು.
Delay of 32 days, condone
302 days.
302 days, yes. In case if it is succeed not entitled for the interest for enhanced compensation amount, office is directed to secure original records from the tribunal. Yes.
Serial number 47.
My lord, I appeal for the appellant, my lord. My lord, the appeal on hand was dismissed for my lord, attending the office objection by 2 advocates, my lord. Now the appellant, my lord, who is a full driver, has engaged me, my lord, and I have filed an application to recall that dismissal order.
Yeah, no, office objection.
ಅದನ್ನ ನಾನು ಮಾಡ್ತೀನಿ ಸ್ವಾಮಿ, ಒಂದು ವಾರದಲ್ಲಿ ಸ್ವಲ್ಪ ರೀಕಾಲ್ ಮಾಡಿ ಕೊಟ್ರೆ.
Pending consideration of IA 1 and 2 of 2024. 2 weeks time is granted to comply office objection.
Yes, my lord, that order may be recalled, my
No,
lord.
it will be pending. Only after you complied, we will recall it.
Oh, grateful, my lord.
We have an experience that after recalling, again they will not comply.
My lord, we want
No,
to.
it is not for you.
Yes.
Again you are dismissing. Again application for recalling. It is recalled. Again they are not complied. Therefore, now we have changed our order saying that first recall, first comply, then we'll recall.
Oblige, my lord.
Yes.
Within 2 weeks.
Yes.
Serial number 48. N. Kumar for petitioner.
Appear for petitioner, my lord. CC, my lord, I filed review petition seeking to review the order dated 1/9/2023. Parting MFA 150/2020, my lord.
For what?
Where, my lord, by dispensing the service of notice to me, my lord, a liability has fallen on me. Kindly see, my lord, at the page number 11, my lord.
This is not our order. Other bench.
Other bench, or illa, my lord. Justice ತಮ್ಮದೇನೆ ಬರುತ್ತೆ, my lord.
Yes, yes.
My lord, kindly see, I put the online order copy, my lord, at page number 77. At the next page, my lord, 78. 78 ಅಲ್ಲಿ order dated 15/3/2020. 78. Third, my lord, order dated 15/3/2022. Learned counsel.
28 is that execution petition.
No, illa, ಅದು ಹಿಂದಿನ page, my lord.
ಹಿಂದಿನ
page.
7. Date of order.
15/7 to 15/3/2022. ಕೆಳಗಡೆ
15/3/2022.
Learned counsel for the appellant, Mr. Lokeshwari HC filed memo seeking dispensation of the notice to respond number 3 to 4. I am the respond number 4. Therein, who are the owners of both the vehicles, whose liability has been fastened on the insurer. In the notice.
Is it true that liability has been fastened on the insurer?
Yes, my lord. Kindly see the order, my lord. Kindly see the order. At the page number 31, my lord. Can I read, my lord? Imprint order, operative position.
No, I'm saying that tribunal order.
But tribunal order is made against me and my insurer, my lord. Say, by fixing a contributing negligence of 30%, my lord. Here the issue is, my lord, only with respect to 30% the contributing
No,
negligence.
what
my
is
lord.
that order of the tribunal?
Kindly see, my lord, tribunal of the order, my lord.
Page 64.
Yes, my lord.
ಏನ್ ಮಾಡಿದ್ದಾರೆ?
ಅದರಲ್ಲಿ
1 and 2 being the
30%.
insurer of the owner of the lorry jointly severally liable to pay that 70%.
Not against me, my lord. But what happened, my lord? The accident against
30% is
against me and me insurer. Next para, my lord. Next para. Respond number 3 and 4 being the owner and insurer of the lorry number AP09TA 1658 in which the petitioner was driving is liable to pay the 30% compensation amount to the petitioner, as the petitioner has also contributed his part of negligence. The fourth respondent is directed to deposit 30% compensation amount within 30 days. Is my insurer, my lord.
no, what is that case of the claimant?
The case of the claimant is, my lord, he said my driver, my lord. Actually, my lord, in the early morning 4:30, my lord, while driving in the highway road, my lord, it dashed against the lorry which was parked in
Because
the
your vehicle.
Well, my vehicle is, my lord,
Lorry.
lorry. Both are lorries, my lord.
No, your employee has filed a compensation.
Yes, my lord. Against the
Against
offending
that
vehicle,
other lorry.
other
The
lorry and
tribunal
the
has given a liability on both
both, my lord, yes.
70 and 30.
70% fixed against the offending lorry and their insurer, and 30% against me and my insurer, my lord.
No, insurance company is there.
Insurance company there, my lord. Can you see, my lord? So far as 30% of contributory negligence is concerned, they preferred an appeal before this honorable court, wherein without
Who has preferred?
Preferred, my lord. Kindly see, my lord, my insurer, my lord.
No, it is preferred by your insurer.
My insurer, my regional manager, New India Assurance Company. He is my insurer. He challenged the 30% of the award ordered by the tribunal against me and my insurer.
No, your insurer has challenged.
Yes, my lord.
That 30% has been
30%,
ordered.
yes. Only
It should be only owner.
Yes, my lord.
On what ground?
Well, the ground is, my lord. Actually, there is no scope for contributing negligence. There is a negligence on the part of the driver of the vehicle. On that ground, my lord, they filed the appeal, my lord, wherein without hearing me, my lord, well, the facts is, my lord.
No. See, your insurer has filed an appeal.
Yes, my lord.
Your insurer has filed an appeal on what ground? He is saying that policy is not applicable.
No, my policy is there. Everything is admitted, my lord.
Saying that
The negligence on the part of the driver.
other vehicle.
Yes, the other vehicle.
His cycle, it is not 70, 100% is on that
No,
other lorry.
they're questioning only 30%, my lord. Then
No, he is saying
so far as
that.
70% is concerned, my lord.
No, he is saying that 30% liability fastened on that other lorry is wrong. It should be 100% on that other vehicle.
Yes, my lord.
That is his case.
No,
Now
no,
that-
my lord, that's not the contention, my lord. The contention is, my lord, there is a negligence on the part of the driver of the lorry, which was driven by the driver, my lord. So I am not entitled to pay 30%. Only the owner and the driver of the offending lorry, have to be pay 30%. That is their contention, my lord.
No, on
Where-
what ground, mister?
No,
Insurance policy is that.
Well, that is the, my lord. That is the case, my lord.
No. How can he challenge that his insured is not, see, he can challenge only policy is not applicable.
No, my policy is admitted, my lord. Policy is admitted. We have a valid license, my lord, driving license.
What is the finding of this court?
The finding of this court, my lord, kindly see, my lord.
Anyhow, that the notice has to go.
Notice has to go.
Why then they have dispensed you then?
Maybe by oversight, my lord, I don't know.
No, but
My lord, without
relief is
hearing me-
against you when they are
That's
sought.
what, my lord. My lord, only I came to know that order after getting the notice from the execution court, my lord, where they filed execution petition against me.
Heard. Issue notice.
No, submission, my lord, here.
What is that stay you are seeking for?
Seeking, my lord, the stay of the execution proceedings, my lord.
Stay of execution ಯಾಕೆ ಮಾಡ್ತೀರಾ? ನಿಮ್ದು ಮಾತ್ರ ಮಾಡಿಸ್ಕೊಳ್ಳಿ 30%.
ಅಲ್ಲ 30% ನನ್ ಮೇಲೆ ಮಾಡ 30% my lord. ಅವ್ರ execution ಹಾಕಿರೋದು 30% ಗೆನೆ.
ನಿಮ್ದಕ್ ಮಾತ್ರನಾ?
Yes.
Yes, stay of further proceedings in execution petition number.
It's petition number, my lord. 18/2023.
18 of 2023, pending in the file of senior civil judge JMFC, Chamani till next date of hearing.
One more submission, my lord.
That Ravi Shankar will take notice for,
Yes, I will serve copy, my lord.
no, whoever that will take notice will.
The only contesting respondent is, my lord, the insurance company, respondent number 1 only, my lord. Other respondents may be dispensed with the service of
ಅಲ್ರಿ
notice.
ಇದ್ರಲ್ಲಿ ಮತ್ತೆ ಈ ಬೇರೆ ತರ ಆಡ್
ಆಮೇಲೆ ಇದನ್ನ 70% ಕಂಪ್ಲೇಂಟ್ ಮಾಡಿದ್ದಾರೆ already. So for 70% is concerned, they complained already. This is only with
regional
respect
manager, New India Insurance Company ಯಾರು ಅಪಿಯರ್ ಆಗ್ತಾರೆ?
A. Ravishankar, my lord.
A. Ravishankar.
He only appeared in that.
Yes, A. Ravishankar is directed to take notice for respondent number 1. 2-3 ಯಾರು ಅಪಿಯರ್ ಆಗಿದ್ರು ಅಲ್ಲಿ?
2-3 not required, my lord.
ಆಯ್ತ್ರಿ, ಯಾರು ಇದ್ರು ಹೇಳ್ರಿ. ವಕೀಲರು ಅವ್ರು 2-3 ಬೇಡ ಬಿಡಿ.
ಅಲ್ಲ 2-3-4
ಓರಿಯೆಂಟಲ್ ಇನ್ಶೂರೆನ್ಸ್ ಯಾರು ಅಪಿಯರ್ ಆಗಿದ್ರು ಅಲ್ಲಿ?
2-3-4 ಗೆಲ್ಲ ಬೇಕಾಗಿಲ್ಲ, my lord, and my view, because dispute is only with respect to payment of.
ನನಗೆ ಗೊತ್ತಾಯ್ತ್ರಿ, who is appearing for respondent number 2
Respondent number 3, my lord. Respondent number 3 also dispensed, my lord, therein.
Respondent number 3 dispense ಮಾಡ್ಬಿಟ್ಟಿದಾರಾ?
ಅಲ್ಲೂ ಮಾಡಿದ್ದಾರೆ, ಹೌದು.
ಆಯ್ತು, ಓರಿಯೆಂಟಲ್ ಇನ್ಶೂರೆನ್ಸ್ ಕಂಪನಿ ಯಾರಿಗಾರ ಕೊಡೋಣ ಹೇಳಿ. ಯಾರಿದ್ದಾರೆ ಓರಿಯೆಂಟಲ್ ಇನ್ಶೂರೆನ್ಸ್?
R2. R2, my lord, Sudhakar Reddy.
You are there, Mr. Ravi.
K. Sridhara, my lord. K. Sridhara. K. Sridhara, advocate for R2.
ಹಾಕಿದಾರ ಅದರಲ್ಲಿ?
ಹಾಕಿದ್ದಾರೆ.
ಅದೇ K. Sridhar is directed to take notice for R2. Counsel for the petitioner has filed in a memo. Appellant, petitioner has filed in a memo for dispensation of notice to
Respondent number 3 and 4.
respondent number 2 go.
Sorry, my lord. Respondent number 2 and 4.
2 and 4. Notice to 2 and 4 is dispensed. Serve ಮಾಡಿ. But now that execution is stayed in respect of that claimants, Mr. Notice has to go to them because their execution.
No, my lord.
Yes, their execution is stayed. Yes. Dispense ಬೇಡ. ಒಂದು ರವಿಗೆ, ಇನ್ನೊಂದು ಕೆ ಶ್ರೀಧರ್ಗೆ. ಕೆ ಶ್ರೀಧರ್ for R3, Ravi for R1. Directed to serve one set of copies. Issue emergent notice to 2 and 4. Stay of further proceedings of execution till next date of hearing.
Number 49, Abhinag as per petitioner.
Respondent number granted my amendment application on the last date of hearing, my lords. I have sought to include a prayer regarding the Amendment Act. I've placed my amended petition.
Yes. At the request of counsel for the parties, leaves this matter after 2 weeks.
State may also have to file the objection, my lord, because the constitutional validity of the amended provision of the.
ಆಯ್ತು, ಅದು ಬೇರೆ ಕೇಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕಿ
For the-
that matter is going on in before
Please.
the other bench.
For the court,
Yes.
the interim order may kindly be extended.
Interim order granted earlier is extended till next date of hearing.
Great.
The date may be fixed, my lord.
That matter has to be decided, Mr. It is before that other bench. Constitutional validity matter is pending. Yes.
Please.
Yes.
B group matter, serial number 50, Shruti Changati for.
Yes, for the petitioner, my lord, this is a PTCL matter, but I may make one submission, my lord. If my lord would see page number 9, the grant is in form number 1, which is very clearly a sale, my lord, and there is may I be permitted to pass on a judgment of the Honorable Supreme Court.
Where is
which
that forum number?
One, it's at page 9, my lord, which clearly shows that it is an outright sale.
ಎಲ್ಲಿದೆ outright sale?
My lord would see the first paragraph. It says, ಹಿಡುವಳಿಯಲ್ಲಿ ಇದ್ದ ಸರ್ಕಾರಿ ಜಮೀನನ್ನು ಸಾಗುವಳಿಗೆ ವಿಲೇವಾರಿ ಮಾಡಿ ಹಿಡುವಳಿ ಹಕ್ಕನ್ನು ಕೊಡುವುದಕ್ಕೆ ಏರ್ಪಟ್ಟ ನಿಬಂಧನೆಗ ಮೇರೆಗೆ ಈ ಕೆಳಗೆ ಬರೆಯಲ್ಪಟ್ಟಿರುವ ಶೆಡ್ಯೂಲಿನ ವಿವರಿಸಲ್ಪಟ್ಟಿರುವ ಜಮೀನು ವಿಕ್ರಯಿಸಲ್ಪಟ್ಟು ಎಕೆ ನರಸಿಂಹ ಎಂಬುವವರು ಬಹಿರಂಗವಾದ ಹರಾಜಿನಲ್ಲಿ ಕೊಂಡುಕೊಂಡು ಇರುವುದರಿಂದಲೂ ಮತ್ತು ಸದರಿ
ಹರಾಜಿನಲ್ಲಿ
ಕೊಂಡುಕೊಂಡು that has been cut off ಅಥವಾ ನಿಯನ್ whatever, my lord, and then it says ಕೊಂಡುಕೊಂಡಿರುವ.
We'll get that original records from that whether that ಸರ್ಕಾರಿ ಕಿಮ್ಮತ್ತಿಗೆ ಅನ್ನೋದನ್ನ it was strike off.
My lord would read, if I'm permitted to read further, my lord, it says ಮತ್ತು ಸದರಿ ಹರಾಜು ಕ್ರಮವಾಗಿ ಮಂಜೂರ.
No, what you are saying is correct, madam.
My lord.
These are all printed form.
My lord.
Wherever required, they will put in a striking of that word.
No doubt, my lord, but it says
Now-
upset price of 22 rupees 8 paise. It has been sold, and the judgment that I've just passed across the bar, my lord, the Honorable Supreme Court has interpreted in a 1948 Form 1
Yes.
to say that very clearly that it is an outright sale, and therefore the provisions of the PTCL Act are not attracted to the
No,
case
if
at
it
hand.
is a sale,
My lord,
it is not applicable.
my lord, but Form
We
1.
have to find out from the original records whether that grantee has purchased by public action or it is granted by the government.
No doubt,
If
my
it
lord,
is
but
granted by the government, even 22 rupees he has paid. If it is reduced market value, then this
My lord,
court said
actually,
it has to be considered as an upset price.
I submit myself.
Now,
my lord.
what is the finding of the AC and DC?
My lord, they have wrongly applied a rule that was in force in 1938, and they have assumed that there is a proscription for against non-alienation forever, and they have resumed and restored the.
No,
they have
I would taken this contention that this is not a granted land.
My lord, my only submission is if my lord would only see the judgment that I've passed across the
No,
bar.
I'm asking you,
Yes.
have you taken this contention before the DC that this is not a granted land? Therefore, act is not applicable. Have
My
you
lord,
taken?
I have in fact pleaded in the writ petition that I was not.
No, I am asking
My
before
lord.
the deputy commissioner, have you taken?
My lord, may I just.
On the other hand, you have admitted that it is granted land.
My lord, my only submission is this: the proceedings before the AC occur without notice to me. I have not participated in those proceedings. So thereafter, when I discover that such an order has been passed against me, I approach the DC and seek for setting aside of the order on the ground that I'm the absolute owner of the land in question. Now, my lord would see the grant is of the year 1948. In 1950, the first sale occurs. I am a subsequent purchaser. They initiated proceedings before the AC in the year 2005. That is 55 years after the sale. Now, form number 1, the Honorable Supreme Court has held, because the grant certificate is the certificate is in form number 1. The Honorable Supreme Court has held that form number 1 amounts to a title deed. I may just be permitted to take my lord to the relevant paragraph, which is at, my lord would see on page 456, internal page 456 at placetum A.
Yes.
Just above paragraph 20. Says
Yes.
form 1 also indicates that the land in question was purchased and what was paid by the purchaser under the said document was the purchase price.
No, this is one of the proof to say that this is a purchase.
No doubt, my lord, but
Now,
my lord would
form
see-
number 1 is prescribed for sale.
No, my lord, form number 1 is a title certificate, title grant, my lord. My lord would see other grant
Here
certificates
that we have to see
are not
form
issued in
number
form number 1.
Title 1.
I may also be permitted
According
to.
to the appellant certificate of grant, perusal of the class therein clearly shows that land was sold in the public action and Muttappa purchased the same for the price of so and so. Sent to the digital Telecast register extract produced annexure C before the High Court show that land in question was sold for. No, there are so many documents it is produced to prove that Telecast certificate that it is in a register extract produced.
My lord, the
accepting High
Saguvali
Court
chit.
that land in question is sold for.
My lord, the Saguvali chit that has been produced is form number 1. That's what the Supreme Court is referring to.
Supreme Court is not said just because it is form number 1, it is purchased.
My lord would
They
only,
said
I may just be
in the
permitted.
form number 1, it is shown that it is a purchase. In addition to that, annexure C before the High Court, that is Telecast register. There also it is shows that it is purchased. Therefore, court come to the conclusion that this is a purchase, not a grant.
My lord.
Yes, you secure that
Serial
record.
number 9, page 19, my lord, in DC order, it clearly says whether it is a market rate or not. Not coming out.
If it is in a grant,
It's a
then
grant.
question of market rate or reduced, it's different. If it is an action sale, then question of applying that act would not arise us.
Correct.
Now, only on the basis of the forum you cannot decide. In the case of the Supreme Court, see that what is that called?
Telecast register extract.
Telecast register is also shows that it is action purchase. Therefore, Supreme Court said, Act is not applicable. In this, you get in a record,
I will read.
see that whether it is in a grant or in a purchase. If it is in a purchase, then Act
Whether
cannot be
it is a
applied.
market value or not. that
Yes.
is it.
No, action purchase and bandaga market
Action
value.
ಬರಲ್ಲ.
It
ಇಲ್ಲ,
is not
ಇಲ್ಲಿ
you have granted.
is a
Yes. We'll see that secure records.
Stays in my favor.
Yes, we'll continue that. Government advocate is directed to secure original records. Interim order granted earlier is extended till next year.
Serial number 51 adjourned, serial number 52, chair EAV for a petitioner. Kalyan R.
This is the matter where your lordships on last occasion directed the state to secure the records to ascertain whether it is a granted, land granted and a grower food or general scheme, my lords.
Yes.
List is to be
Lord,
prepared by the other side, governments. List has to be prepared by the governments. That has been
Yes,
directed.
Mr. Where is your?
Maybe taken next week, my lord, I will secure the record and.
Matter has come from the long periods. There, the matter has not been concluding.
Yes, next week.
Next week.
Yes. Government advocate, at the request of government advocate, leads this matter next week.
Interim matters may be in all
Interim
matters.
order granted earlier is extended till next date of hearing.
Submission in 52.5L, but since it was Romore Food Scheme, my lord, several matters were clubbed together. That's it. That is the only point. That's it. The matters, please, my lord, has to be dealt individually is my submission.
On what ground you are seeking for separation of that matter?
Allah, parties are different. Survey number tracks are different.
See,
Only
thing
on the
is,
ground that
if you succeed on the ground that it is by Gromor food scheme, then writ petition has to be allowed. Otherwise, each case has to be decided separate. That's
No. Not like my contention is, my lord, it is not under grant under a Romore Food Scheme anta nandu. But it has to be decided anta, that is what
No,
the court
see,
events, my lord.
First thing is that they are relying on that this court judgment and all.
Please.
Gromor food scheme act is not applicable. But there is a full bench judgment of this court. They said Gromor food scheme act is not applicable. But that has been reversed by the Supreme Court. None of this judgment of the division bench of this court has considered.
Consider that.
If it is a Gromor food scheme also, act is applicable, Supreme Court has said. Nobody has brought to the notice of the court, even before the division bench.
It is attained finality. Supreme Court also it is.
No, attain finality without.
No, bringing it to the notice, correct. I do.
Supreme Court, which I am referring, their detailed order has been passed that under order 41 rule, if the grant is under rule 43J, also act is applicable. That has not been noticed by any other judgment.
That 52.1 million.
Also in 53.2, we also taken the same grounds.
52.1 million, it
Thing
is
is that
granted
before
land.
division bench or single judge, either the government advocate, not that grantees has brought to the notice of this.
In that case.
One more thing is that division bench judgment has been confirmed by the Supreme Court.
Yes.
But in confirmation order, there is no detail order.
No, only it is dismissed. Special leave is dismissed.
Earlier judgment of the Supreme Court is not brought to the notice. Therefore, that judgment still holds on the field.
That 52.1 million is the oldest matter. It has been dealt by individually.
52.1.
Ask.
I thought he has to secure that records. Now,
Separate matter oldest.
who is appearing for that petitioner in that 52.1?
I am but respondent 3 and 4.
Elladku records bekala. First we'll see that. Then one more points, all that grantees are, the purchaser are relying, the delay.
Delay is there.
Yes.
If he fails in this, he is relying on that. Therefore,
My lord,
ultimately,
my approach to the IAC is in time, my lord.
Hearing the matters on the constitutional validity, if it is not, it is quite interlinked.
now that
My lord, in my
therefore we have
matter,
to wait for the decision of that.
in my matter, my lord, concurrent findings of both.
No, but point of law is there.
You know,
If constitutional validity, that writ petition is allowed. If delay is not, delay is the criteria in view of that, then we have
you have a latest, amended act.
amendment ne challenge ಮಾಡಿದ್ದಾರೆ ಈಗ.
Amendment ne challenge
ಅದು
ಮಾಡಿದ್ದಾರೆ.
ಬೇರೆ ನಡೀತಾ ಇದೆ ಸ್ವಾಮಿ. ಅದನ್ನ 50-60 ಕೇಸ್ ಕ್ಲಬ್ ಮಾಡಿ
ಅದರಲ್ಲಿ ಡಿಸಿಷನ್ ಆದ್ರೆ then I can decide all these matters.
Date may fix.
Yes.
ಅದಕ್ಕೆ
ಯಾವತ್ತಿಗಿದೆ ಅದು?
ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಬೇಡ ಸ್ವಾಮಿ. ಆಫ್ಟರ್
Gromer food is the
First week carbon revolution.
ಇದು ಕಾನ್ಸ್ಟಿಟ್ಯೂಷನಲ್ ವ್ಯಾಲಿಡಿಟಿ ಮ್ಯಾಟರ್ ಯಾವತ್ತಿಗಿದೆ?
21st ಗೆ
21st ಇದೆಯಾ? ಆದ್ರೂ ಏನ್ ಬೈ ದಿಸ್ ಎಂಡ್ ಆಫ್ ದಟ್
ಆಗಲ್ಲ, ಅದು ರಿಸರ್ವ್ ಆಗತ್ತೆ ಅವಾಗಾದ್ರೂ ಅಷ್ಟೇ.
ಲೀಸ್ ದಿಸ್ ಮ್ಯಾಟರ್ ಇನ್ ಥರ್ಡ್ ವೀಕ್ ಆಫ್ October.
Entry matters granted.
Granted early
Yes,
is
ma'am.
extended till next date of it.
Much obliged.
Yes. Yes.
Serial number 21, password activity taken up on Monday, inform Shastri.
21, who is there? Shastrina?
Today,
ಯಾವತ್ ಬೇಕು? Next week? Yes, Monday.
Court of sir. Court of sir.
ಹೇಳಿ ಸರ್.
Serial number 50. 5 ಇದೆಯಾ?
28.
55. ಗುರುದೇವ್ ಪ್ರಸಾದ್ ಅವ್ರದ್ದು.
ಇದೆ ಸರ್, ಇದೆ.
ಓಕೆ. ಆಮೇಲೆ ಸೀರಿಯಲ್ ನಂಬರ್ 32 and 33 ಏನಾಯ್ತು? 32 ಏನಾಯ್ತು? 33 ಏನಾಯ್ತು?
32 ಅಡ್ಮಿಟ್ ಆಯ್ತು.
ಅಡ್ಮಿಟ್. 33
ಪಾಸ್ ಓವರ್.
ಅವ್ರ ಯಾರ ಬಂದಿರೋ ಅವರು ಇದ್ರಲ್ಲ, ಅವ್ರ ಕೊಲಿಗ್ ಇದ್ರು.
ಇದ್ದಾರೆ.
28.
ಸರಿ ರೆಡಿ.
ಯಾವ್ದಕ್ಕೆ? ಇಲ್ಲ. ಎಲ್ಲ ಸಮ ಮಾಡಿದೀವಿ. ಮೇಡಮ್ಗೆ 2 ಕಡಿಮೆ. ಬಂದೆ. 28. ಯಾರು?
ಇದು ಇನ್ನೊಂದು 86, 76, 31, 30. ಅಲ್ಲ ಅದು ತಂದಿದ್ರು.
57.
ಹಾ 5. ಹಾ. ಹಾ. ಸೆಕೆಂಡ್ ಇದು ಸೆಕೆಂಡ್ ಮುಗಿದ್ಮೇಲೆ ಫಸ್ಟ್ ಬರುತ್ತೆ. ಎರಡು ಇರ್ತದೆ ಪ್ರೋಟೀನ್.
ಅವ್ರು ಮೇಡಮ್ಗೆ ಜಾಸ್ತಿ ಆಗುತ್ತಂತೆ 15-20 ದಿವಸದ ಹಂಗೆ ಮಾಡ್ಕೊಂಡು ತಿರ್ಗಾ ಎಲ್ಲ
ಸಾಹೇಬ್ರೆ
ಸರ್
ಒಂದು 52 ಇದೆ.
52 ಸರ್.
ಪಾಸ್ ಆಯ್ತು.
52. 52.
ವಿಜಯ್ ಶೇಖರ್ ಯಾವತ್ತಿಗೆ ವಿಜಯ್ ಶೇಖರ ಗೌಡ R3 ಯಾವತ್ತಿಗೆ 3rd week of October.
ಎಲ್ಲ Final hearing matter, serial number 53, Ashok and Patil for appellant. Connected matter, KT Gurudeva Prasad.
Yes, Patil.
Ready?
Yes, sir.
Yes.
Two appeals are filed by the insurer seeking reduction of
Now that,
compensation.
you have filed an appeal and you are also filed.
Objections are there. Both the appeals.
Both. Yes, Mr. On what ground you are challenging only quantum or?
Only quantum, only quantum.
Yes.
But I have raised two grounds.
Now that there are 1, 2, ಎರಡೇ ಅಲ್ವಾ?
ಹೌದು.
That's
The deceased was a MBBS student.
ಯಾವ್ದ್ರಲ್ಲಿ first?
1586 of 2018, arising out of MVC.
2493.
2493 minutes.
2493.
The parents and the
Class objection 109 of 21.
Class objection 109?
109 of 21.
Yes. Now that start from which page?
19, para 19.
19. Yes. Yes, now.
The only ground, the two grounds are that the deceased was an MBBS student, and the tribunal has taken the income at rupees 15,000. And the interest is awarded at 8%. These are the only two grounds we have urged.
You have taken.
Yes,
Income MBBS student.
yes.
Final year MBBS.
15,000. Interest 8%.
Interest is at 8%. Yes.
Yes. Now that you have to argue, Mr.
Court has considered only 15,000 rupees the income.
Yes.
Even a Supreme Court judgment for MBBS student 25,000 rupees.
Yes. What is the date of the accident?
Date of accident?
12/3/16.
12/3/2016. Yes, madam.
Supreme Court judgment, date of accident? Date of accident, copy ಮಾಡಿಟ್ಟಿದ್ದು ಬೇರೆ file ಅಲ್ಲಿ ಇತ್ತು. 2022, volume 6, SCC 206. ನೋಡ್ರಿ ಅದು. ಮಂಜಮ್ಮ and others versus.
Page number, sir.
Out of his 1 month income, he has to deduct 50% deduction correct ಇದೆ.
ಹೌದು ಸರ್.
ಬಾಕಿದ್ದು future prospects ಕೊಟ್ಟಿದ್ದಾರಾ?
ಕೊಟ್ಟಿದ್ದಾರೆ. They have awarded 40% is taken. Yes.
Then only that dispute regarding that income.
Income and the interest. These two.
No, in your, on what ground you are challenging, Mr. Gurudev Prasad?
ಅದಂದೆ income ಒಂದು.
Income ಒಂದು ಅಲ್ಲ ಬಾಕಿದ್ದೆಲ್ಲ ಕೊಟ್ಟಿದ್ದಾರೆ.
ಬಾಕಿದೆಲ್ಲ ಕೊಟ್ಟಿದ್ದಾರೆ.
15 ಇದೊಂದು ಕೊಟ್ಟಿಲ್ಲ ಅಂತ ಕಾಣಿಸುತ್ತೆ.
Future prospects
ಕೊಟ್ಟಿದ್ದಾರಾ?
ಇಲ್ಲ ಮಾಡಿಲ್ಲ.
Future prospects is not added, Mr. Patil.
ಮಾಡಿಲ್ಲ.
That is liable to be added.
Yes, 40%.
Yes.
ಇದರಲ್ಲಿ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಜಡ್ಜ್ಮೆಂಟ್ ಒಂದು ರೆಫರ್ ಮಾಡಿದ್ದಾರೆ.
Fixed 30,000.
30,000.
MBBS student claimants mother is aged 45 years, 19 years MBBS student.
ಹೌದು.
The High Court fixed the salary of 12,000, taking into the consideration deceased as doctor who has deceased as a doctor otherly would have earned sufficient. Consider into the deceased income by following that down mentioned facts and circumstances of case. I have taken that 15,000 per month.
ಜಡ್ಜ್ಮೆಂಟ್ ರೆಫರ್ ಮಾಡಿದ್ದಾರೆ in page 20 ನಲ್ಲಿ.
ನೀವು ಅದೇ ಜಡ್ಜ್ಮೆಂಟ್ ಹೇಳಿದ್ದ 2016.
ಇದರಲ್ಲಿ 30,000 ಮಾಡಿದ್ದಾರೆ.
Yes.
Page 20, internal page 20.
Yes.
But for for of course, I am relying on a judgment where he was he was pursuing BE in third year, where the Honorable Supreme Court has granted, has taken 10,000 the income.
Then what is the date of the accident?
Please, I'll pass on the copy of.
Engineering student 15,000 ನಮ್ಮರಲ್ಲಿ ಇಲ್ಲೇ ತಗೊಂಡಂಗಿರ್ಬೇಕು. ನಮ್ಮ ಹೈಕೋರ್ಟ್ದಲ್ಲೇ ಡಿವಿಷನ್ ಬೆಂಚ್.
This was in the year 2012. The accident was in the year 2012.
ಈ ಕೇಸಲ್ಲಿ?
This case is arising out of 2016.
16. ಇದು 12.
ಹೌದು.
Claiming 25 lakhs, so and so 8,000 per month. The tribunal assessed 15,000 per month. One of national cause 8,000 deceased per month from.
It was reduced to 5,000, my lord. The Honorable Apex Court in paragraph number 8, continuing on page 8. Page 8, my lords. Therefore, looking into the educational qualification and family background, and as observed here in above, the deceased was having a bright future studying third year civil engineering, we are of the opinion that the income of the deceased at least ought to have been considered at least as rupees 10,000 per month, more particularly considering the fact that the skilled laborers were getting 5,000 per month even under Minimum Wage Act 2012. But if I may read, my lords, the para 8 minutes from the beginning, so that my lords, at the outset, it is required to be noted that deceased at the time of accident was 21, 22 years age, and that he was third year student in civil engineering. Therefore, can be said that looking to his educational qualification, he was having a bright future. Learned tribunal assessed the income of deceased at rupees 15,000 per month for the purpose of awarding compensation and their future economic loss. However, the impugned judgment and order, the High Court has reduced the compensation and determined the income of the deceased at rupees 5,000 per month, awarding the future economic loss to the claimants, considering the income of the deceased as rupees 5,000 is not sustainable at all. Even the skilled laborers were getting rupees 5,000 per month under the Minimum Wage Act. In the year 2012, as the deceased was studying third/fourth semester civil engineering, cannot be considered worse than the skilled laborers. Even the council appearing on behalf of the Union of India has fairly considered that assessing the income of the deceased at rupees 5,000 per month for the purpose of awarding the compensation under the head of future economic loss can be said to be at lower side, and as such is not justifiable. While awarding the future economic loss when the deceased died at the young age of 21, 22 years.
Engineer 2012 10 now we are for engineering we are considering 5. It is 2016 igala.
Yes, ma'am.
Now that is there any case related to that MBBS students?
It's MBBS,
that case you are referring that.
Internal page 20.
It depends, on how his family, as well as whether he is a meritorious student or he is been a
Serial number 3.
Page number?
Internal page 20.
20, yes.
Serial number 3. Other 2014 AC is 2690. Totally 19 years, first year MBBS.
50 years taking into the consideration the deceased as a doctor would have been earned
Minimum sum of rupees 30,000
per month. Deducted 50% to the personal expenses. Yes.
After discussing all that, the tribunal at page paragraph 25, issue number 3.
ಅವರು ಅದರಲ್ಲಿ ಹೈಕೋರ್ಟ್ 12,000 ಕೊಟ್ಟಿದ್ದಾರೆ. ನಾವು 15 ಕೊಡ್ತೀವಿ ಅಂತ ಹೇಳಿದಾರೆ ಅಷ್ಟೇ. Why that he has reduced, why he has not considered Supreme Court fixing 30,000 ಅಂತ ರೀಸನ್ ಇಲ್ಲ. ಇದ್ಯಾವುದಿದೆ?
Page 23 ನಲ್ಲಿ ಇಂಜಿನಿಯರ್ ಸ್ಟೂಡೆಂಟ್ ಗೆ 20,000 ಕೊಟ್ಟಿದ್ದಾರೆ.
Considering the fact that the accident occurred in 2016, your lordship may kindly take at 18,000 rupees.
2012 ಗೆ deceased tribunal taking into the consideration of deceased doctor would have been earned minimum of 30,000. Fix that 50%. 2012 ಗೆ 50 month. At least we have to take 20. We'll make it 20,000. Yes.
But the other ground is
30. What is that judgment you are referring?
The other ground is the interest is awarded at 8%.
Interest you have to reduce.
Please. Only 2 grounds.
Future prospects is not given.
That may be added.
What about that second case, Mr.?
Same, it is also MBBS.
Doctor.
He is in second year, MBBS studying in second year.
ಅದರಲ್ಲೂ 15 ತಾಂಡಿದಾರಾ?
ಹೌದು 15. It is also same
yes,
income is adopted.
Conventional
that will recalculate. So learned counsel appearing for insurance company has contended that at the time of the accident, deceased were studying in MBBS. They are the students. They are non-earning members of the family. Even Apex Code in Civil Appeal number 6724 of 2021 disposed of on 18th November 2021 in case of engineering students for the accident occur in the year 2012 has considered 10,000. Therefore, the monthly income of the deceased assessed by the tribunal 15,000 is on higher side. Secondly, he has contended that considering that age, secondly, he has considered that in view of judgment of this court, interest awarded by the tribunal 8% is on higher side. Hence, he sought for allowing that appeal filed by the insurance company by dismissing the appeal filed by the claimant. Shri Gurudev Prasad, learned counsel appearing for claimant, has contended that at the time of the accident, both the cases deceased were a student studying in MBBS. In Apex Court, we are going to do. No. Huh? Similar circumstances has considered the income of the deceased as 30,000. 2014 ACJ 2693. In tribunal also, number of Supreme Court judgment has been referred. Ide 2014 adane raka itara markad. In the similar circumstances, Apex Court has considered monthly income of the deceased was 30,000. Supreme Court has also referred that Apex Court judgment has the tribunal has considered that Apex Court judgment without giving any notice, without giving any reason. They have assessed only 15,000 per month. Secondly, he has contended that in view of judgment of Apex Court in case of Magma, the Pranay Sethi, claimants are entitled 40% of the income of the deceased for future prospects. Lastly, he has contended that in view of judgment of Apex Court in case of Magma, the claimants are entitled 40,000 each. Heard the learned counsel for the parties peruse judgment and award. Ashwin Kumar and Madan died in road traffic accident occurred on 12/3/2016 due to rash and negligent driving of driver of car bearing registration number KA Kara KA 13 M9919 Adatwa Ala KA 04 MM 5043. Both of them were studying in MBBS at the time of the accident. Considering that judgment of Apex Court, which is relied on by the tribunal, and considering that economical background of the family of the claimants, family of the deceased, and their academic qualification, I am of the opinion that monthly income of the deceased can be assessed as 20,000 per month. In MVC 493 of 2016, the deceased was aged about 22 years. In view of judgment of Apex Court in case of Pranay Sethi, 40% of the income of the deceased has to be added for future prospects. He is a bachelor, 50% has to be deducted for personal expenses. The multiplier applicable to that age group is 18. Accordingly, loss of dependency has been reassessed as follows.
20,000 plus 8,000 at the rate of 40%, 28,000 minus 14,000 at the rate of 50%, 14,000. 14,000 into 12 into 18, 30 lakhs, 24,000.
In addition, 15,000 for loss of estate, 15,000 for funeral expenses. In view of judgment of apex court in case of Magma, who are the claimants, Mr. Ranna? ಮೂರ್ ಜನ ಇದಾರಲ್ಲ, ಬ್ರದರ್ ಒಬ್ಬ ಇರ್ಬೇಕನ. 2493
2493 ನಲ್ಲಿ ಇಬ್ರೇನೆ
2493 22 years 2493 ಮೂರ್ ಜನ ಇದಾರಲ್ಲ 2493 ಅಲ್ಲಿ.
Akash Kumar,
ಆಕಾಶ್ ಕುಮಾರ್ ಮೇ ಬಿ ಬ್ರದರ್ ಏನಪ್ಪಲ್ಲ.
brother,
Yes.
He's son of
Climate-
my lords, the Hemant Kumar. Our
Claimant number 1 and 2 are entitled 40,000 each for Filial Consortium. In MVC 2494 of 2016, what was his age?
23 years.
Deceased was aged about 23 years. In view of judgment of apex court in case of Pranay Sethi, 40% has to be added for future prospects. Since he is a bachelor, 50% has to be deducted for personal expenses. Idrallo 18 alla. Multiplier applicable to that is 18. Same barattalla.
Oh, same.
In addition, 15,000 for loss of estate, 15,000 for funeral expenses. Idrallo yaru claimants?
But it's parents and the other siblings.
Medical expenses 1,70,000.
Medical expenses is retained.
1,70,000.
Idrallo parents 1 and 2 are entitled 40,000 each.
Minor
In
sister.
view of judgment of this court, the interest has to be scaled down to 6% from 8%. Accordingly, the appeals are disposed of. Judgment and award passed by the tribunal is modified as follows.
Amount in deposit may be transferred.
ಯಾವ್ದ್ರಲ್ಲಿ? Cross objection delay ಇದೆಯಾ? ಕೊಡಿ.
My appeal is in 2018.
Delay is there.
ಅಡ್ಮಿಟ್ ಆಗಿರ್ಲಿಲ್ಲ ಅವ್ರು.
Non-filing of an IA for continuation of delay along with that. Now, when you have filed?
2011-2020.
22. ನೀವು ಫೈಲ್ ಮಾಡಿರೋದು? ಹೆಂಗಿದು? ಹೆಂಗಿದೆ ಇದು? ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಇರ್ಲಿಲ್ವಾ?
ಅಲ್ಲ ಇದರಲ್ಲಿ
ಎಂತದ್ದು?
ಅಬ್ಜೆಕ್ಷನ್ ಅಲ್ಲಿ ಹೇಳಿದೀವಿ. Insurance company filed appeal in MFA so and so before this honorable court and the appeal is not yet been admitted by this honorable
ಯಾವತ್ತು
court.
ಅಡ್ಮಿಟ್ ಆಗಿದೆ? 18 ಅಲ್ಲೇ ಅಡ್ಮಿಟ್ ಆಗಿದೆ ಅಂತ. ಎಲ್ಲಿದೆ ಅಡ್ಮಿಟೆಡ್? ಯಾವ್ದು ಇದಲ್ಲ ಒರಿಜಿನಲ್ MFA.
Admit ಆಗಿದೆ. Notice served on 3/11/3/18.
Notice when you have received?
11/3/18.
Issue notice to that admit, issue notice to the respondent 18. When you have received that notice?
11/3/18.
11/3?
18.
You have filed it in?
Filed it in on 20/11/20.
Then the delay ಇದೆಯಲ್ಲ.
ಅಲ್ಲ ಅದ್ ನಾನು ಅಡ್ಮಿಟ್ ಆಗಿಲ್ಲ ಅಂತ ಮಾಡ್ಕೊಂಡಿದ್ದೆ.
ಹೌದೌದು. Now office is also not raised an objection. 708 days delay. Yes. The claimants are not entitled for interest for a period of 708 days for enhanced compensation of this. ಆಯ್ತು, ಇದು ಆರ್ಡರ್ ಮುಗಿಸಿ. ನಿಮ್ಮ ಆಫೀಸ್ ಮಾಡಿರೋ ತಪ್ಪಿಗೆ ಎಲ್ಲವೂ ಮತ್ತೆ ಅವ್ರಿಗೆ ಅಯ್ಯ ಹಾಕಿ ಮತ್ತೆ ಆರ್ಡರ್ ಮಾಡಿ ಮತ್ತೆ ಮಾಡೋಷ್ಟು. Amount in deposit is transferred to the tribunal. Yes.
Serial number 54 Arjan. Serial number 55 K.T. Gurudeva Prasad for appellant. Connected matter D. Vijay Kumar.
Yes, Vijay Kumar is there.
Either.
Yes, my lord. I am ready, my lord.
Ready? Yes. What is this, Mr.
Case of injuries.
Enhancement or?
Enhancement.
Ah.
Negligence, the finding of the tribunal is negligence is on the driver of car.
There is no dispute regarding that. Our appeal illala.
Illa.
Yes.
In the first appeal,
First yavadu? First is 2928.
My lord, Tejaswini. Para 12, my lord. Para 12.
Yes. 2928. Para 12. Yes.
breast fracture of third or dorsal spine.
Yavadu 2928 now.
15 days he was in the hospital. He undergone surgery also.
Yes.
Yes,
She. Disability?
PW2, 52% limb and 27.3% to the whole body.
27%, 52% limb.
Court has taken only 10%.
52 ಅಂತ ಅಂದ್ರೆ
My lord, she is a supervisor continuing in service and getting regular income. There is no loss of future income.
15 Oh, there is no loss of income is deducted.
Yes, my lord. Yes, my lord.
Disability untouchable. 15
Exhibit P9, she has been terminated from the service.
According to petitioner, she was doing a supervisor work earning 12,000 per month. In this regard, she has produced that letter.
That has been disputed by the tribunal and they have not proved that she has been terminated.
The job on her inability to do the job due to accidental injury, but she has not examined that. You have not examined that employer or anybody to show that you are not working or even co-employee.
But
Co-employee or even the bank statement.
Certificate is produced
Yes.
at Exhibit P9. Salary come termination certificate.
What is?
Exhibit P9.
How many injuries?
Well, only fracture of
Injury.
Yeah, injury is breast fracture of third dorsal spine with cord compression, fracture of right parasympathesis of mandible,
Yes.
concussive head injury, contusion over left foot.
Later period ಕೊಟ್ಟಿಲ್ಲ.
15th days he was in the hospital.
Yes. Yes. Towards disability 80,000 ಕೊಟ್ಟಿದ್ದಾರಾ?
Disability
1 lakh ಕೊಟ್ಟಿಲ್ಲ.
loss of future income ಕೊಟ್ಟಿಲ್ಲ.
Future income
1 lakh
ಕೊಟ್ಟಿಲ್ಲ.
ಕೊಟ್ಟಿಲ್ಲ.
Loss
1
of
lakh.
income during later
Later period ಕೊಟ್ಟಿಲ್ಲ.
future
ಡಿಸಬಿಲಿಟೀಸ್ ಗೆ 80,000 ಕೊಟ್ಟಿದ್ದಾರೆ.
disablement ಅಂತ ಹೇಳಿ 1 ಲಕ್ಷ.
80,000.
And amenities only 20,000.
Amenities ಕಡಿಮೆ ಕೊಟ್ಟಿದ್ದಾರೆ. Future medical expenses. You have any doctor's evidence regarding future medical expenses?
ಇದೆ. Doctor evidence.
No.
PW2. Around 30,000 approximately ಅಂತ ಹೇಳಿ.
ಓ ಇಲ್ಲ, ನಾನು ಐ ಆಮ್ ಸೀಯಿಂಗ್ ದಟ್ ಅದರ್ ಮ್ಯಾಟರ್. ಪೈನ್ ಅಂಡ್ ಸಫರಿಂಗ್ ಕೊಟ್ಟಿದ್ದಾರೆ.
ಕೊಟ್ಟಿದ್ದೀವಿ.
ಅಟೆಂಡೆನ್ಸ್ ಚಾರ್ಜಸ್, ಲಾಸ್ ಆಫ್ ಇನ್ಕಮ್ ಡ್ಯೂರಿಂಗ್ ದ ಲೇಟರ್ ಪೀರಿಯಡ್ ಕೊಟ್ಟಿಲ್ಲ.
ಕೊಟ್ಟಿಲ್ಲ.
Yes, how many days? As 15 days she was in the hospital. Yes. Medical expenses ಕೊಟ್ಟಿದ್ದಾರೆ. Loss of income future ಕೊಟ್ಟಿಲ್ಲ. Towards disablement 1 ಲಕ್ಷ ಕೊಟ್ಟಿದ್ದಾರೆ. Loss of future amenities ಕಡಿಮೆ ಕೊಟ್ಟಿದ್ದಾರೆ. Future medical expenses ಏನ್ ಹೇಳಿದ್ದಾರೆ ಡಾಕ್ಟ್ರು? 30,000 ಅಂತ ಹೇಳಿದ್ದಾರೆ. 30,000. Days. According to you, 12,500. Yes. What about second case? Second case, 2929. That is para 24. Disability is 8% tandara. 19.6%. 49%. 49% ಅಂತಂದ್ರೆ 15. ಅದ್ರಲ್ಲಿ ಬರೀ 8% ಡಿಸಬಿಲಿಟಿ. ಇದರಲ್ಲಿ ಏನು ಇದಿದೆಯಾ? ಇದರಲ್ಲೂ she has continued in that work.
Continuing service and getting regular income. And doctor has assessed only physical disability, not functional disability. And also court observed that he has not followed the proper procedure while assessing the loss of income.
ಇದರಲ್ಲಿ ಪ್ಯಾಕರ್
ಪ್ಯಾಕ್ ಮಾಡೋ ಅಂತ.
ಅದರಲ್ಲಿ ಏನು ಕಂಟಿನ್ಯೂಷನ್ ಆಫ್ ಜಾಬ್ ಏನಿಲ್ಲ. Why that loss of income during the later loss of income due to the disability ಕೊಟ್ಟಿಲ್ಲ?
ಅಲ್ಲ ಡಿಸಬಿಲಿಟಿ ಕೊಟ್ಟಿದ್ದಾರೆ.
ಇದರಲ್ಲಿ ಕನ್ಸಿಡರ್ ಮಾಡಿದ್ದಾರೆ.
ಕೊಟ್ಟಿದ್ದಾರೆ.
ಇದ್ರಲ್ಲಿ ಕೊಟ್ಟಿದ್ದಾರೆ. ಅಲ್ಲ ಇದರಲ್ಲೂ ಅಷ್ಟೇ ಲಾಸ್ ಆಫ್ ಬರೀ ಡಿಸಬಿಲಿಮೆಂಟ್ ಅಂತ
ಡಿಸಬಿಲಿಟಿ ಮಾತ್ರ ಕೊಟ್ಟಿರೋದು.
Now in this case what was she?
She is a packer and continuing service and getting regular income. That has
Where is that evidence to show that he has continued?
My lord, para 31, my lord.
Para 31,
Yes, my lord.
Yes, it is obvious to evidence and record that petitioner has taken a treatment, undergone operation.
Only for 8 days.
The petitioner is salaried woman. She has to produce the relevant document like a bank statement, but she has not produced, not entitled for compensation. Continue ಬಗ್ಗೆ ಏನು ಹೇಳಿಲ್ಲ ಯಾಕೆ?
ಅಲ್ಲ that presumes that because she is continuing ಅಂತಾನೆ ಬಂದಿದೆ.
Where is that?
ಅಲ್ಲ that is the presumption by the tribunal.
No, where is that finding?
The same thing, my lord, because it is not coming the way of her occupation and income. And she has not said,
what you are saying, that where is that in that judgment?
She also not stated she has discontinued.
No, is it not that they have to give a reason, mister?
You
are giving a reason for everything. Yes.
My lord, herself she has not claimed that she is not going to continue in service.
No, she
no evidence from the employer.
No, her evidence is due to that there is a loss. There is no finding that in first case there is a finding because she has not produced any examination of that author and all. But here there is no that. Our evidence. It is false to say that I was not working as a packer. Our suggestion. Yes. In this she has continued. She has there is no this thing finding that she has continued in this work. What is that disability assessed by the doctor? 20.
ಅಲ್ಲ ಅಷ್ಟು ಪರ್ಸೆಂಟೇಜ್ ಬರೋದೇ ಇಲ್ಲ. ಟ್ರಿಬ್ಯುನಲ್ ಡಿಸ್ಪ್ಯೂಟ್ ದ ಎವಿಡೆನ್ಸ್ ಆಫ್ ಡಾಕ್ಟರ್ ನಾಗರಾಜ್.
Yes, 49%. Whole body, doctor said 19%, 19.6%. What are the injuries, Mr.
Yes. My lord, humerus fracture and femur. Para 24.
Yes, fracture with supracandicular femur, fracture with intracandicular extension, all the grievous in nature. In this injury, she has taken treatment in the district hospital, Tumkur, Shugana Hospital, orthopedic. Yes. What is that? Hacker earning 9,000 per month. What is the date of the accident?
2016. Her claim is 9,000.
Her claim itself is 9,000.
Yes, yes, my lord.
Yes.
Or claiming.
How many days she was in that hospital, Mr.?
8 days, my lord.
8 days she was in the hospital. 8 days. Loss of income, pain and suffering, attendance charges. Loss of income during the later.
41 years.
Yes, towards disablement.
59% to the limb and 19.6% to the whole body.
What is her age?
41 years.
41 years, my lord.
Yes, to multiplier. 9,000.
41 is 15 multiply. 41, 14 multiply. 14 multiply. 41 to 45, 14 multiply.
9,000. That disablement 80,000 has to be removed and it has to be given under that other hand. Yes.
Later period
Later period we will consider. Iveradena?
Future amenities kadame kottidare.
Yes, that will see. You know, there are two
Future-
appeals or three appeals.
Future medical expense idrallunu 30,000 ಅಂತ ಹೇಳಿದ್ದಾರೆ. 15 ಕೊಟ್ಟಿದ್ದಾರೆ.
ಇದರಲ್ಲಿ ಎಷ್ಟು ಕೊಟ್ಟಿದ್ದಾರೆ?
15,000.
MEC ಆಮೇಲೆ ಎಂತಕ್ಕೆ ಲಯಬಿಲಿಟಿ ಬಗ್ಗೆ ಡಿಸ್ಕಸ್ ಮಾಡಕ?
Liability.
Yes. Yes, that's all.
ಅಷ್ಟೇ.
ಇಂಟ್ರೆಸ್ಟ್ 9% ಕೊಟ್ಟಿದ್ದಾರೆ.
9 ಇದೆಯಾ?
ಹೌದು.
First 2928. So and so learned counsel appearing for claimant has contended that at the time of the accident, she was working as a supervisor and earning 12,500 per month. Due to that accidental injury, she has been removed from the service. To that effect, she has produced exhibit
P9.
Exhibit P9. And doctor has been examined. He has assessed disability to the extent of
62% limb and 27.3.
52% limb disability. Tribunal has not granted any compensation for loss of income due to the disability. He further contended that due to that accident, claimant has suffered grievous injury. She was inpatient for a period of 15 days. She has suffered lot of pain during the treatment. She has to suffer this disability and unhappiness throughout his life. Compensation awarded by the tribunal for pain and suffering, loss of amenities, other incidental expenses, and future medical expenses is on lower side. Sought for enhancement of compensation. Per contra, Vijay Kumar, learned counsel appearing for insurance company has contended that even though claimant has claimed that she was earning 12,500 per month as a supervisor and she has been removed from the service. To prove the same, she has not examined that author of the document and she has not produced the bank statements or the termination letter. Therefore, it is very clear that she has continued in his service. Tribunal has rightly not awarded any compensation for future loss of income due to disability. Secondly, he has contended that considering that injury suffered by the claimant and considering that evidence of doctor and medical records, compensation awarded by the tribunal, pain and suffering, loss of amenities, future medical expenses are just and reasonable. The interest awarded by the tribunal is on higher side. Hence sought for dismissal of the appeal. Heard the learned counsel for the parties. Peruse judgment and award. It is not in dispute. Claimant has suffered an injury in a road traffic accident occurred on 23/2/2016 due to rash and negligent driving of driver of car bearing registration number KA 53A2637. At the time of the accident, she was working as a supervisor and earning 12,500 per month. Even though claimant has claimed that she has been removed from the service, to prove that she has not examined that employer and not produced that termination letter. Therefore, tribunal has rightly not granted any compensation for loss of income due to disability. Due to that accident, claimant has suffered grievous injury. Doctor has been examined as PW3. PW3. He has assessed disability 52% to limb, 17% to whole body. She has to suffer this disability and unhappiness throughout his life. And she has been inpatient for a period of 15 days. She has suffered a lot of pain during the treatment. Considering that evidence of doctor and injuries suffered by the claimant, I am inclined to enhance the compensation for pain and suffering from 90,000 to 1 lakh. The claimant is also entitled for loss of income during the later period for 3 months into 12,000 into 500. For amenities has to be enhanced from 20,000 to 50,000. In respect of future medical expenses is concerned, due to the accident, claimant has undergone surgery. Doctor has been examined as PW4. In his evidence, he has deposed that she required 30,000 rupees for removal of the implant. Considering that the evidence of doctor and injury suffered by the claimant, I am inclined to enhance the compensation for future medical expenses from 15,000 to 25,000. It will not carry any interest. The enhanced compensation amount carries 6% interest. In MEC 2929 of 2016, at the time of the accident, claimant was working as packer and earning 9,000 per month. She has categorically stated that due to that accidental injury, she has not continued in her service. Doctor has been examined as PW4. In his evidence, he has categorically stated that claimant has suffered 49% disability to limb, 19.6% to that. ಇದರಲ್ಲಿ ಅವ್ರು ಕಂಟೆನ್ಷನ್ ತಾಂಡಿಲ್ಲ
ತಗೊಂಡಿದೆ
ಕಂಟೆನ್ಷನ್ ಫಸ್ಟ್ ಮಾಡ್ತೀರಾ ಕಂಟೆನ್ಷನ್ ಅದರಲ್ಲಿ ಡಿಸಬಿಲಿಟಿ ಬಗ್ಗೆ
49 ಅಲ್ಲ 59
19.6%.
19.6.
Yes, considering that evidence of doctor and injury suffered by the claimant, I am of the opinion that whole body disabilities has to be assessed 15%. At the time of
1/3 ತಗೊಳ್ಬೇಕು
1/3 ಆದ್ರೆ ಎಷ್ಟಾಗುತ್ತೆ? ಇನ್ನು ಜಾಸ್ತಿ ಆಗುತ್ತೆ. 1/3
15% ಅಲ್ಲ ಬೇಡ
50%, 49 plus 10%, 59%.
ಬರಲ್ಲ
59% ಅಲ್ಲಿ 1/3 ಅಂದ್ರೂ ಜಾಸ್ತಿ ಇದೆ.
That's what that if you say that 1/3 yes.
Please no 15%.
Yes, since doctor tribunal has taken 8%, I have just taken as 15. Yes. At the time of the accident, she is aged about
43
years.
43
years.
41 or 43.
43 years. The multiplier applicable to that age group is 14.
14.
Accordingly, loss of future earning has been reassessed as follows. Income 9,000.
9,000 into 12 into 14 into 15%, 2,26,800.
Due to the tax dent, claimant has suffered in the head up towards disablement. Instead of that, loss of income during the later loss of income due to disability. Other replace model. 80,000 badlo 2 lakhs and that. Yes. Due to the tax dent, claimant has suffered grievous injury. She was inpatient for a period of 8 days. She has suffered lot of pain during the treatment. She has to suffer this disability and unhappiness throughout his life. Considering that evidence of doctor and injury suffered by the claimant, I'm inclined to enhance the compensation for pain and suffering from 50,000 to 60,000. Claimant also entitled for loss of income during the later period for 3 months.
27.
Yes. Loss of amenities has to be enhanced from 25,000 to 50,000. Loss of in medical expenses.
amenities correct ಆಗಿದೆ.
Medical expenses ಇದ್ರಲ್ಲಿ ಡಾಕ್ಟರ್ ಎಷ್ಟು ಹೇಳಿದ್ದಾರೆ?
30.
ಎಲ್ಲಿದೆ?
Four ಅಲ್ಲಿ ಇದೆ.
ಅಲ್ಲ ಈಗಾಗಲೇ 10 ವರ್ಷ ಆಯ್ತು, ಇನ್ನ ಏನು ಅವ್ರ ಫ್ಯೂಚರ್ ಮೆಡಿಕಲ್ ಎಕ್ಸ್ಪೆನ್ಸ್ ಮಾಡಿಲ್ಲ.
Around rupees 30,000.
Same.
ಇದು ಅಲ್ಲ ಇದುವರೆಗೂ ಮಾಡಿದ್ರೆ they should have produced more than 10 years. ಅಲ್ಲ nearly 8 years, sorry.
Yes. The interest has to be for enhanced compensation amount carries 6% interest.
In both the cases.
ಒಂದ್ರಲ್ಲೇನ ಯಾವ್ದ್ರಲ್ಲಿ ಯಾವ್ದಿದು?
In both cases.
ಅಲ್ಲ
ಎರಡು
ಎರಡರಲ್ಲೂ 9%
ಎರಡರಲ್ಲೂ 9 ಮಾಡಿದರೆ 6 ಮಾಡ್ಬೇಕು.
ಎರಡರಲ್ಲೂ 6 ಬಟ್ ಡಿಲೇ ಮೇಲೆ ಒಂದ್ರಲ್ಲಿ ಮಾತ್ರ ಡಿಲೇಗೆ ಇಂಟ್ರೆಸ್ಟ್ ಡಿನೈ ಮಾಡಿದ.
ಇದ್ರಲ್ಲಿ ಆರ್ಡರ್ ಮಾಡ್ಬೇಕು.
2339 ಯಾವ್ದು? 2339 ಸೆಕೆಂಡ್ ಮ್ಯಾಟ್ರಾ? ಎಸ್.
ಹೌದು, ಸೆಕೆಂಡ್ ಮ್ಯಾಟರ್.
ಡಿಲೇ ಕಂಡನ್ ಆಗಿದೆ 18/12/23 ನಲ್ಲಿ.
ಒಂದ್ರಲ್ಲಿ ಇಂಟ್ರೆಸ್ಟ್ ಹಾಕಿಲ್ಲ, ಒಬ್ರು ಸಾಹೇಬ್ರು ಇಂಟ್ರೆಸ್ಟ್ ಹಾಕಿದ್ದಾರೆ. ಇನ್ ದಟ್ ಆನ್ 29/11/2022 in view of order dated 29/11/2022, the claimant is not entitled for the interest for a period of 81 days for enhanced compensation. All pending applications are disposed of.
Much obliged.
Serial number 56, Ravi Kumar NR for appellant, EI Sanmati.
Yes. For the appellant. Case of injury. Yes,
Only enhancement or?
Only enhancement.
Yes.
He was a driver of the school bus at Chikmagalur. While driving the school bus.
No, now all that is not dispute, only now income.
Income.
Yes, what is that income?
Income, he has stated that 10,000 was paid as a salary. Tribunal has taken only 8,000 as a notional income has taken. The
2014 ಏನ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದೀರಾ?
he has not produced.
No, that 2014 ಗೆ 8,500 ಇದೆಯಲ್ಲ.
Employer evidence ಮಾಡಿಲ್ಲ.
Admittedly, in the charge sheet also, he was a driver in the school bus. Driver in the school bus. And he has stated that he was earning.
8,500 ಇದೆ, even driver ಅಂದ್ರೆ will take 500 more, 9,000. Then your claim itself is just
10,000.
Yes.
And the disability is concerned, my lord.
Now we will come to the disability.
Disability is concerned, he has lost one right eye.
ಎಲ್ಲಿದೆ finding?
Finding in para
20.
15 of the, para of 13 of the judgment.
Para 13?
13.
Yes. Yes, read.
13. And perusal of the medical records, exhibit P 8 to 18 and 27/30 and the C 1 to 13. Disclosed that the petitioner has sustained the several injuries on his person, and he took the treatment in Minto Hospital, Victoria Hospital, Nimans Hospital, Kims Hospital, AJ Hospital, and Sridhar Nursing Home. His injury is described as grievous in nature. X-rays and the scan report reveals that the petitioner has sustained several fracture injuries, including the head injury. The said medical records corroborate the evidence of PW1 regarding the injuries. PW2, Dr. Ulla Shetty has deposed that the petitioner has sustained grievous injuries and he is suffering from permanent disability of 40% with respect to the vision of the vision and 17% with respect to the left upper limb. Disability certificate is at exhibit P18 and it is consistently with the evidence of P22. This is as
ಆಯ್ತು ಟ್ರಿಬ್ಯುನಲ್ ಎಷ್ಟು ಕನ್ಸಿಡರ್ ಮಾಡಿದ್ದಾರೆ
40% ತಗೊಂಡಿದ್ದಾರೆ 55 years age.
40% ತಗೊಂಡಿದಾರಾ?
Total 40%. As per the schedule, he was admittedly he was a driver. Schedule 1, part 4, that is loss of sight of such an extent to the render the claimant under the perform any work for the which eyesight is essential is 100% as taken.
ಯಾವ್ದ್ರಲ್ಲಿ?
Employees compensation act.
ಯಾವ್ದು ಶೆಡ್ಯೂಲ್ ಎಷ್ಟರಲ್ಲಿ?
Schedule 1, schedule 2, sorry, schedule 1, part 1.
ಪಾರ್ಟ್ 1 ಅಲ್ಲಿ ಕ್ಲಾಸ್ ಎಷ್ಟನೇ ಸೀರಿಯಲ್ ನಂಬರ್?
4.
ಲಾಸ್ ಆಫ್ ಹ್ಯಾಂಡ್ಸ್ ಅಂಡ್ ಥಂಬ್ಸ್ ಅಂಡ್ 4 fingers, 1 hand amputation.
ಅದಲ್ಲ. ಇದರಲ್ಲಿ
ಪಾರ್ಟ್ 2 ಅಲ್ಲಿ
the list of injuries remain to the result of permanent total disablement. Part 1.
ಪಾರ್ಟ್ 1 ನ ಪಾರ್ಟ್ 2 ನ?
Part 1. First schedule, part 1, in column number 4.
Loss of sight to such an extent to that render that claimant unable to perform your work.
Unable to perform.
ಎಲ್ಲಿ ಡಾಕ್ಟರ್ ಹೇಳಿದಾರಾ?
Doctor ಹೇಳಿದ್ದಾರೆ. And he has also surrendered the, as per the exhibit.
He has deposed that petitioner has sustained grievous injury and he is suffering from permanent disability of 40% with respect to that vision. 17% with respect to that limb.
And
Evidence of
and he has lost the one eye. Therefore, exhibit P29, he has produced before the court, my lord, that he has surrendered the DL to the authority. He has stated, my lord, that is, ನಾನು ಮೇಲ್ಕಂಡ ವಿಳಾಸದಲ್ಲಿ ವಾಸವಾಗಿದ್ದೇನೆ. ಈ ಹಿಂದೆ ನಾನು ಚಾಲನಾ ವೃತ್ತಿಯಲ್ಲಿ ಮಾಡುತ್ತಿದ್ದೇನೆ. ಚಾಲನಾ ವೃತ್ತಿಗೆ ಸಂಬಂಧಪಟ್ಟಂತೆ ತಮ್ಮ ಕಚೇರಿಯಿಂದ ವಾಹನ ಚಾಲನಾ ಪರವಾನಗಿಯನ್ನು ಪಡೆದಿದ್ದು, ನನ್ನ ವಾಹನ ಚಾಲನೆ ಪರವಾನಗಿ ಸಂಖ್ಯೆ ಸೋ ನಂಬರ್, ಇದನ್ನು ದಿನಾಂಕ 26/7/85 ವಾಹನ ಚಾಲನಾ ಪರವಾನಗಿ ಪಡೆದುಕೊಂಡಿರ್ತೇನೆ. ಈಗ ನನಗೆ ವಾಹನ ಅಪಘಾತವಾಗಿದ್ದು ಇದರಿಂದ ನನ್ನ ಬಲಗಣ್ಣಿಗೆ ಸಂಪೂರ್ಣ ದೃಷ್ಟಿಹೀನತೆ ಹೊಂದಿರುತ್ತದೆ. ಅದರಿಂದ ನನಗೆ ವಾಹನ ಓಡಿಸಲು ಆಗುವುದಿಲ್ಲ. ಅದರಿಂದ ನನ್ನ ವಾಹನ ಚಾಲನಾ ಪರವಾನಗಿಯನ್ನು ಸ್ಮಾರ್ಟ್ ಕಾರ್ಡ್ ಅನ್ನು ತಮ್ಮ ವಶಕ್ಕೆ ನೀಡಿದ್ದು, ಇದನ್ನು ರದ್ದುಪಡಿಸಿ ಸೂಕ್ತ ಹಿಂಬರವನ್ನು ನೀಡಬೇಕೆಂದು ತಮ್ಮಲ್ಲಿ ಕೋರಿಕೊಳ್ಳುತ್ತೇನೆ. ಅದಕ್ಕೆ ಎಂಡೋರ್ಸ್ಮೆಂಟ್ ಡಾಕ್ಟರ್ ಸರ್ಟಿಫಿಕೇಟ್ ಎನ್ಕ್ಲೋಸ್ ಮಾಡಿದ್ದಾರೆ. ಅಡಕ ಮಲ್ಲೇಗೌಡ ಆಸ್ಪತ್ರೆ ವೈದ್ಯರ ದೃಢೀಕರಣ ಪತ್ರ ಮತ್ತು ರಿಪೋರ್ಟ್ ಮತ್ತು BPL ಕಾರ್ಡು, ಚುನಾವಣಾ ಕಾರ್ಡು ಇಷ್ಟನ್ನ ಕೊಟ್ಟು he has surrendered his DL. Therefore this
ಎಲ್ಲಿ where you have read now?
exhibit P29 ಮೇಲೆ
ಕೊಡಿ. ಲೆಟರ್
ಹೌದು.
ಯಾರ್ದು ಲೆಟರ್?
the injured, the claimant has
ಅಲ್ಲ, ಡ್ರೈವಿಂಗ್ ಲೈಸೆನ್ಸ್ ಸರೆಂಡರ್ ಎಲ್ಲಿ ಮಾಡಿದ್ದೀರಾ?
ಅಲ್ಲಿ RTO ಆಫೀಸ್ಗೆ ಮಾನ್ಯ ಪ್ರಾದೇಶಿಕ ಸಾರಿಗೆ ಅಧಿಕಾರಿಗಳು RTO ಕಚೇರಿ ಚಿಕ್ಕಮಂಗ್ಳೂರು
ಅವ್ರಿಗೆ ಬರ್ದಿರೋ ಲೆಟರ್?
ಅವರಿಗೆ ಬರೆದು DL ನೆಲ್ಲ ಸರೆಂಡರ್ ಮಾಡಿ ಕೊಟ್ಟಿದ್ದಾರೆ.
ಅವರಿಂದ ಬಂದಿರೋ ಲೆಟರ್ ಇದು? ಅಲ್ಲ, ಸರೆಂಡರ್ ಆಗಿರೋದಕ್ಕೆ ಏನಿದೆ ಪ್ರೂಫ್ ಅಂತ?
ಸರೆಂಡರ್ ಇದರಲ್ಲೇ ಕೊಟ್ಟಿದ್ದಾರೆ. ಅದರಿಂದ ನನ್ನ ವಾಹನ ಪರವಾನಗಿಯನ್ನು ಸ್ಮಾರ್ಟ್ ಕಾರ್ಡ್ ಅನ್ನು ತಮ್ಮ ವಶಕ್ಕೆ ನೀಡಿದ್ದು ಇದನ್ನು ರದ್ದುಪಡಿಸಿ ನನಗೆ ಸೂಕ್ತ ಹಿಂಬರ ಕೊಡಬೇಕೆಂದು ತಮ್ಮಲ್ಲಿ ಕೇಳಿಕೊಳ್ತೇನೆ. ಅದರೊಟ್ಟಿಗೆ ಮಲ್ಲೇಗೌಡ ಆಸ್ಪತ್ರೆಯ ವೈದ್ಯರ ದೃಢೀಕರಣ ಪತ್ರ ಮತ್ತೆ ರಿಪೋರ್ಟ್ ಮತ್ತೆ BPL ಕಾರ್ಡು, ಚುನಾವಣಾ ಕಾರ್ಡು ಇಷ್ಟನ್ನ ಎನ್ಕ್ಲೋಸ್ ಮಾಡಿ ಅಡಕವನ್ನ ಅವರಿಗೆ ಕೊಟ್ಟು DL ಕ್ಯಾನ್ಸಲ್ ಆಗಿದೆ. Therefore, the schedule is applicable because of his work is concerned, employment is concerned. This schedule is concerned.
Yes.
Therefore, the loss of one eye for the and also multiple fracture of his ribs and other fractures as noted by the doctor at exhibit P18. P18 may consider. P18, the right side complete loss of vision. Doctor has opinion in the disability certificate. Exhibit P18, terminal restriction of left wrist joint with persistent pain. X-ray shows fracture union and implant in situ.
Yes.
the disability certificate and doctor opinion that after perusal of the
Yes,
case.
Mr.
Lordship, he was working as a driver of the bus, Lord. He was working for a school, Lord. After the accident, the claim of the person is that he driving license has been surrendered, but you are asking whether he was given any other job. He has not given.
No.
The
See,
employer is not examining whether he was moved from the job, because
No.
this is not a easy case.
no, his thing is, he was a driver. His profession is a driver. His livelihood is that once he lost that, then Supreme Court said that he is entitled for that.
But that is in the ECA case, workers' compensation, but this is MBC case, Lord. He should have examined the employer saying that he was removed from the job because of this, he could not drive the vehicle, or he has not got.
No, school ಅಲ್ಲಿ ಏನ್ ಕೊಡ್ತಾರೆ ಇವರಿಗೆ? Driver is the driver only.
They might have given some other job. They also have examined the employer, Lord. Because
See, ultimately, he can do other work other than that this.
whether it was
but-
given any other work, whether he was removed from the job,
Yes, we'll consider.
that is not
Yes.
proved by the petition.
Yes.
Therefore, the disability of 40%, even though it is on higher side,
Yes.
Lord, that employer's compensation.
Not-
There should be a total disablement with respect of name.
Good.
It is not that he cannot do all type of, any other type of work, Lord.
Yes.
He can only, has only shown that he has surrendered the driving license.
Yes.
So other type of work.
Yes.
And the tribunal has taken only 30% of the disability.
30% or 40%?
30% to the vision and 6% to the upper limb.
Yes.
6% to the upper limb. Totally, even though if it's calculated, 42% it will come as per the, our 40% matra tanidra whole body. 40% has taken by the tribunal. That is also wrong. And even the loss of eye, the doctor has opinion also, 40% to the eye, he has opinion that.
No, has
And
he said he can't do the driving?
No, he has already.
ಅಲ್ಲ ಡಾಕ್ಟರ್ ಏನು ಹೇಳಿದಾರಾ?
ಹೌದು ಹೇಳಿದ್ದಾರೆ.
ಡಾಕ್ಟರ್ ಹೇಳಿದಾರಾ?
ಡಾಕ್ಟರ್ ಹೇಳಿದ್ದಾರೆ ಇದರಲ್ಲಿ. ಡಾಕ್ಟರ್ ಒಪಿನಿಯನ್.
But he has not stated that he cannot do any type of work.
On perusal of the sheet and the clinical examination, we are of the opinion that he has permanent physical disability of 40% with respect to the vision is concerned.
Yes.
And 17% to the upper limb is concerned. The
I think he can do some work. We have to take it 60%, please, plus future prospects.
Please.
Future prospects is entitled. Because he has lost that his skilled work. Then other head, they have given sufficient.
There it's sufficient. There is no room for
Sufficient.
enhancement.
ಅಲ್ಲಿ 25,000 ಡಿಸಬಿಲಿಟೀಸ್ ಅಲ್ಲಿ ಕಡಿಮೆ ಆಗುತ್ತೆ. ಅವಾಗ ಇದ್ರಲ್ಲಿ ಕೊಟ್ರೆ why that they have given disabilities also separate
disability, that is 25.
loss of income during the later period, loss of future income ಕೊಟ್ರೆ amenities ಕೊಟ್ಟ ಮೇಲೆ disabilities extra ಬರಲ್ಲ. We'll just recalculate. That is the only. Yes, mister. That's all.
And the doctor opinion that he required 35,000 for the future in his general ward.
ಆಯ್ತು 25,000 ಕೊಟ್ಟಿದ್ದಾರೆ ಅದಕ್ಕೆ.
For removal of the implant, cost about 35,000 in general ward in AJ hospital. But tribunal has awarded only 25,000. That is the
10,000 ಹೇಳಿದ ಪೂರ್ತಿ ಕೊಡಲ್ಲ ಫ್ಯೂಚರ್ ಮೆಡಿಕಲ್ ಎಕ್ಸೆಲ್ಸ್ ಅಲ್ಲ. Yes. Only that will enhance 60% plus future prospects.
Income
and income 9,000. Yes. Third. So and so learned council appearing for.
ಇಲ್ಲ.
ಅಲ್ಲ, he is admitted that he is a driver. 8,500
ಅಲ್ಲ 9,000 ಇದೆ.
ಅಲ್ಲ 8,500 ಇದೆ. ಲೋಕದಲ್ಲೇ ಇದೆ. Since he is a driver, ಒಂದು 500 ರೂಪಾಯಿ ಜಾಸ್ತಿ ಸೇರಿಸ್ತೀವಿ ಅಷ್ಟೇ. Wherever that it is proved that he is a driver. ಇದು ಯಾರಿಗೆ ಗೊತ್ತಾ? ಡೈಲಿ ವೇಜಸ್ ಎಂಪ್ಲಾಯೀಸ್ಗೆ. ಇವ್ನು ಡ್ರೈವರ್ ಆಗಿರೋದ್ರಿಂದ ಅವ್ರಕ್ಕಿಂತ ಸ್ವಲ್ಪನೂ ಜಾಸ್ತಿ ಬರಲಿಲ್ಲ ಅಂದ್ರೆ ವಾಟ್ ಇಸ್ ದ ಯೂಸ್ ಅಂತ. ಎಸ್. So and so learned council appearing for. The claimant has contended that at the time of the accident, he was working as a driver in which school, mister?
St. Mary's School.
St. Mary's School, Chikmagalur. Due to that accident, he has suffered he lost an eyesight. He has examined the doctor. Doctor has deposed that the claimant has suffered 40% disability in respect of vision, 17% in respect of upper limb. Due to that disability, he is unable to do his driving work. He has surrendered his driving license. To that effect, he has also produced the letter day, yeah, the annexure, exhibit,
29, my lord.
exhibit,
29. P29.
exhibit P29. The tribunal, instead of assessing functional disability as 100%, has assessed only a 40%, is on lower side. Secondly, he has contended that due to the disability, he has suffered he has lost his job. He is unable to do his day-to-day work. In view of judgment of Apex Court, he is entitled for future prospects. What is his age?
55 years.
55 years antandre 10%. Lastly, he has contended that due to that extent, claimant has suffered the above said injury. He was inpatient for a period of
42 days.
42 days. He has suffered a lot of pain during the treatment.
Just one submission. In the schedule of the code, loss of sight to such an extent as to render claimant unable to perform any work for which eyesight is essential.
ಹೌದು
Driver eyesight ಬೇಕಲ್ಲ.
Any work, Lord, it is only not in respect of driver. If he is not able to do any work, then it is 100%, Lord.
No, therefore, I am not relying on that. As a driver, see, 40% eyesight as it is, we have to take. Disabilities in that other aspects, it has 17%. Since he has driver, he has surrendered his profession. Even then, he can do some other work. Therefore, 40% has been given a left, saying that he can do other work. Therefore, I have fixed for a 60. Otherwise, I could, if you refer that, it should be an 100% one. Yes. Therefore, I have not taken that his contention on that ground. Inpatient for a period of 42 days. He has suffered a lot of pain during the treatment. The compensation awarded by the tribunal, pain and suffering, loss of amenities, other incidental expenses, is on higher side. Is on lower side. Hence, he sought for enhancement of interest is 9% idea.
9%.
Sri Sanmati Learned Council appearing for the claimant, the insurance company has contended that even though doctor has deposed that he has suffered 40% disability in respect of the vision, he has not examined that employer to show that instead of driving work, he has not been employed for any other work other than the driving. And he further contended that the injury suffered only in respect of 40% in respect of that eye. He can do other work. And considering his age, the tribunal has rightly assessed whole body disabilities as 40%. He further contended that even though he has claimed that he was earning 10,000 per month, he has not produced any document to establish the same. Therefore, tribunal has rightly assessed notional income as 8,000. Lastly, he has contended that considering that injury suffered by the claimant, considering that evidence of doctor and medical records, overall compensation awarded by the tribunal for pain and suffering, loss of amenities, other incidental expenses is just and reasonable. The interest awarded by the tribunal, 9% is on higher side.
Laden period, he was 42 days when he inpatient, only 48,000 has been awarded. That is required to be enhanced.
ಆಯ್ತು 3 ತಿಂಗಳು ಕೊಟ್ಟಿದ್ದಾರಲ್ಲ 3 ತಿಂಗಳು ಸಾಕು. We'll see that by calculating that what is that loss of income will come, then I will see that whether it is required for enhancement. Heard the learned counsel for the parties. There was judgment and award and original records. It is not in dispute claimant has suffered an injury in a road traffic accident occurred on 28/5/2014 due to rash and negligent driving of driver of lorry bearing registration number KA18 B4878. At the time of the accident, he was working as a driver in private school
St. Mary's School.
and he was earning and private school. Due to that accident, he has suffered the following injury. He has examined the doctor as PW2. In his evidence, he has deposed that the claimant has suffered 40% disability in respect of vision, 17% in respect of left upper limb. Since he was a driver, in view of vision disability, he is unable to do his driving work. As per Exhibit P29, he has surrendered his driving license. But he has not examined that employer to show that he was not given any alternative work. Considering that vision disability and considering that the claimant was working as a driver, I am of the opinion that the whole body disabilities has to be assessed 60%. In view of, due to the disability, he is unable to do his day-to-day work. In view of judgment of apex court in case of so and so, the claimant is also entitled for future prospects. Even though he has claimed that he was earning 10,000 per month, he has not produced any document to establish the same. Since admittedly he was a driver, considering that evidence of PW1, I am of the opinion that monthly income of the claimant can be assessed as 9,000 per month. In view of judgment of apex court in case of Pranay Sethi, deceased, the claimant was aged about 55 years at the time of the accident. 10% of the income has to be added for future prospects. The multiplier is to 11. Accordingly, future loss of income reassessed.
9,000 plus 900 at the rate of 10%, 9,900. 9,900 into 12 into 11 into 60%, 7,84,080.
In other head, the compensation, anyhow that the other head dalli ಸ್ವಲ್ಪ ಕಡಿಮೆ ಇರೋದ್ರಲ್ಲಿ disabilities 25 ಕೊಟ್ಟಿದ್ದಾರೆ, that will be work out. Instead of removing, we'll enhance this and close it. Other head, compensation awarded by the tribunal is just and reasonable. The enhanced compensation amount carries 6% interest. In view of order dated 8/12/2023, not entitled for the interest for a period of 217 days for enhanced compensation amount. Yes.
Number 57, K.T. Gurudeva Prasad for appellant, K. Suresh.
I appeal for the respondent number 2.
Yes, ready, Suresh. Yes, Mr.
Case of injuries. There is no permit to the lorry.
No permit.
Adರಲ್ಲಿ exonerated the liability on the insurance company and directed the owner to pay the Amritpal Singh case
Pay and
recovery.
Yes, Mr. That's all.
ಆಮೇಲೆ ಇಲ್ಲ injuries ಜಾಸ್ತಿ. In para 11 of the judgment.
Yes.
He suffered a closed fracture shaft of the humerus and multiple fracture head, one bone, etc. This regard doctor as examined by the petitioner as PW3 in his evidence clearly deposed that there is one closed fracture on right humerus, middle 1/3 region and head injuries.
ಎಷ್ಟು ತಗೊಂಡಿದ್ದಾರೆ ಟ್ರಿಬ್ಯುನಲ್ ಅವರು?
ಅಲ್ಲ ಅದರಲ್ಲಿ The doctor evidence is PW three, doctor evidence 47.41% to the limb and 15.8% to the whole body.
ಇವ್ರೇನ್ ಮಾಡಿದ್ದಾರೆ?
ಏನು ಯಾವ್ದನ್ನು ಕರೆಕ್ಟ್ ಆಗಿ ಡಿಸ್ಕಸ್ ಮಾಡಿಲ್ಲ, 5% ಅಂತ ಹೇಳಿದ್ದಾರೆ ಅಷ್ಟೇ.
ಎಲ್ಲಿ?
ಪ್ಯಾರಾ 13 ಅಲ್ಲಿ.
300 per day, out of 1/3 to be deducted is personal expenses, hence contribution. ಇದೇನ್ 1/3 ಎಲ್ಲ ಮಾಡಿದಾರಲ್ಲ, ಏನದು?
ಪರ್ಸನಲ್ ಎಕ್ಸ್ಪೆನ್ಸಸ್ ಅಂತ 1/3 ಮಾಡಿದ್ರು.
ಇಂಜುರಿ ಕೇಸಲ್ಲಿ?
ಇಂಜುರಿ ಕೇಸಲ್ಲಿ.
ಯಾರೋ ಹೊಸಬರು ಇರ್ಬೇಕು. Who is that?
Date of accident is 24/9/2013. 2013. He was aged about 32 years. 32 years he was doing.
What is that income you have claimed?
30,000 per month.
ಟ್ರಿಬ್ಯುನಲ್ ಎಷ್ಟು ತಗೊಂಡಿದ್ದಾರೆ?
9,000 ಮಾಡಿ ಅದರಲ್ಲಿ 1/3 ಡಿಡಕ್ಟ್ ಮಾಡಿದ್ದಾರೆ.
ಅದು actually 8,000 ತಗೋಬೇಕು ಸ್ವಾಮಿ. 8,000 ತಗೋಬೇಕು ಸ್ವಾಮಿ. It's the accident is of the year 2013. 8,000 ತಗೋಬೇಕು.
32 years.
Yes. ಎಷ್ಟು ದಿನ ಹಾಸ್ಪಿಟಲ್ ಅಲ್ಲಿ?
Hospitalization is 5 days.
Pain and suffering ಕೊಟ್ಟಿದ್ದಾರೆ. Loss of immunity ಎಷ್ಟು pain? Medical expenses ಕೊಟ್ಟಿದ್ದಾರೆ.
Loss of immunity 10,000.
Conveyance charges, special food to attendance charges ಎಲ್ಲ separate. Permanent loss of income, future medical expenses. Yes, Mr. Suresh.
ಸ್ವಾಮಿ ಅದರಲ್ಲಿ 2013 ಆಕ್ಸಿಡೆಂಟ್ 9,000 ತಗೊಂಡಿದ್ದಾರೆ. 8,000 rupees has to be taken madam.
ಆಯ್ತು. Pay and recovery.
ಹೌದು ಸ್ವಾಮಿ. There is no scope for enhancement ಸ್ವಾಮಿ. ಅವ್ರು ಕೊಟ್ಟಿರೋ ಸರಿ ಇದೆ.
Yes, we'll consider.
Yes, madam.
ಎಲ್ಲಿ ಅದು ಅಮೃತ್ ಪಾಲ್ ಕೇಸ್ ಬಿಡಿ. So and so learned counsel appearing for the claimant has contended that due to the accident, claimant has suffered about doctor evidence. Doctor evidence.
Bone grafting ಎಲ್ಲ ಆಗಿದೆ.
Suffered doctor evidence. Grievous injury. He was inpatient for a period of 5 days. Doctor has been examined as PW3. In his evidence, he has deposed that claimant has suffered 47.41% disability to upper limb, 15.8% to that whole body. Tribunal has assessed whole body disabilities.
Non-union of fracture ಅಂತಾನೆ ಹೇಳಿ.
5% ಮಾಡಿದಾರಾ?
5%.
Is on lower side.
It is to be 1/4 ಸ್ವಾಮಿ. Upper limb, therefore it is to be 1/4 of the disability of the upper limb.
ಎಷ್ಟಾಗುತ್ತೆ 1/4 ಆದ್ರೆ?
12% ಆಗುತ್ತೆ. 47.41 ಇದೆ, 48 ಇಟ್ಕೊಂಡ್ರೆ 12% ಆಗುತ್ತೆ.
12%.
Disability right upper limb which is about 15 points whole body. Yes, upper limb ಅಲ್ಲ. 12%. Yes. Secondly, he has contended that due to that accident, claimant has suffered grievous injury. He was inpatient for a period of 5 days. He has suffered lot of pain during the treatment. He has to suffer this disability and unhappiness throughout his life. A compensation awarded by the tribunal for pain and suffering, loss of immunities, other incidental expenses. Is on lower side. Lastly, he has contended that the tribunal has given a finding in respect of liability. The offending vehicle was not having valid and effective not having any valid permit as on the date of the accident, rightly exonerated that insurance company from liability. But third parties is concerned that insurance company has to pay that compensation amount with liberty to recover from owner of the offending vehicle. In support of his contention, he has relied on Apex Court Judgment, Amrut Park, 2018-7 SEC 558. Per contra, Sridhar Learned Counsel appearing for insurance company has contended that. Suresh, yes, contended that the injury suffered by the claimants are only in respect of upper limb. Doctor has assessed the disability as 47%. Considering that injury suffered by the claimant and medical records, tribunal has rightly assessed 5%. He further contended that considering that evidence of doctor and injury suffered by the claimant and medical records, compensation awarded by the tribunal in the other hand, just and reasonable. Lastly, he has contended that at the time of the accident, offending vehicle was not having the permit, not having a valid permit. Since insured has violated the policy condition, tribunal has rightly exonerated insurance company from the liability. Hence, he sought for dismissal of the appeal. Heard the learned counsel for the parties, Perose, judgment and award. It is not in dispute. The claimant has suffered an injury in a road traffic accident occurred on 24/9/2013 due to rash and negligent driving of driver of lorry bearing registration number AP12V0938. At the time of, due to the accident, claimant has suffered the above said injury. Doctor has been examined as PW2 na? PW3. PW3. In his evidence, he has deposed that claimant has suffered 47.58% disability to upper limb. Considering that evidence of doctor and injury suffered by the claimant, I am of the opinion that whole body disabilities has to be assessed 12%. Tribunal has assessed monthly income as 9,000. The multiplier applicable to that age group, ಎಷ್ಟು multiplier? 16. Accordingly, loss of future earning has been reassessed as follows.
Rupees 8,000 has to be taken, my lord. 2013 accident. 2013 accident.
Tribunal has considered 9,000. There is no appeal from your side.
In that case, I will file cross objections if the appeal is admitted, my lord.
Yavaga? Case argument ಆದ್ಮೇಲೆ.
Admit agila. Appeal admission
agila. This is in hearing, mister. This is the hearing. Now, Mr. Suresh, it is in that hearing list. That means to say it is admitted.
Yes.
Yes.
9,000 into 12 into 16 into 12%, 2,07,360.
But the case was dismissed against the company, Swami. Dismissed against the company. Then how can I file cross objections?
ಅಂತ ನೀವೇ ಹೇಳಿದ್ರಲ್ಲ ನಾನು ಕ್ರಾಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕ್ತೀನಿ ಅಂತ.
ಅಲ್ಲ ನಾನು ಹೇಳ್ತಾ ಇರೋದು ಅಡ್ಮಿಟ್ ಆಗಿದೆ ಫೈನಲ್ ಹಿಯರಿಂಗ್ ಅಂದ್ರಲ್ಲ ಡಿಸ್ಮಿಸ್ ಆಗಿದೆ ಕಂಪನಿ ಮೇಲೆ. ನಾನು ಇನ್ನೇ ನೋ ಇಫ್ ದ ಕ್ವಶನ್ ಆಫ್ ಕಾಂಪನ್ಸೇಷನ್ ಬಿಕಾಸ್ my lord is considering regarding the compensation holding that the company is with liberty to pay and recover.
Yes, then you are right. You have said that I want to file a cross objection.
Because appeal hakilla and adu kelide.
The income 8,000 consider. Yes.
Sorry, man.
Yes.
8,000 into 12 into 16 into 12%, 1,84,320.
Yes. Due to that accident, claimant has suffered grievous injury. He was inpatient for a period of 5 days. He has suffered lot of pain during the treatment. He has to suffer this. What are the injuries, Mr.?
A fracture of humerus and in bone, non-union antanu ide, bone, he
Yes.
undergone a bone grafting.
He has suffered lot of pain during the treatment. He has to suffer this disability and unhappiness throughout his life. Considering that evidence of doctor and injury suffered by the claimant, I am inclined to enhance the compensation for pain and suffering from 60,000 to 70,000. Loss of immunities from 10,000 to 40,000. Loss of income during the later period for 3 months. Other head compensation awarded by the tribunal is just and reasonable. Interest is 6% idella?
House.
Yes. In
6%.
respect of liabilities is concerned, the tribunal has given a finding that at the time of the accident, the offending vehicle was not having valid permit. Since insured has violated the policy condition, tribunal has exonerated that insurance company. However, in respect of third parties is concerned, the insurance company, since offending vehicle is covered with valid insurance policy, insurance companies has to pay that compensation amount in first instance with liberty to recover from owner of the offending vehicle. Accordingly, the appeal is allowed in part. Judgment and award passed by the tribunal is modified as follows. The insurance company is directed to deposit compensation amount with interest within 6 weeks from date of receipt of the copy of this order, with liberty to recover from owner of the offending vehicle.
One submission, my lord.
Hmm.
Serial number 50 finally, common judgment or separate judgment?
ಏನ್ ಬೇಕು ನಿಮಗೆ?
Separate judgment.
ಆಯ್ತು.
Yes.
Serial number 58, A.M. Venkatesh for appellant, connected matter, Nagaraja Hegde.
I'm for the appellant, my lord. Today they served the copy, my lord. I will file the wakalat, my lord.
Served copy in what? In that
Crop.
class ಅಲ್ಲಿ ಇವತ್ತು ಕೊಟ್ಟಿದ್ದೀರೇನ್ರಿ?
ಕೊಟ್ಟಿದ್ದೀನಿ ಸ್ವಾಮಿ, ಅವ್ರು 2-3 ಸತಿ ಕೊಟ್ಟಿದ್ದೀನಿ, ಅವ್ರು ತಗೊಂಡಿಲ್ಲ ಅಂತ ಹೇಳ್ತಾರೆ.
ಆಯ್ತು.
Anyway, I have served.
Yes. When do you want time or ready?
Time.
Yes. At the request of counsel for appellant in MFA 8-11 of 2018. Leave this matter of 2 weeks. Yes.
Next week.
Next week. Yes.
Serial number 59, O. Mahesh for appellant, connected matter, B. Pramod.
Ready, madam? Ready. Mahesh and ಕಾಣಿಸ್ತಾ ಇಲ್ಲ. He is not there next week. Yes. None appear for the appellant in MFA 1326 of 2019. Please this matter of 2 weeks.
Serial number 60, Sridhara Murthy for petitioner, K. Ramesh Rao.
In this, I appear for the third respondent in both the matters, my lord.
Yes.
We have engaged senior counsel Jaikumar Patil. He is just coming from the other court.
Lordship, last time directed the government to secure the documents, records.
Could not secure. Next week I will secure.
In that regard,
In all cases,
Yes.
that is the problem. Why you can't get the
I wrote a letter and all to them.
next week?
my submission, my lord, due respect to my friend, already 2 occasions this honorable court has directed them. Long back.
ಬೇಕಲ್ರಿ, ನಾನೇ 2 ಸಾರಿ ನನ್ನ ರೋಸ್ಟರ್ ಬಂದ್ಮೇಲೆ ಹೇಳಿ.
And we have secured the RTA from the department that there are no documents available.
DC also says.
You have to ask that officer.
Yes,
Even in the order sheet, DC also told that no records are available.
Yes.
I
At
will
the request
verify.
of government advocate, as a last chance, week's time is granted to.
Maybe posted on 23rd, Your Honor, 23rd Mangalwara.
ಆಗ ಅವ್ರು
This is a very old matter.
They can't get it, mister.
I will verify.
Yes, you have to ask the officer to come to the chamber and explain why he has not. Yes. Yes.
Vast door matter.
Date.
23rd,
Next week.
Serial number 18, M.R. Iremated for appellant. Serial number 18,
Yes. None appear.
Memo file ಮಾಡ್ಬಿಡಿ at least. Memo.
Leave this matter ಅಲ್ಲ ನಾನ್ ಕಂಪ್ಲೇಂಟ್ಸ್
ಹೌದು ಸರ್.
ಎಲ್ರಿ ಅವ್ರು ಹಿರೇಮಠ ಯಾಕೆ ಬರಲ್ರಿ ಬರ್ತಾರಲ್ಲ ಎಲ್ಲ ಕೇಸಿಗೆ ಹಿಂದೆ ಟೈಮ್ ತಗೊಂಡಿದಾರ ನೋಡಿ ಏನು ಪ್ರೋಸೆಸ್ ನಾವು ಪ್ರೆಸೆನ್ಸ್ ಇದ್ರ ತೋರ್ಸ್ಬೇಕು ಆನ್ ರಿಕ್ವೆಸ್ಟ್ ಅಂತ ತೋರ್ಸಿದ್ರೆ ಗೊತ್ತಾಗುತ್ತೆ ಇದೆಯಾ ನಮ್ ಬೆಂಚ್ ಅಲ್ಲಿ ಆಮೇಲೆ ಕೊಟ್ಟಿಲ್ಲ
ಆಮೇಲೆ ಅದೇ ಪಾರ್ಟ್ ಮಾಡಿದ್ರು.
ಏನ್ ಮಾಡಿದ್ದಾರೆ ಎಸ್ ವೇರ್ ಇಸ್ ದಟ್ ಹಿರೇಮಠ್ ನನ್ appear for the plan.
My lord, serial number 33, my lord. Serial number 33.
The last chance, 2 weeks time is granted to comply office objection.
Serial number 33, Mohammed Sharif for appellant, D. Vijay Kumar.
For appellant.
For the respondent, my lord.
Yes. Ready?
Yes, my lord.
Yes.
It's a case of injury, my lords. The appellant is a driver by profession and he has suffered fracture of the neck of femur as well as shaft of femur and there is also left clavicular fracture, my lords. He was inpatient on 2 occasions. One time at Hosmat Hospital.
Now what was he? Driver?
Driver by profession. Yes, my lords. Admission in 2 different hospitals. First admission at Hosmat and second admission at Srinivasa Hospital, my lords.
What is that evidence of the doctor?
Doctor has given whole body disability of 18% and 52% for the limb, my lords. Whereas the tribunal has taken 15% to the whole body as the disability.
Doctor has 18.
18. Yes, my lords.
Now what is that income?
His income has been taken as 16,000 per month based on the bank statement that was produced.
16,000.
16,000.
Yes.
16,000 to be.
What is that income you have claimed?
My lords,
16,316.
as per the evidence, he was drawing a salary of 17,000 lump sum per month. He was working as a driver with Prestige Shantiniketan and we have let in the evidence of PW3.
Income ಎಲ್ಲ ವರ್ಕೌಟ್ ಮಾಡಿ 16,000 ತಾಂಡಿದ್ದಾರೆ. Income
They have taken on an average,
there
they
is
have
no
taken
dispute
16,316 per month.
Only dispute in respect of disability.
Disability 18% has been taken.
Yes.
Physical disability has been taken, my lords. He being a driver, function disability should have been assessed is my humble submission.
No, is it he has surrendered his driving license and he is not doing any this thing driving?
Now he
has he proved that? As like last case.
we have let in the no.
Last
Subsequent bank statement is also not produced for having removed
He
from
has
the
not.
service.
He has not surrendered his driving license.
Yes,
as far
ma'am.
as I
It's to
know.
say that he has yes.
He
Last
can-
case you have
he-
seen that he has given a letter to RTO and he has surrendered with that medical records and all. Yes.
No, my lord.
And doctor itself said it is only 18%. 18% disability ke driving license
That is-
ಯಾರು surrender ಮಾಡಕ್ ಹೋಗಲ್ಲ.
Physical disability. my lord.
He can, and functional disability much less.
Yes. Income ಆಯ್ತು. How many days you were in that hospital?
Totally 12 days, my lords. Totally 12 days he was admitted as an
12
inpatient.
days.
Yes, my lords.
Pain and suffering, medical expenses, conveyances, loss of income on account of disability, loss of income during the treatment.
Loss of income during the period of treatment, my lord, 65,000 is awarded.
ಎಲ್ಲ ಕೊಟ್ಟಿದ್ದಾರೆ
ಎಲ್ಲಾದ್ರೂ ಜಾಸ್ತಿ ಕೊಟ್ಟಿದ್ದಾರೆ.
disabilities has to be
ಎಲ್ಲ
3%
ಅಲ್ಲ,
ಜಾಸ್ತಿ.
ಅದು ಕೂಡ ಇನ್ಕಮ್ ಜಾಸ್ತಿ ತಗೊಂಡಿರೋದ್ರಿಂದ ಬರೋದಿಲ್ಲ ಸ್ವಾಮಿ. Because he is
no.
continuing in service.
No, income is not this thing. They have taken only 16,000 as per his.
My lord,
An
2000,
average.
my lord, 2016 ನಲ್ಲಿ 9,500.
No, that
Almost
you have,
double the
he has proved and produced that tribunal has taken. Nobody has disputed. I can't reduce that, Mr.
Correct, my lord, but same thing, that's why retained ಅಷ್ಟೇ ಮಾಡ್ಕೊಂಡು, even
Yes,
the
yes.
disability also, because he is continuing in service, therefore no question of future loss of income.
No,
My lord,
no.
my humble submission, my lord, kindly turn to pay para 45 my lord, tabular form compensation.
Para?
Para 45. ಅದರಲ್ಲಿ ಪೇನ್ ಅಂಡ್ ಸಫರಿಂಗ್ ಒಂದ್ ಸ್ವಲ್ಪ ಜಾಸ್ತಿ ಮಾಡಿ ಇನ್ನು ಉಳಿದದ್ದು ಎಲ್ಲದೂ ಜಾಸ್ತಿ ಕೊಟ್ಟಿದ್ದೆ ನಾನು. ಇಲ್ಲ ಅಂದ್ರೆ ನಾನೇ ಇದ್ ಮಾಡ್ತಾ ಇದ್ದೆ. ಬಿಕಾಸ್
Yes, interest.
ಇನ್ಕಮ್ ಇಸ್ ಟೇಕನ್ ಇಂಟ್ರೆಸ್ಟ್ ಇಸ್ ಆಲ್ಸೋ ಮೆಲಾಡಿ is at 9%. ಅದು ಕೂಡ ಜಾಸ್ತಿ ಇದೆ.
Yes, ತಗೊಳ್ಳಿ.
So, my lords, para 36 of the judgment, my lords.
I heard you.
Doctor has told that there is a stiffness in the right hip and right knee.
Yes.
And he needs frequent rest, period of rest while walking,
They
as it develops pain in him.
not entitled for the interest for a period of 492 days for enhanced compensation amount. So and so learned counsel appearing for the claimant has contended that due to that extent, claimant has suffered grievous injury. He has examined the doctor as PW2. He has deposed that claimant has suffered 52% disability to lower limb and 18% to whole body. Tribunal has assessed whole body disabilities. 15% is on lower side. She further contended that due to that accident, claimant has suffered grievous injury. She was inpatient for a period of 12 days. He was inpatient for a period of 12 days. He has suffered a lot of pain during the treatment. He has to suffer this disability and unhappiness throughout his life. The compensation awarded by the tribunal, pain and suffering, loss of immunities, other incidental expenses is on lower side, sought for enhancement of compensation. For contra, Vijay Kumar, learned counsel appearing for corporation,
BMTC corporation
has contended that even though doctor has assessed that whole body disabilities is 18%, considering that injury suffered by the claimant, considering his age and medical records, tribunal has assessed whole body disabilities 15% is just and reasonable. The monthly income assessed by the tribunal is on higher side. Secondly, he has contended that considering that evidence of doctor and injury suffered by the claimant, the medical records, the overall compensation awarded by the tribunal is just and reasonable. The interest awarded by the tribunal 9% is on higher side. Hence sought for dismissal of the appeal. Heard the learned counsel for the parties. Peruse judgment and award. It is not in dispute. Claimant has suffered an injury in a road traffic accident occurred on 23/4/2016 due to rash and negligent driving of driver of bus bearing registration number KA 57 F0265. Due to that accident, claimant has suffered the following injury. He has examined the doctor as PW2. In his evidence, he has deposed that claimant has suffered 52% disability to lower limb, 18% to whole body. Considering that evidence of doctor and injury suffered by the claimant, I am of the opinion that whole body disabilities has to be assessed 18%. Tribunal has rightly assessed monthly income as 16,000. The multiplier applicable to that age group is
15, my lords.
15.
15. 39 years.
Yes, 39 years is 15.
15.
Accordingly, loss of future earning due to disability has been reassessed as well. 16.
ಅಲ್ಲ ಇದರಲ್ಲಿ 5 days ಮಾತ್ರ ಟ್ರೀಟ್ಮೆಂಟ್ ತಗೊಂಡಿರೋದು. ಬೇರೆ ಸೆಕೆಂಡ್
two different hospitals.
Yes.
Next occasion
16,000 into 12 into 15 into 18%, 5,18,400.
Yes. Due to the accident, claimant has suffered the aforesaid injury. He was inpatient for a period of 12 days. He has suffered lot of pain during the treatment. He has to suffer this disability and unhappiness throughout his life. Considering that evidence of doctor injury suffered by the climate, inclined to enhance the compensation, pain and suffering from 40,000 to 50,000. Amenities from 25,000 to 35,000. Other hand, compensation awarded by the tribunal is just and reasonable. Enhanced compensation amount carries 6% interest. Not entitled for the interest for a period of 492 days for enhanced compensation amount.
And also future medical expenses.
Future medical expenses ಈಗ ನಾವೇನು enhance ಮಾಡಿಲ್ಲ.
Please.
Cell number 35, Gaurav GK for appellant, M. Ashok
Much
Kumar.
obliged.
Yes.
I'm for the appellant.
Where is Ashok Kumar? Has he filed an objection?
Yes, madam.
Padi. Objection.
Oh.
There is a delay of 524 days in filing an appeal. IA 1 of 2021 is filed for condonation of delay. Respondent has filed an objection. Heard the learned counsel for the appellant. Peruse that affidavit filed along with that application for the reasons stated in that accompanying affidavit. Delay of 524 days in filing an appeal is condoned. IA 1 of 2021 is allowed, subject to condition. In case, ಏನು ನೀವು ಕ್ಲೈಮೇಟಾ? In case appellant is succeed, is not entitled for the interest for enhanced compensation. Any date may be next week. Yes.
Cell number 37, Nagaraja HR for appellant, EI Sanmati.
ಎಲ್ಲ ಇದ್ರಲ್ಲ ಅವರು ಸನ್ಮತಿ ಅವರು. ಏನು ಎನ್ಹಾನ್ಸ್ಮೆಂಟ್ ಅಷ್ಟೇನಾ?
Case has been, claim petition itself is dismissed on the ground that earlier the claimant has filed claim petition.
ಅದ್ರ ಬಗ್ಗೆ ಅವ್ರೇನು ಹೇಳ್ತೀನಿ, ಕಲಿಗಿದ್ರಲ್ಲ. Why it is passed over in the morning?
The judgment copy ಒಂದೇ ಅದಕ್ಕೋಸ್ಕರ ಅದೇನು ಅವ್ರು ಇದ್ರು ಸ್ವಾಮಿ ಇಲ್ಲೇ
ಇದ್ರ ಅದು
ನೋಡ್ತೀವಿ ಇಲ್ಲಿ ಇದ್ರೆ ಕರೀ.
ಎಸ್ ಆಯ್ತು ಕೊಡಿ, ಅದೊಂದು ಜಡ್ಜ್ಮೆಂಟ್ ಕೊಟ್ಟು ಬೆಳಿಗ್ಗೆ ತೆಕ್ಕೊಟ್ರಲ್ಲ ಅದ್ರಲ್ಲಿ ಆ ಬುಕ್ ಕೊಡ್ರಿ, ಬೆಳಿಗ್ಗೆ ಇಲ್ಲಿ ಕೊಟ್ರಿ, ಕೆಳಗಡೆ ಬುಕ್ ಕೊಟ್ರಿ, ಜಡ್ಜ್ಮೆಂಟ್ ಕೊಟ್ರಲ್ಲ ನೀವು, ಏನಕ್ಕೆ ಅದು ನೋಡಿ. ಇದನ್ನ power of the appellant court exercising how the officer functions after the act. ಏನಕ್ಕೆ ತಕ್ಕೊಟ್ಟಿದ್ದಾರೆ? Karnataka Land Revenue Act 5A, judicial review order passed from the statutory authorities order for State Commission challenge before the Deputy Commissioner. Once cause finality of reopen after 9 years.
ಸನ್ಮತಿ ಅವ್ರ ಫೋನ್ ನಂಬರ್ ಇದೆಯಾ?
By entertaining the appeal at ISU Prakash, with appointment. Judicial review or order passed by the authorities, order of the State Commissioner challenge before the State Commissioner and the matter attained finality, matter reopened after 9 years by the successing register by entertaining that the appeal. Two 2006. ಅವ್ರಿಲ್ಲಲ್ಲ ನೆಕ್ಸ್ಟ್ ವೀಕ್.
ನೆಕ್ಸ್ಟ್ ವೀಕ್.
ಎಸ್. ಇದ್ಯಾವ್ದು ಇದು? ನಮ್ಮ ಹೈಕೋರ್ಟ್
ನಮ್ಮ ಹೈಕೋರ್ಟ್ ಕನ್ಸಿಡರಿಂಗ್ ವೆರಿ ಸೇಮ್ dismiss for non-prosecution ಆಗಿತ್ತು earlier petition.
ಎಲ್ಲಿ ಏನು ಎಲ್ಲಿ where is that answer?
Yes, para 4 in the para 4 also ಇರುವಾಗ the respondent number 2 and 3 filed to the petition contending that claim made by the petitioner totally false and frivolous and there was no such negligence on the part of the driver of the bus. It was contended that the compensation claimed by the petitioner is highly exorbitant, imaginary and untenable and the petitioner has sustained injuries due to his own negligence. It was contended that driver of the bus next ಇದೆ ಸ್ವಾಮಿ ಅಲ್ಲೇನೆ inter alia. It was also contended that the petitioner was residing in the limits of MA city address.
Petition on the ground that petition deserved to be dismissed. ಇದೇನೋ ಬೇರೆ ಇದೆಯಲ್ರಿ?
ಅಲ್ಲ ಅದನ್ನ ನೆಕ್ಸ್ಟ್ ಪ್ಯಾರಲ್ಲಿ ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ 2 and 3.
No such limitation has been prescribed for filing in a petition under petitioner MUC was dismissed for non-prosecution. Therefore, remedy of available petitioner was not decided on the merits. Petition which is filed MUCT was maintainable. Yes, illegal. ಅದಕ್ಕೇನು ಆನ್ಸರ್ ಮಾಡಿದ್ದಾರೆ?
ಇದರಲ್ಲಿ
issue regarding the quantum hearing for dismissal of the either petitioner not disclosed by the petitioner. What to disclose by so and so. If also MSC itself not in common. Therefore, the court in view of the absence of any bar for second petition maintainable. The petitioner has filed MSCT Davangere. It is transferred to the additional second petition. Is one of the, yes, it is maintainable antarla.
It is maintainable ಅಂತ ಹೇಳ್ತಾರೆ.
Yes. Now that she said it is not on that, it is on merit.
ಇಲ್ಲ
ಅದ್ರಲ್ಲೇನೋ ಫೈಂಡಿಂಗ್ ಎಲ್ಲ ಕೊಟ್ಟಿದ್ದಾರ?
ನಾಟ್ ಆನ್ ಮೆರಿಟ್ ಸ್ವಾಮಿ. ಕೈಂಡ್ಲಿ ಕಮ್ ಟು ಲಾರ್ಡ್. ಅದ್ರ ಮೇಲೆ ಇಶ್ಯೂಸ್ ಮೇಲೆ ಯಾವ ಇಶ್ಯೂಸ್ ಮೇಲೂ ಇದೆ ಕೊಟ್ಟಿಲ್ಲ ಅವರು. ಕೈಂಡ್ಲಿ ಕಮ್ ಟು ಪ್ಯಾರಾ 10.
ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅವ್ರು ಬರ್ಲಿ.
ಆಯ್ತು.
None appear for the respondent.
In the meanwhile, NCR may be called.
ಕಂಡೋನ್ ಮಾಡ್ಬಿಟ್ಟು ಇದ್ ಮಾಡ್ಬಿಡೋಣ ಅಲ್ವಾ?
ಆಯ್ತು.
Yes, ಎಲ್ಲಿದೆ ಸೀರಿಯಲ್ ನಂಬರ್?
37.
Delay 22 days, condone, hard admit. Yes.
39. Harish Babu K.N. for appellant, B. Pradeep.
Appear for appellant in this case.
Pradeep. Ready?
MSCT is coming to the conclusion that he is having a driving lesson to drive LME. The vehicle involved is a 5,700 kg, but there is no permit. Regarding permit is concerned, the liability has been fixed against the owner of the vehicle.
But Act says that permit is not required. How though?
Supreme Court.
No, weight of the vehicle is less than
3,400 kgs. Here, Millard, 5,700.
ಇಲ್ಲ ಕೊಡಿ ಅದು ಆಕ್ಟ್ ಕೊಡಿ.
Auto rickshaw, Millard. Goods auto rickshaw and all not required. Here, Millard, the vehicle involved in the accident is 5,700.
5,700.
407 Tata.
ಅದು ಕೊಡ್ರಿ ಯಾವ್ದಪ್ಪ 66?
I know that, Millard. 66 14 subclass E. 3,400.
ನಿಮ್ದು ಎಷ್ಟು weight ವೆಹಿಕಲ್ದು?
Unladen weight is 2,350 son.
Laden weight, Millard, not unladen.
Unladen weight ಅಲ್ಲ ಇದರಲ್ಲಿ.
Grass vehicle weight.
Grass weight, if the goods vehicle of grass vehicle weight of which does not exceeding 3,000 kilo. Grass Mr. Unladen ಅಲ್ಲ ಇದು.
ಇಲ್ಲಿ unladen ಕೊಟ್ಟಿದ್ದಾರೆ, grass ಏನು ಕೊಟ್ಟಿಲ್ಲ.
Laden ಇಲ್ಲೇ ಇದೆ, B extract ಇದೆ ಇದು. Exhibit P5 ಪಾಲಿಸಿನಲ್ಲೂ ಇದೆ, B extract ಅಲ್ಲಿ.
ಎಷ್ಟಿದೆ ಪಾಲಿಸಿ?
5,700 kg.
Then
pay and recovery ಆಗಬೇಕು ಸರ್.
Then you have no case.
Pay and recovery ಆಗಬೇಕು.
Pay and recovery ಯಾಕೆ? No permit ಅಲ್ಲ, pay and recovery ಆಗ್ಬೇಕು ನಾವು.
No permit
ಅಮೃತ್ ಪಾಲ್ ಕೇಸಲ್ಲಿ pay and recovery. ಅಷ್ಟೇನಾ?
ಆಮೇಲೆ ಇದು ಅಮೌಂಟ್ ಇದು ಇನ್ಕಮ್ 8,000 ತಗೊಂಡಿದ್ದಾರೆ. 2015 accident. ಅದು 9,000 ತಗೋಬೇಕು.
9,000 ತಗೋಬೇಕು. 9% ಕರೆಕ್ಟ್.
ಎಷ್ಟು ಇವ್ರ ಕ್ಲೈಮ್ ಇನ್?
ಕ್ಲೈಮ್ 10,000 ಇದೆ ಪರ್ ಮಂತ್.
10,000 ಮಾಡಿ.
ಟ್ರಿಬ್ಯುನಲ್ ಎಷ್ಟು ತಗೊಂಡಿದ್ದಾರೆ?
8,000.
8 ತಗೊಂಡಿದ್ದಾರೆ.
ಮಲ್ಟಿಪ್ಲೇಯರ್ 15 ಮಿನಿಟ್ 9% ಹೋಲ್ ಬಾಡಿ ಡಿಸಬಿಲಿಟಿ.
9,000 ತಗೋಬೇಕು.
9 ತಗೊಳ್ಬೇಕು.
ಆಮೇಲೆ ಲಾಸ್ ಆಫ್ ಎಮ್ಯುನಿಟೀಸ್ ಏನು ಕೊಟ್ಟಿಲ್ಲ.
ಇದು ಡಿಸಬಿಲಿಟಿ ಎಷ್ಟು ಪರ್ಸೆಂಟ್?
9%.
9% ತಗೊಂಡಿದ್ದಾರೆ.
ಅವರು ಏಜ್
40 years ಮೇಲೆ 15 ಮಲ್ಟಿಪ್ಲೈ.
40 years.
ಅದೆಲ್ಲ ಕರೆಕ್ಟ್ ಇದೆ. ಎಷ್ಟು ದಿನ ಹಾಸ್ಪಿಟಲ್ ಅಲ್ಲಿ ಇದ್ರಿ?
ಹಾಸ್ಪಿಟಲ್ ಅಲ್ಲಿ ನಿಯರ್ಲಿ
2 occasions ಮೇಲೆ
14 days. He was inpatient for 14 days.
14 days.
ಆಕ್ಚುಯಲ್ ಮೆಡಿಕಲ್ ಕೊಟ್ಟಿದ್ದಾರೆ, ಸ್ಪೆಷಲ್ ಡಯಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ. ಲಾಸ್ ಆಫ್ ಅರ್ನಿಂಗ್ ಡ್ಯೂರಿಂಗ್ ದ ಟ್ರೀಟ್ಮೆಂಟ್ 9 ಮಾಡಿದ್ರೆ 27 ಆಗುತ್ತೆ ಅಷ್ಟೇ.
ಹೌದು. ಅಮ್ಯುನಿಟೀಸ್ ಕೊಟ್ಟಿಲ್ಲ, ಅದೊಂದು ಸ್ವಲ್ಪ
ಅಮ್ಯುನಿಟೀಸ್ ಕೊಟ್ಟಿಲ್ಲ ಸರ್.
ಬಟ್ ಪೇನ್ ಅಂಡ್ ಸಫರಿಂಗ್ 60,000 ಕೊಟ್ಟಿವಿ.
ಆಯ್ತು, ಅಮ್ಯುನಿಟೀಸ್ ಒಂದು
ಎರಡು ಫ್ಯಾಕ್ಟರ್ ಇದೆ.
ಎಸ್. So and so learned counsel appearing for the claimant has contended that as on the date of the accident he was earning 10,000 per month. Tribunal has assessed 8,000 is on lower side. Secondly, he has contended that due to that extent, claimant has suffered grievous injury. He was inpatient for a period of 14 days.
14 days.
He has suffered lot of pain during the treatment. Compensation awarded by the tribunal, pain and suffering, loss of immunities, other incidental expenses is on lower side. Hence, he
Loss
sought
of
for-
immunity ಕೊಟ್ಟಿಲ್ಲ.
Huh?
Loss of immunities ಕೊಟ್ಟೇ ಇಲ್ಲ sir.
Tribunal has not granted any compensation for loss of immunities. Lastly, he has contended that in respect of liability, tribunal has given a finding that offending vehicle was not having valid permit and rightly exonerated that insurance company. In respect of third parties is concerned, insurance company has to pay that compensation amount, liberty to recover from the owner of the offending vehicle. Hence, he sought for enhancement. Pradeep, learned counsel appearing for insurance company has contended that even though he has claimed 10,000, he has not produced any document. Tribunal has rightly assessed 8,000. Considering that evidence of doctor and injury suffered by the claimant, overall compensation awarded by the tribunal just and reasonable. Liabilities is concerned, he has contended that as on the date of the accident, offending vehicle was having no permit. Since insured has violated the policy condition, insurance company, tribunal has rightly exonerated that insurance company. Hence, sought for dismissal. Heard the learned counsel for the parties. It is not in dispute. Claimant has suffered an injury in a road traffic accident occurred on 10/11/2015 due to rash and negligent driving of driver of tempo bearing registration number KA 470455. Even though claimant has claimed that he was earning 10,000, the notional income has to be assessed for 2015 as 9,000. Tribunal has rightly assessed whole body disability is 9%. Multiplier applicable to that age group is 15. Loss of future earning has been reassessed.
9,000 into 12 into 15 into 9%, 1,45,800.
Due to that accident, claimant has suffered the opposite injury. Inpatient for a period of 14 days. Considering that evidence of doctor and injury suffered by the claimant is entitled for loss of income for a period of 3 months and loss of amenities 40,000. Liabilities is concerned, the tribunal has given a finding that the offending vehicle was not having valid and driving license itta.
Driving license.
Driving license ಇತ್ತು, permit
Even they
ಇಲ್ಲ.
were driving license covers, Miller, that's what.
Yes.
MSCTA itself is
Yes,
telling
yes.
for the conclusion.
Not having holding a permit as on the date of the accident, then tribunal has exonerated that insurance company from the liability on the ground that insured has violated the policy condition. However, in respect of third parties is concerned, insurance company has to pay that compensation amount, liberty to recover from the owner of the offending vehicle. Accordingly, the appeal is allowed that in part, insurance company is directed to deposit compensation amount with interest, liberty to recover from owner of the offending vehicle. Delay is controlled.
Serial number 44, Kumara KG for appellant, connected matter. Suresh Kumar HM, ME Punacha.
ಅವ್ರೇನ್ ಬರ್ತಾ ಇಲ್ಲಲ್ಲ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ನನ್ನ ಅಪಿಯರ್ ಫಾರ್ ದ ಅಪ್ಲೈಂಟ್ ಲೀಸ್ ದಿಸ್ ಮ್ಯಾಟರ್ ಆಫ್ಟರ್ 2 weeks.